certain, Madam Speaker, that the government will realize how rash and foolish this legislation is. When they try to implement it and the whole system shuts down, as happened recently at the licensing office, a number of systems just shut down. And they realize how ill-intentioned this is, how poorly thought out this is. And they get a next backlash from the population, including their own supporters. They'll be back in Parliament to amend this legislation. This is the most foolish, the most draconian, the most ill-advised, the most incompetent, the most amateurish, the most unworkable, the most impractical, the worst piece of legislation I've ever seen in terms of amendment to the Motor Vehicle and Road Traffic Act. Look at what we did. Look at what we did. Madam Speaker, I had the honor and privilege when I was Minister of Works to introduce the breathalyzer. We were in a joint select committee for 7 months on that. We took consultation from the public. We invited interest groups. We had meeting after meeting with respect to the breathalyzer. And then we amended the law and we introduced the breathalyzer. And road fatalities began to decline. It is after the introduction of the breathalyzer, which was done with proper consultation with the public, that road fatalities began to reduce in Trinidad and Tobago. And I had the honor to be responsible for that. I am ashamed of the Ministry of Transport at this point in time. No consultation, foolishness, impractical legislation, and untruths to explain their bumbling and their fumbling. Thank you, Mr. Madam Deputy Speaker.
Member for Tobago East.
Thank you, Madam Deputy Speaker. Madam Deputy Speaker, I want to take this opportunity to express my gratitude to all the peoples of Tobago who understands good governance. And who spared not a moment to make a profound demonstration of what the intent of this government means for the people of Tobago. Madam Deputy Speaker, I would think that when legislations are made, they are made to bring amicable and amiable situations to the population. When this legislation was put together, that was the sole intention, to create an amiable situation so that the people of Trinidad and Tobago could exist in an environment where they understand the value of things, the value of legislation, and the value of the way you do business. If you compare this legislation to the demerit system, you would see how brutal the demerit system was. We are hearing here today about the fines, but I would always continue to say, if you do not break the law, you would not become intimately attached to the fines. This system actually gives the citizens of Trinidad and Tobago a fighting chance. One stop by law enforcement can cause you to gather demerit points that you are immediately suspended. One stop. And when that happens, consideration is not taken to the fines that are to be paid. Consideration is not taken in terms of how you mind your family. And consideration is not taken to the system that you have to do your refresher in order to get back your permit. It means that you have plunged that individual into immediate hopelessness and immediate hardship. Even the Bible states where there is no law, there is no sin. So based on the utterances and the commentary coming from the other side, it means that we should not have laws. And I say, I take umbrage to that approach to business. Even the God of the universe gave us laws by which we should operate and which should exist. But he included reprieve, he included forgiveness, and he included cleansing. With the demerit system, it offered you little or no hope. You see, a caring and responsible government replaced that barbaric move with a chance to consolidate a position into the benefit of not only the perpetrator, but the state. And that is what this legislation is doing. The fact that we are here today debating, it means that we are paying attention to the citizenry. And we are including them in the decision-making process of Trinidad and Tobago. I have met with a wide cross-section of persons in my constituency, and we examined all the variables of the bill. And there was a huge agreement that if we err on the side of the law, then the fines will never be something that we have to consider going forward. And the fact that we are making legislation, it is because we must put structures in place to allow Trinidad and Tobago to be a law-abiding country. Are we to believe, Madam Deputy Speaker, that the citizens of this country prefer to be lawless? Let us all ask ourselves, which is easier, to obey the law or to pay the fines? Which is easier? But I'm hearing, Madam Deputy Speaker, that, those on the other side, I'm hearing the utterances suggesting that we may not be sensible, but I don't know if they are paying attention to current activities taking place in this country. Because I know that Tobago forms an integral part of Trinidad and Tobago. And I know Tobago spoke, whether they were fines or not, Tobago spoke in an emphatic manner on January the 12th. How would have the government been viewed if we did not make legislation and we did not make amendments so that the citizens of this country could operate in a comfortable space? How would the government have been viewed? But you see, there are those of us who believes that we are God's gift to brightness. Yeah. Right? And I'm saying that if you understand what bright means, Bright means that anything that is bright enhances its surroundings. Take a check on the light bulbs around here. It enhances this environment. But we are often plunged into a situation where we believe that we can boast about certification and brightness, and when you look around you, nothing happens. But as soon as the level of engineering comes around that make things happen and enhances the lives of people, you hear all the negatives. But we would always have to return to the juncture where those on the other side, they were in a position to legislate, they were in a position to enhance the lives of the citizens of this country, and the citizens of this country had to resort to rejecting them in preference to the government of the day. I want to advise, Madam Deputy Speaker, that we are not merely here to make legislation. We are not merely here for that. But we are certainly here to make excellent legislation to enhance the lives of the people in Trinidad and Tobago and reduce the hardship that they face. Madam Deputy Speaker, just a few comparisons. With the demerit points, once you are suspended, you had no chance to feed your family, you had no chance to repair the defect, and you had no chance to pay the fee that you had to pay to do your refresher. With this legislation, we are not suspending anybody. We are giving you a chance to repair your defect, whether it be 3 days, 7 days, 14 days, we are giving you a chance. And we are giving you a chance to continue to earn your livelihood, to feed family, do business, and all the other fringes that we could add on. I am saying that if we are blind to a situation, we may not be able to offer much of an excuse. But when you deliberately find yourself in a situation to mislead, hide true evidence, and deny presenting proper facts to support your actions, I see you as hypocritical. Madam Deputy Speaker, I would want this entire country to understand that the overall desire of all of us is that we have a lawful, law-abiding country. And therefore, it is the responsibility of the government of the day, and I dare say the responsibility of this entire parliament, to ensure that whatever we do it in the best interest of the overall citizenry, and make sure that we can make solid contributions towards our own development. We cannot continue to put ourselves in a position to suggest to all and sundry that if we don't do it, it cannot be done. This government has demonstrated in an emphatic way that they are legislating well, and it is taking the desired effect. I wonder if they would want to consider the crime statistics. And the crime statistics has been brought down to where it is because we legislated well. Thank you, Madam Deputy Speaker.
Member for Ruka-Lopino.
Thank you very much, Madam Deputy Speaker. And Madam Deputy Speaker, I was just about to get a little bit comfortable in my seat to take on the contribution of my colleague from Tobago East. And I was taken by surprise when he wound up the debate, his debate, and I started taking notes. And Madam Deputy Speaker, I had absolutely nothing much to respond to from my colleague from Tobago East. And it seemed as though, Madam Deputy Speaker, he came or someone may have prepared some notes for him to attack the demerit point system, and he made comments like, with the demerit point system, you have no chance to feed your family, etc., etc. Those are the comments of my colleague from Tobago East. But whoever prepared the members' contribution set him up. Because the same demerit points that he took time to attack, he is obviously unaware, perhaps blissfully unaware, that the demerit points that you attack is still on the books of Trinidad and Tobago. It's still on the books. And what your government did, member, my colleague from Tobago East, what your government did was to remove demerit points from some traffic violations and maintain demerit points for some serious traffic offenses to preserve lives. So perhaps you should have educated yourself, inform yourself when you speak to this parliament and the people of Trinidad and Tobago, and don't mislead anyone. Because if the demerit points was as bad as you pretended it to be, then your government would have removed it from the law books of Trinidad and Tobago. And I want to tell you, because my colleague from Diego Martin Northeast, I think he would have done himself a little bit of disservice by not going into detail with the amount of work he did. He didn't have enough, and then you were being constantly interrupted from my colleague on the other side. But my colleague from Diego Martin Northeast would tell you, Madam Deputy Speaker, that the PNM took years upon years upon years, consultation after consultation after consultation, and we removed road fatality rate in Trinidad and Tobago. At one point in time, it was 272 road fatalities on an annual basis. And because of the legislative interventions that we have made over the years, by 2020, going into 2021, it was reduced by 60%. The lowest road fatality rate in Trinidad and Tobago since the 1940s. But Madam Deputy Speaker, this is not something that you achieve in just 1 year. It is years of hard work, research and policy, working with your colleagues in the licensing office, in the Trinidad and Tobago Police Service, in the Ministry of Works and Transport, and in the judiciary, to bring about the type of result that we can speak of today, not only as an opposition, but I can tell you that if we are true patriots and we are true citizens of this country, we should be proud that Trinidad and Tobago recorded its lowest road fatality rate since 1945. This was something, Madam Deputy Speaker, that was promoted, it was discussed all over the world, that even in Jamaica, they sent a team to study the work that we would have done. Madam Deputy Speaker, I'm being interrupted by my colleague on the opposite side.
Okay, yes, members, let's give the member for Aruca Lupino a chance to make his point.
Thank you very much. Thank you very much, Madam Deputy Speaker. Madam Deputy Speaker, the Inter-American Development Bank, the World Bank, Caribbean institutions studied the work that we would have done in Trinidad and Tobago to bring about the type of results to record the lowest road fatality in the history of this country. It was no easy work. It required a number of interventions, Madam Deputy Speaker. So when my colleague from Tobago East can stand and make statements that he has absolutely nothing or no knowledge of, we have to take umbrage to that. Because lives are being lost. How many people it is, I don't want to bring the president here in this debate, but there are many people in this country, when they hear mangled bodies on the roads, They think of their children, they think of their aunts, their uncles, who would have lost their lives because of the issue of road fatalities in this country. And therefore, when a government could come into power, and if, according to what the Minister of Transport could say, that we didn't have the data when we made decisions, had he had the data, I would assure my colleague, the Minister of Transport, that they would not have done and interfered with the demerit point system had they done the work, the research, and the data that he claimed that they did not have. It is irresponsible when politicians who are given the mandate to govern a country could be so flippant in making decisions that can impact the lives of people. Decisions, Madam Deputy Speaker, that can mean life or death. And he talked about the demerit point system. I want my colleague from Tobago East to know that when the demerit point system was fully in effect, both rich, poor, middle class, it was applied consistently and equitably across the board.
Not like fines. Not like a fine.
But you want to increase fines. You want to double fines. $3,000, $4,000, $2,000. The rich will pay it, but the poor will not be able to pay it. And if I am a CPEP worker fired, or a forestry worker fired, there is no way, absolutely no way, Madam Deputy Speaker, that I can pay the fines that are now on the law books of Trinidad and Tobago. You cannot transform behavior by punitive measures. Madam Deputy Speaker, what the demerit point system did, you see, they don't know, you know. Because with the demerit point system, Madam Deputy Speaker, with the demerit point system, you commit a traffic violation, you get 1, 2, please give me a break. 2 traffic violations, 2 demerit points. You commit another traffic violation, Madam Deputy Speaker, the scheduled amount of demerit points is applied. And when you reach closer to that threshold, having committed several traffic violations, the law makes it incumbent upon the licensing authority to write the driver or the owner of the vehicle and let them know that you are reaching close to your threshold. What's your behavior? It is not true when they are saying that with 1 traffic violation you can lose your demerit point. That is simply not true.
Fantasy.
It is simply not true. It is an accumulation of points over a period of time by the commission of traffic violations that will cause a driver to lose his driver's permit. It is an accumulation, and that is the reason why it is called a demerit point system. Because you commit a traffic violation, it adds. You commit a further traffic violation, and even before you meet the minimum threshold of cancellation, the law makes it or put a responsibility on the police or the licensing division to warn the driver that you are approaching your threshold. What's your conduct? And if the driver exceeds the minimum threshold and his driver's permit is cancelled, the law allows for the driver to participate in a driver's rehabilitation program. These are the things, Madam Deputy Speaker, that change behavior, because road traffic violation and the enforcement of road traffic laws is not only about punitive measures, but it is about changing behavior. It is about changing the behavior. So when this government recklessly and irresponsibly interfered with the demerit point system, and it is the same government, after so doing, led by a prime minister from Superior, would watch the people of this country and call us a lawless dump. The same country where you gutted the demerit points that contributed to the saving of lives and the changing of behavior, you turn around months after and call us a lawless dump. Well then, if we are a lawless dump, it is because this government, by their behavior, by gutting responsible legislation, contributed to Trinidad and Tobago being a lawless dump. Contributed to it. And therefore, Madam Deputy Speaker, they realized they made an error. And in the dead of night, The member for the Omati North, he said it. The Minister of Finance, the member for Faizabad, in his budget statement, gave a whole list of offenses that the government intended to increase. And he said, we expected to raise $200 million or $180 million. I mean, come on. You are hoping, in order to raise $180 million, then you're hoping that people commit traffic offenses. And if people don't commit traffic offenses or traffic violations, your estimate of revenue, where are you going to recover that money? And the list that he provided was far different, because the Minister of Finance never said that he intended to amend the 9th schedule of the Act. He just itemized 5 offenses in the budget statement, and Madam Deputy Speaker, Boxing Day, we have to learn by the publication of an order on Christmas Day that the 9th schedule was interfered with, or perhaps amended, by the Minister of Transport, where fines for traffic violation have been doubled. Pandemonium in the country. And they did it so much so, not realizing, Madam Deputy Speaker, that there is a cap under the fixed penalty provision, that you cannot affix a fixed penalty for a violation or an offense that is over 75% of the prescribed fine in the Act. Because they were so busy trying to do it quickly, because we believe all of us have been distracted by Christmas and New Year's and what have you, that even in the same legal notice was illegal, because a lot of those fines were above the prescribed 75% limit. That is when you're doing things, Madam Deputy Speaker, it's only foul thief that's operating in the night like that. When you are responsible and you are a legislator and you have some decorum about yourself, you don't go in the night, especially on Christmas night, to interfere with the law, not expecting to be caught. And if I am to use the words of the Attorney General that was uttered in this Parliament, I want to tell both the Attorney General and the Minister of Transport to remove your grubby hands from the Motor Vehicle and Road Traffic Act. Remove it. Madam Deputy Speaker, I can tell you, Madam Deputy Speaker, that it is, when you look at this piece of legislation, it is going to contribute to an overwhelming of the judicial system in this country. And I will explain why. In 2020 or 2017, when the PNM amended the Motor Vehicles and Road Traffic Act and introduced a system of traffic violations and traffic offenses, over 147,000 cases were removed from the magistrates' court system, because it was detected that what you had was police officers and licensing officers issuing fixed penalty tickets. People were not paying their fixed penalty tickets. And the law as it was then required that if a fixed penalty ticket is not paid over a period of time, the matter is automatically listed in the magistrates' court. Over 147,000 traffic offenses were logged in magistrates' courts all around the country. And by the introduction of that piece of legislation, we removed all of the 147,000 cases. And in addition to that, we established a system of traffic offenses and traffic violations. Traffic violations meaning the less serious ones, and the serious ones like careless driving, driving under the influence, etc., we regard that as traffic offenses. And with traffic violations, we introduced fixed penalty system, a new fixed penalty system, administrative fines, etc. And by that, we entered into a new era of traffic law enforcement, not what you would have witnessed some weeks ago when the 9th schedule was interfered with. Madam Speaker, you observe what transpired in this country. People were lining up on the streets to head to licensing offices from 8 p.m. the night because of this oppressive 9th schedule that was introduced. And on All Year's Night, when they recognized that they made some errors, on Christmas Day, on All Year's Night, they went back again to publish a new order. That is the reason why we are here today, Madam Speaker, Madam Deputy Speaker. That is the reason why we are here. Because they went and they interfered with those laws in the dead of night, got public pressure, pushed back from the public, pandemonium all over. And then they came with this piece of legislation as though they are doing the people of this country some favor. They are not. They are bending to public pressure. And the question that we now have to ask ourselves is whether or not this piece of legislation, as it's drafted, is going to ameliorate or reduce the pressure by the public. Madam Deputy Speaker, I say no way. Let's look at some of the clauses of the law. And I want to point you, Madam Deputy Speaker, to Clause 6, Subclause 2. Where a constable finds a vehicle on any occasion and has reason to believe that a traffic violation specified in the first column of the 11th schedule is being or has been committed in respect of that vehicle, the constable shall affix a fixed penalty warning to any part of the vehicle where the fixed penalty warning may be easily seen, and for the purposes of this part, the affixed penalty warning shall be deemed to have been served upon the person so liable for the traffic violation. So the police officer on patrol, or I guess licensing officer or traffic warden, he sees a vehicle parked at the side of the road, not being driven by someone, observe that there are some traffic violations, the condition of the vehicle and what have you, and he decides, or she decides, to affix a fixed penalty ticket to that vehicle. A fixed penalty warning to that vehicle. But look at 3. So you affix the warning to the vehicle. And subclause 3 said that notwithstanding any law to the contrary, the owner of a vehicle on which a fixed penalty warning was affixed under subsection 2 shall be presumed to be the person liable for the traffic violation. So if the owner is residing in Mayaro, allows his vehicle to be driven by someone in Port of Spain, is unaware that there was an affixed warning attached to that vehicle, subclause 3 is saying that he shall be presumed to be the person liable for the traffic violation and shall be required to comply with the fixed penalty warning. If you don't know, and that is the case in this country where you own a vehicle and you allow someone to drive a vehicle, but this law is saying that if the police officer or the law enforcement officer affixes a warning to that vehicle, even though you as the registered owner may not be aware, and it is not possible that you are aware, you will be deemed to be liable. And it is your responsibility to comply with the warning. How can you comply with something that you don't know?
In 3 days.
And worse yet, in 3 days. You allow, and the law allows you to loan your vehicle and to lend your vehicle to someone to drive. It is not illegal. So how, as the owner of the vehicle, you will be aware? What kind of madness is that? And the law is telling you that you have 3 days. The law is saying that you now have 3 days to remedy it. You're not aware in the first place. And what if a homeless person or someone decides to remove the affixed warning to the vehicle? How will the driver know? And how is the owner going to know? This is unworkable, Madam Deputy Speaker. It is, according to my colleague from the Gomartin Northeast, it is a knee-jerk reaction to the mess that they have made in this country. And they come with a piece of legislation that is impractical, it is unworkable, and it will cause more pain on the citizens of Trinidad and Tobago. It will cause more pain. Madam Deputy Speaker, it gets even worse. Because if you are issued with a warning by a law enforcement officer, you have 3 days, Madam Deputy Speaker, to address it, as my colleague would have said. Madam Deputy Speaker, look at what is happening in the licensing office. Madam Deputy Speaker, we have over 1 million vehicles on the roads of Trinidad and Tobago. And as my colleague said, it is this government that issued a legal notice a short while ago, not too long ago, that allowed for the importation of vehicles 8 years. So by the time the vehicle reaches here, that is 8 years old, that vehicle is ready to be inspected already because it would have all kinds and all manners of problems. So you are bringing more vehicles onto the roads of Trinidad and Tobago, more substandard vehicles on the roads of Trinidad and Tobago, over 1.2 million vehicles. And you are saying that you have 3 days, and you have to find yourself. You have to find yourself to a licensing office or a police station within 3 days so that they can issue you with a certificate of compliance. It cannot work. And if you go to a police station and for one reason or the other the police can't see you or issue you with a certificate of compliance, what happens to you then? Or if you go down to the licensing office, Madam Deputy Speaker, and you have to line up because there's all kinds of things happening at the licensing office. Look at what is happening in Caroni. And you go there on the 3rd day, if you are lucky enough to go there on the 3rd day, and you cannot get your vehicle inspected or a certificate of compliance issued to you, the law makes no provision for that vehicle owner or driver to be given a further grace period to comply with the law and to be issued with a certificate of compliance. Madam Deputy Speaker, this does not make sense. There is no way the Trinidad and Tobago Police Service can be burdened further on this matter. It is unworkable. What system are you putting in place? What training? What technological advancement are you making? How are they going to transmit
in 1 day
that document to the licensing office? Are they going to run down to the licensing office? Are they going to do it via some electronic means when some police stations don't even have access to internet? And what if a police officer, what if a law enforcement officer or police officer, for one reason or the other, does not inform the licensing office that a certificate of compliance is issued? What happens to the poor citizen? What happens to the poor citizen? And that is the reason why my colleague from the Gomartin Northeast said that in jurisdictions around the world where you have similar provisions, it makes and creates a provision for up to 1 month to become compliant with the law, because simply, Madam Deputy Speaker, 3 days can't be enough. 3 days can't be enough. It gets even worse. You are issued with a warning. For one reason or the other, you cannot comply with the law within the 3-day period, and you as an owner or a driver of a vehicle decides that I'm going to put down my vehicle. I cannot drive it because I could not have complied with the law within the 3 days, and therefore I'm going to start taking a PTSC bus to go to school, a TT ride share to move around, but I will leave my vehicle at home because I was not able to comply with the law. Hear how ridiculous this law is. If you cannot issue or come within compliance within 3 days, the ticket or the warning automatically translates or converts into a fixed penalty ticket. How on earth can it become a fixed penalty ticket that I'm not driving the vehicle on the road?
you can't get the part.
And I can't get the part. Or I went to a parts shop or an inspection station, and for one reason, they cannot address all of the issues identified. And I, as a responsible driver, you, as a responsible driver, my colleague from Tunapuna, being a responsible driver, cannot drive the vehicle and decide that I'm going to leave the vehicle at home until I rectify the issue. This law is saying that because you have not complied and come within compliance within 3 days, a fixed penalty ticket is going to be issued. You will still be prosecuted even if you have a parked vehicle at home. Colleagues, that cannot be right. someone did not think this through properly. Because it is wrong for a citizen to have his vehicle at home, doesn't drive it because he has not complied with 3 days, looking for his vehicle and the parts to come into compliance with the law, and a fixed penalty ticket is issued to you. And you have to pay $3,000. And if you don't pay that $3,000, the matter is enlisted before the court, and you are overwhelming the judiciary. Again, the 147,000 cases that I told you about a short while ago, Madam Deputy Speaker, it will be 300,000 cases before the court, because I can tell you that there is no way poor people in this country would be able to comply with the law under this very oppressive piece of legislation that is before. It is unworkable. It is wrong. This legislation does not make sense. It is impractical. The licensing division does not have the resources to address these issues. The Trinidad and Tobago Police Service does not have the resources for people to line up police stations all over the country, for a police officer to come and inspect their vehicle, or for a licensing officer to come and inspect their vehicles. And when they do so, and if they do so within 3 days, they are not sure whether a certificate of compliance will be issued to them. And the law is saying that the warning is going to be converted into a fixed penalty ticket. It's wrong. It does not make sense, Madam Deputy Speaker. And Madam Deputy Speaker, I want to make a recommendation to the government, because as flawed as this bill is, and we know the intention of the bill, is basically to turn the Trinidad and Tobago Police Service into a revenue authority. That's what it's all about. But I want to make a recommendation, because I was a technocrat, and I'm going to use my knowledge to make a recommendation to the government. Because I was a technocrat when we introduced the system to improve the fixed penalty ticketing system and what have you. The system that was designed ensured that there was seamless integration between the Ministry of Transport, the licensing division, the judiciary, law enforcement officials, traffic wardens, and what have you. That's the reason why you can see police officers walking around with devices to issue fixed penalty tickets. And as soon as you issue a fixed penalty ticket, it is integrated with the licensing office, it is integrated with TTPS, with the judiciary, and what have you. Makes sense, because of the corruption that existed under the old fixed penalty ticketing system, where police officers took bribe to remove ticketing system tickets from the system. And with an automated system, it ensured that the opportunities for corruption and bribery are reduced significantly, and that you do not have a system that will overwhelm the judicial system. That you provide for a system of paying your tickets, going to TT Post offices, going in different locations, approved payee locations to pay a fixed penalty ticket, because in those days you could only go to the court to pay a fixed penalty ticket. And it was so not working that sometimes people go to the magistrate's court to pay their fixed penalty ticket, Madam Deputy Speaker, and they turn back, not because they don't want to pay their fixed penalty ticket, but because it is unworkable and they cannot meet the cashier.
Would you like your additional 15 minutes?
Most certainly, Madam Deputy Speaker, most certainly. Thank you very much. And that is the reason why we decentralize the payee system, where people can go in different locations to have their tickets paid and what have you. So I'm coming back to the system that was designed to improve the ticketing system in this country. Warning is a good thing, because it provides the owner of the vehicle, or the driver of the vehicle, with an opportunity to rectify the issues. The 3 days does not make sense. It is unworkable. Forcing people to run to the licensing office and to the Trinidad and Tobago, to a police station within 3 days, and moving a document from one day to the other, oh my God, it does not make sense, Madam Deputy Speaker. What can be done is that if a law enforcement officer stops a vehicle and the law enforcement officer identifies some traffic violations and decides to issue a traffic violation, that warning can be issued on the device with the specified timeline. Of course, a timeline that is practical and workable, without overwhelming the licensing office, without overwhelming the Trinidad and Tobago Police Service. And it provides the violator or the alleged violator with an opportunity to rectify the issues. Once that is recorded, any other law enforcement officer that stops the driver of the vehicle on any other occasion, the law enforcement officer will see that on so-and-so date at so-and-so time, a warning was issued, and that you had 1 month or 20 days or 30 days to correct the issues. We checked your vehicle, the issues have not been addressed, and as a result of that, a fixed penalty ticket will be issued to you. That is what a warning system is all about. The platform is there. The technological platform is already there. And all that is required, Madam Deputy Speaker, is for the technology to be amended to allow for law enforcement officers to issue a warning, allow the driver the time and the space to address the issue, and if they are stopped in a roadblock or on any other occasion, and the law enforcement officer who stops the driver on the next occasion, he would see from the technology that this driver was warned on a particular occasion, and if it is still within the timeline to address the issues, they allow you to go your way. And if it is over the timeline, then a fixed penalty ticket is issued. That can be done seamlessly. It is a practicable approach to addressing this. It will not overwhelm the licensing office or offices around the country. It will not overwhelm police stations around the office, around the country. And it will produce the outcome that we all desire in this country. But this bill that the minister and the government introduced in this parliament, it is going to wreak more havoc. It is going to cause more pain, especially on poor people in this country, because I can just imagine the lines that you're going to see at licensing office around the country, the lines in police stations around the country. You could just imagine, Madam Deputy Speaker, what can happen. And if citizens believe what transpired over the Christmas holidays are going to be dealt with by this piece of legislation, then wait and you will see where barley does grow. Wait and you will see where barley does grow. This legislation does not make sense. The government needs to go back to the drawing board or listen to some of the recommendations coming out from this side, because the history of the PNM has always been on the side of law enforcement, and it is because of that we can boast that under the PNM, road fatality dropped by 60% in this country. And therefore, we will support any piece of legislation that makes sense, that is workable, not no knee-jerk reaction to your bad behavior, not no knee-jerk reaction to your interference of the laws when you believe that we were distracted over the Christmas and New Year's holidays. Bring new legislation, bring good legislation, because according to my colleague from Tobago East, he said Tobago East or something like that, they support good legislation or something like, or this is excellent. This is not excellent legislation. And if he believes what he is saying, to save this piece of legislation from the embarrassment that it is, the government should take on board some of these recommendations. And if the government is not prepared to take on board the recommendations that we have made, then Crapo smoke our collective pipes. And the people of this country will see mayhem when this legislation comes into place. And we are warning this government. This piece of legislation is sloppy. It makes no sense. It is going to cause more burden on the people of Trinidad and Tobago. You should settle yourself and come with something better. Thank you, Madam Deputy Speaker.
Member for Barataria, San Juan.
Bring back some sanity to this thing here. Bring back some sanity.
Thank you very much, Madam Deputy
Bring back some
Speaker, for allowing me this opportunity to join
that technocratic
this debate at such a timely manner. Madam Deputy Speaker, my colleagues are encouraging me to bring back some sanity, to bring back some common sense and logic to this debate. And when you listen to my colleagues opposite Madam Deputy Speaker, they are all experts in vehicles, you know. They are experts in vehicles, and I want to believe them because I believe they are the only political party to sell 2 cars and build a 5-story building. You see, when I listen to my colleague from Aruka, Lopino, I had to ask the Attorney General if he was a student of his, because he clearly did not understand the law, and I don't want to accuse him of being deliberate, but he misled this Parliament with respect to the interpretation of the bill before us. And I think it is my duty,
Was it standing order? Was it standing order?
Overruled. He is not imputing improper motive. He is just explaining what you said.
Thank you very much, Madam Deputy Speaker. Madam Deputy Speaker, I'll go through the clauses of the bill to show where my colleague clearly had no understanding whatsoever of the law. You see, my colleague said that he was a technocrat at the Ministry of Works and Transport, and he worked so hard on all of this demerit points and this U-turn system and so on. And this is in 2017 that the Motor Vehicle Act was amended to include the demerit points and so on. He became a member of Parliament in 2020, and you know the former Prime Minister didn't even put him in that ministry. So it speaks for itself, right? It speaks for itself. But he said that the legislation is not workable, it is ridiculous, and it is sloppy. Now, Madam Deputy Speaker, I want to take you to the substantive clause of this bill, which is Clause 6. Do you know Clause 6 mirrors identically what Section 81 of the Parent Law says? What? You know who passed the Parent Law? What? It is them who passed the Parent Law. So he is saying that everything that we have in this bill, which mirrors the Parent Act at Section 81, ain't making sense. Simple. It says, Madam Deputy Speaker, he went through the clauses. He said that, and I'll go back through it. He said it is not workable when you looked at subsection 2 and 3, which says that they will affix a fixed penalty notice to any part of the vehicle because a vagrant might pick it up. Madam Deputy Speaker, you know when you go to the substantive legislation at Section 81(2), it says that the constable may affix a fixed penalty notice to any part of the vehicle. So he didn't think about the vagrant when he advised the government to pass the law the last time, Madam Speaker. He then says it is draconian. It is not the rule of law, because at subsection 3, the owner of a vehicle on which a fixed penalty warning was affixed under 2 shall be presumed to be the person liable for the traffic violation. You know, if you go back to the Parent Law that they passed at subsection 3, it says, the owner of a vehicle on which a fixed penalty notice was affixed under 2 shall be presumed to be the person liable for the traffic violation. It is the identical thing. So this is sheer hypocrisy when the member for Aruka Lopino will come here to say that the legislation is sloppy, it is unworkable, it is draconian, and this is the same law that they passed in 2017. And he couldn't see that? Is that the level of intellectual laziness that they are subjected to? But, Madam Deputy Speaker, it is the licks that they got on Monday that have them buzzody. That licks wash away all the common sense from that side. That licks mash them up, Madam Deputy Speaker. And then the member for Diego Martin Northeast, who is not here right now, he said, it is absurd. Where did they get this 1 day, 24 hours notice from? That if you get the fixed penalty notice, according to the bill, at subsection 6, the fixed penalty warning, you have to send a duplicate of that fixed penalty warning to the licensing authority within 1 day. He said, I don't know where they get 1 day from. Who come up with 1 day? Where they get it from? Well, Madam Deputy Speaker, you know when you go in the parent law, that they passed in 2017, it used to be 3 days. You know in 2020 they amended the parent law to now bring it back to 1 day?
Who them? Nah. Sir, I'm not them.
You know, Madam Deputy Speaker, members of Parliament are paid or given an allocation for staff to help with research and things. Oh gosh, let someone help you all prepare for your contribution, man. And in fact, Parliament has given you an iPad with internet. Use it. Use it.
Rotunda.
And I'll tell you something, the laws of Trinidad and Tobago are all online. Use it. Use it. You see, Madam Deputy Speaker, when you listen to them, you will think that we come up with this law and it is we hate people and so on. But Madam Speaker, we are mirroring what is already in the existing law. We mirror it. We mirror it. So where's the problem?
So they bring this 1 day?
Yes, they brought the 1 day and now chastising us for putting a 1 day notice. But Madam Deputy Speaker, we have to look at the architect of the law. Currently, the law, if this bill is not passed, currently the law stands as you have a vehicle, for example, without wipers. The police stops you, the law enforcement officer stops you, immediately you get a fixed penalty notice. Immediately. What we are saying is no. Take a few days, sort out your business, and you have not a single cent to pay. What's wrong with that? We have not created a single new offense in this bill. All of this are existing offenses on the book. Not a single new offense was created. So what is the draconian nature that my friends are speaking of opposite? You are getting a chance to fix the infraction so that therefore you don't have to be subject to the fixed penalty fine. So it is relieving a burden towards the citizenry, but at the same time ensuring that there is law compliance.
Some fairness.
If you have your vehicle in a good working condition, I'm sure when they were ministers, you think they could drive in a vehicle without wiper? No. They wouldn't do that. No, they won't do that. Up till now, they wouldn't do that. But Madam Speaker, if you have your vehicle in a good working condition, you have nothing to worry about. But if you break the law, then you have something to worry about. You have nothing to worry about. And then, you know, my colleague, Aruka Lopido, he said, you know, the PNM, they did so well with road safety that they reduced road fatalities to the lowest since 1945. Madam Deputy Speaker, I think in 1945 we had bull cat and donkey cat and thing, you know. It had no car on the road really. Madam Speaker, he then said that it had the lowest number of road fatalities during their tenure. In 2020, let's look at the history. Let's examine this. The demerit points were introduced in 2020, I think around May or so. I have the numbers here. And these numbers come from the Ministry of Transport and Civil Aviation. There was, in fact, a dip in road fatalities in the year 2021. But you know what happened? There was a lockdown where everybody was in their home because of what? The Delta variant. That was the deadly wave, Madam Deputy Speaker. So there was a decrease. But I want to show you other statistics, Madam Speaker. So let's use that as a baseline, 2021. There were about fatalities, 75 in 2021. Demerit points on board. 2022, it went up to 95. 2023, it went up to 102. 2024, it went up to 124. So how could you say that the demerit points were working? We as a government took a responsible decision by saying that demerit points was not working. We are going to scrap it. Promise made, promise kept. We scrapped it, Madam Deputy Speaker. But at the same time of scrapping it, we had to ensure that there must be some responsibility upon citizens. So therefore, we increased the fine so that there will be a level of deterrence so that people will not break the law. That is what they wouldn't break, so that they wouldn't break the law. But under the PNM law, you had to pay the fine. You get the demerit points, and sometimes you get your license suspended.
Fixed penalty too.
We take out that part with the demerit points, we take out that part with the suspension, and all you have to do is pay the fine. And with this bill now, you have some time to fix the issue before you even get a fine.
What's wrong with that?
What's wrong with that? You all should come here and support that. Yes. You all should come here and support that. But that is why you all only know about country when it is convenient. You all put party before country. That is what you all do. That is what they do. And you know, Diego Martin Naughty said it, you know. Diego Martin Naughty say that how the bloggers are against us. He monitoring Facebook, you know. He are monitoring the law, you know. He monitoring Facebook. He on news source or whatever that is called our source. Right? That is what he doing. He not studying about the safety of the citizens of Trinidad and Tobago. He's not. He is not. Madam Speaker, when we spoke of a lawless society, that is because the PNM left Trinidad and Tobago in a lawless state after 10 years of mismanagement, corruption, nepotism, and incompetence. And you know, they like to talk about these things, but I want to go back in history because I alone didn't agree, or the government here didn't agree that we're in a state of lawlessness on the road. I'm going back to a debate on the 23rd of June 2017. It have a fella who used to sit down on the side, I think on this seat right here.
Right there.
The former Minister of Health, Terence Yalsing. And I quoted him, you know. This is what he said. I quote. They were debating the Motor Vehicles Amendment Bill 2017.
What?
And when he was debating this bill, this is what he had to say. It is about inculcating a culture of safety on our roads because our roads are a place of lawlessness.
Nah, who said that? Who said that?
You ever repeat it?
Send that up. No wonder he went send
The Yalsing said it is about inculcating a culture of safety on our roads because our roads are a place of lawlessness. And until we admit that we have that lawlessness problem, like a drug addict, unless you admit you have a problem, you will not find a solution. The Yalsing said that, you know. I didn't say that. So what? All you disagree with the Yalsing now? You all disagree? So you see, Madam Speaker, when they sit down on that side of the chamber, they just like to say something else. But they at that time agreed that the roads were a place of lawlessness. We came in, we found it in that state, and we are taking steps to fix it. To fix it. And you know, they want to talk about that we're using this as some revenue generation measure. That is not true. We are using this bill in order to save lives on the nation's roads. Because, Madam Speaker, you know I like to walk. You know I like to walk with my numbers and my statistics and my data. You know I like to do my research. Madam Deputy Speaker, before I come in this Parliament. In the year 2015, and I'm using the yellow books that everybody has access to. There's a line item called Motor Vehicles and Road Traffic Fixed Penalty Amendment Regulations Ticket System. In 2015, $42 million were collected in revenue from fixed penalty, from tickets or so on, in 2015. Do you know what is the estimate of revenue in 2025 when they left office for fixed penalty notices? $100 million. They want to tell us that we were using this as revenue generation. In that 10-year period, Madam Deputy Speaker, if you calculate it, they collected $1 billion worth of traffic fines. $1 billion. $1 billion. And have the gall to come and tell us that we're using this as a revenue generation. We are here to save lives because no amount of money can compensate a family member when they lose a loved one on the nation's road because of carelessness, because of recklessness, because of negligence, and because of drunkenness on the road. We are taking that stance, Madam Deputy Speaker. If they don't want to stand with us, we will stand alone in this fight, Madam Deputy Speaker. You mean to tell us that their problem is that we increase fines because somebody is caught driving under the influence of alcohol on the road? That is what they're against, you know. They vex about that. They vex because a man don't have insurance in his car, you know. They vex because a man driving his car without a valid driver's permit, you know, Madam Deputy Speaker. They vex about that. We shouldn't increase the fines for that. We should just hit him a tap on his arm and go up the road? No. When they kill somebody, who is compensating that family? Who is compensating the victims of that family? Madam Deputy Speaker, when I was in private practice, as soon as I came out of law school, as a young attorney, I was engaged in a lot of these running down actions, you call them, where persons get themselves in accidents and so on. And Madam Deputy Speaker, you would have seen clients, victims come to the office because the man who knocked down the mother, the car that was driving, had no insurance. And for you to sit down there and tell that child, listen, you can't get nothing for the loss of your mother because the man had no insurance. The man had no insurance. And today you all are against that? I cry shame upon the PNL. Do you know that even if you have a valid policy of insurance on a vehicle, but the driver that is driving that vehicle does not have a valid driver's permit, do you know that person will not be covered? Under the insurance. The judgment will be entered against the driver personally. But if he's a man of straw, you have nothing to get. You have absolutely nothing to get. Why are you all against this? We are trying to create a society of law and order. We are trying to restore law and order on the nation's roadway. And today, you cannot lend the support. Put away the Balizé tie and wave the red, black, and white in this parliament. Put it away. Put it away. Put it away. Because I want to give you the statistics. You see, look, we have the numbers here.
Teach them.
As of the 15th of January this year, late driving permit renewals for 2026, this is 15 days in a year. 6 months or less, 2,107 persons. Those persons were not driving with a valid license on the road. 2,100 people. 2,100. More than 6 months, but less than 3 years, 142. More than 6 months and less than 5 years, 20. A total of 2,269 persons did not have valid driver's license.
PH drivers too, you know.
I'm not against that. 1,608 vehicles were transferred between that period. That means that persons now came to comply with the law in order for their vehicles to be transferred. And there's another issue. My colleague from Arangwa St. Joseph will also tell you that when you sell a vehicle from one person to the next, and I have a court judgment, it's a Privy Council decision, Neil Rupa, you will see that where you transfer a vehicle and you don't effect the transfer and you don't notify the insurance company, but that vehicle gets into an accident, the insurance policy is also void. The insurance company is not liable to honor any judgment made. And that was clearly stated in this judgment, and it's a common sense approach in terms of the judgment. And I'll quote the paragraph. It relied on the Privy Council case, a local case, CB 2008-03548, Darian Balkaran against Anthony Mitchell, Dave Thomas, and Beacon Insurance. And in that case, at paragraph 6, which relied on the Privy Council case, it says it's an abuse, it's quoting, it's an abuse of language to say that a person who has bought a car is driving it with the consent of the previous owner, for the latter no longer has the power to consent or to withhold consent to the use of it by the new owner. Which simply means that if you sell the car how could the previous man, who was the previous owner, notwithstanding he's a registered owner, say, well, I given X the consent to drive a vehicle? Of course, the insurance company cannot take that particular risk. My friend from Malabar, Mausika, will well know of these matters, being someone in the insurance industry. And he's laughing because I'm being accurate in these particular matters. Let me get back, Madam Deputy Speaker, to some of the numbers. Again, as at Brian used to sell insurance too?
He's an expert.
As at the 15th of January 2026, vehicles inspections, Madam Deputy Speaker, this one was frightening. 31,859 vehicles went for inspection. They passed. That's a good thing. The bad thing is 4,333 vehicles failed inspection. And those are vehicles on the nation's roadway. Those could be potential weapons on the road that could kill yourself or a family member. So what is wrong with what we are doing, Madam Deputy Speaker? If you follow the law, you have nothing to worry about. You have nothing to worry about. You have nothing to worry about. You see, Madam Speaker, also, the fine for driving without insurance has now increased to $10,000. For driving without a permit, it's $1,500. And then there's another category where it can go up to about $3,000. But my friend from Aruka, Lopino, and the member for Diego Martin Northeast went through the schedule of the bill that deals with the notice period and the amount of days you have to fix these particular matters. And we have to be very honest with the population when we're dealing with these matters. This is what we're giving the timeline for. Let's look at the first one. No identification light for the illumination of identification marks on vehicles at night, 3 days. You want more than 3 days to fix a light bulb in your car? That could be fixed in a matter of minutes. That could be fixed in a matter of minutes. No tear or MGW painted on the vehicle. 3 days. To put the number of passengers to be carried on the ride of a taxi. You could go by the tint man and they cut out that fare in a few minutes and stick it on the door. Unauthorized lights on the front or the rear of the vehicle. 3 days to remove that. Vehicles without a horn. Well, I don't want to get into them kind of business, but Madam Speaker, 3 days. You can't go and fix your horn in 3 days?
That is take more than 3 days.
I am not getting into that conversation with Port of Spain. I am not getting into that arena with Port of Spain South. Use of vehicle with no windshield wiper or defective wiper, 3 days. You could go by the auto shop and get a wiper almost immediately. And if it can't change it, you could ask the people there to change it for you too. Vehicles without a reflecting mirror, 3 days. And use of noisy vehicles, 7 days. Madam Deputy Speaker, you have these vehicles now where you plug it into a computer and it can tell you every single thing that's wrong with the vehicle. I started off, Madam Deputy Speaker, with a TIDA. They used to call me a wet man. Right? I remember, Madam Deputy Speaker, the car making noise that I carried by the auto shop. They plug in this thing into a computer and they could tell you everything that was wrong with the vehicle and it was repaired almost immediately. And I wasn't working for no kind of big money. It cost me a few $100s, but I fixed the vehicle because I remembered at that time I was doing these particular matters involving insurance claims. So I understood the importance of having a proper working vehicle on the road because I did not want to be the reason that I could cause harm to another person, Madam Deputy Speaker. We have to be responsible. We have to be responsible.
They still call you wet man?
So, Madam Deputy Speaker, I think I was able to bring back some level of sanity and logic to this debate, Madam Deputy Speaker. I attempted to ensure that the arguments that I made, I backed it up with statistics, facts, and data. The ball is in the opposition court now. If you all want to say no to this bill, ensure that you could convince the population that when someone dies because someone is driving without a valid driver's permit or they have no insurance in their car, go and ensure that you can comfort the victims of that particular accident, Madam Deputy Speaker, and I thank you very much.
Member for Port of Spain North, St. Anne's West.
Thank you very much, Madam Deputy Speaker. Madam Deputy Speaker, I'd like to start today's contribution, our first day back at Parliament in 2026, by reaching out to the constituents who I represent in Port of Spain North, St. Anne's West, and not only thanking them for the privilege of being able to advocate on their part, as they've asked me to here this evening, but also it's useful listening to some of the cross-talk and conversation coming from those on the other side, to just let the population know that as a lifetime member of the PNM, all of us on this side continue to be extremely proud members of the People's National Movement. There is not a single one of us that will falter in carrying out our duty to our constituents who have elected us faithfully to represent them. And this evening and today is a perfect example of why we must carry that responsibility very, very seriously and understand how important it is that we stand in the breach for the people of Trinidad and Tobago. Because what I have heard today, and in particular from the member from Barataria Sahawa, who's departing the chamber at this time, is a completely out of touch contribution. And I start by giving one example. I was at the Belmont Fire Station recently over the season period, driving by to go to my office, and decided to pop in and thank the men and women for their service. And whilst I was there on the pavement, a young man came up to me, a security guard, and asked if he could speak to me for a moment. I said, obviously, and yes, of course, please tell me what's going on. And the pain within which he related the following story, I'd like to share with all of my colleagues here this evening. Because it is important that when you are out of touch, suffering from hubris and in your ivory towers on the other side, you understand that there are those out there who are suffering as a direct result of the policies they have implemented. This young man told me, he pointed to a vehicle on Observatory Street, and he said that's his vehicle, and he works during the day as a security officer, and then he runs a taxi from the evening when he gets off into the night. And he began to relate his experiences and how many tickets that he unfortunately was given, that he was waiting to challenge some of them, because at the taxi stand, he related that there was rivalry and some favoritism, unfortunately, by some of the persons who were issuing tickets. And he related with tears in his eye that he had racked up $13,000 in tickets. And he said, Mr. Young, how can I run my vehicle as a taxi to feed my family, because I'm not making ends meet as a security officer? And today, one of the points we're making that was completely missed by the member for Barataria Sawa, one thing he has become an expert at, as those on the other side, is being a spin doctor and trying to spin reality. The issue we took, and the previous speakers on this side, in advocating for the population, both the member for Diego Martin Northeast as well as the Chief Whip, was on the increase in fines and the significant increases in fines. Because this security guard was relating this before Christmas. And it was on Boxing Day that we woke up with no notification from the government, but rather persons who fortunately were looking at orders published in the Gazette, and we were informed about the draconian increases in fines. No one on this side, not a single member on the PNM side, would ever endorse lawlessness. So don't come here and try to say that is what we're doing. We are very much in agreement with if you follow the law, you may have no problems. But the reality is very different, as that young man related to me. Because very often there can be misunderstandings. And as the member for the Barataria Sawa tried to spin and ended by saying, if you don't support this bill, when somebody dies in an accident, explain it to the family. Nothing in this bill, not a single one of the provisions in the schedule of this bill has anything to do with something that would cause a fatal accident. So don't try to mislead the population. All this bill is here today to do is to try to tidy up a mess and mitigate the pain that you cause as thieves in the night with your legislation. So for the population looking on, this bill here today is solely about trying to provide periods of time for certain offenses to be fixed so you don't face the draconian and awful fines. And to hear a privileged member from Barataria Sawa talk about, well, in today's world, you plug your car into a computer and it tells you everything. You are completely out of touch. Come and walk with me from here to East Port of Spain into Belmont and ask the people who are now unemployed as a result of your policies and decisions whether they can pay a fine of $3,000 when their monthly salary that they're trying to feed their families is less than $3,000 or around $3,000. And they're not breaking the law because they want to break the law. So let's use an example. Your brake light is not working, and that can happen to anybody. You could walk out here now into your fancy vehicle and the brake light bulb has blown or there has been a computer malfunction. And as you leave two streets down, a police officer stops you, says your brake light, because you don't know your brake light isn't working. Your brake light isn't working, and he issues you, as the law currently stands, with a huge fine of thousands of dollars. Your brake light was working this morning because you're a conscientious, law-abiding citizen. As you got into the car, you asked a family member, tell me if my brake lights are working. A bulb can blow at any time. Now, if you have certain types of vehicles as well, Madam Deputy Speaker, and you may or may not know this, sometimes the parts are going to be difficult to get, especially with older vehicles. And those on the other side don't seem to appreciate that. Not only do you have to find the money for the part, you have to find a mechanic to change the part. And then you're being asked in certain instances to get that done in 3 days. But even this bill does not alleviate the pain of the huge sums of fines. Nobody is saying don't fine people. And I agree. One of the fines quoted $10,000 for no insurance. And the member for Barataria Sawa explained what can happen in a liability situation where the insurance company, for certain reasons, may void the insurance, or worse yet, as he says, you have no insurance and you get into an accident and persons who are hurt, damaged, injured, them or their families can't get the damages. But that is not what we're talking about. We're talking about some of the lesser infractions. And this is affecting businesses as well. Go and ask my friend's constituent in Port of Spain South, his constituents on the main road of St. James. Because it was only recently I found out that you can't park facing against the traffic in St. James. So now They are dropping fines on people in St. James in thousands of dollars for someone who may stop to run in quickly to a business place to get something, and they come out and meet that. Well, unlike the lives that those on the other side may be living, there are tens of thousands, if not hundreds of thousands, of persons out there hurting on a daily basis, trying to make ends meet. And that is who we're advocating for today. And for my friends in Tobago, who are riding a high blue wave, as they call it here today, the reason they can talk the way they have is because not a single one of these fines that were increased in the dead of night on Christmas Day have been implemented in Tobago as yet. The Chief Secretary himself is on record saying and threatening authorities prior to the election, saying, don't come here in Tobago and drop no fine on my people. Well, the election done now. And when you start to get the $3,000 fine and the $5,000 fine on a vehicle, when you're struggling to make ends meet, as happened in the Macoya market recently, where persons trying to earn an honest living, farmers, were locked into a compound and their vehicles inspected and tickets dished out by the dozens, taking away all of their days and probably their months' produce in money. That is what we are advocating against on this side. So don't try to spin nothing, and the people know it. And it's funny, you know, because I sit here and it is some of the people in your own constituencies, and I know some of you all would have heard these stories. Taxis in Barataria, Sawa, making the complaint to us about what is going on. Nobody is saying condone the breaking of the law. But as the member for Diego Martin Northeast pointed out, and one of our suggestions today, give more time if you want to pursue a bill like this, because it is difficult. It is difficult, and I am sure every member of parliament on this side has faced it, getting calls from constituents asking for help, monetary assistance, to be able to put their car in order because they have to drop children to school, or they're trying to make a hustle. A small oil leak. An oil leak can happen like that. You go over, you hit a pothole, something like that, something goes wrong, and you get an oil leak, especially with older vehicles. That is a fine of between $2,000 and $4,000. So you have to fix that leak and pay a $4,000 fine. If you want to really provide and alleviate the hurt to the citizens of Trinidad and Tobago out there, increase the number of days, as has been pointed out from other jurisdictions by the member for Diego Martin Northeast. And those are jurisdictions that are considered wealthy nations, jurisdictions where their currency is trading currency. North America, Europe, and these instances. When you look at the schedule, a vehicle with defective fittings, 7 business days. But there's no definition of defective fittings, how many it may be. As I said, there may be difficulties in locating parts. There may be difficulties in getting a mechanic. One of my employees has been trying to get a mechanic to fix in his older vehicle, his air conditioner now for months. You're calling the mechanic, they tell you, come on Tuesday. When you go on Tuesday, they're not home. These are the realities of life for the vast majority of citizens who we have to represent. So our problem, our issue, our plea, in fact, is for those who are suffering the hardships that come about by the fines. And I repeat, nobody is saying that you should not have fines, but you determine the amount of fines, and then to try and spin, as they try to do, that in the 2025 fiscal budget, there was an estimate of $100 million. It is a fact in this fiscal, in this budget, when you go to the revenue documents, you see an increase in revenue for this fiscal, predicted and estimated an increase of $200 million. That's a fact. So don't come and pretend, and to compare 5 years, to compare 5 and 6 years with your 1 year. The administration of this is also an area of concern, as we've heard. As I've sat here, I have had officers reaching out on the phone asking me certain questions. For example, you go and you get your brake light fixed. It says with this piece of legislation now, you could go to a police station and get a police officer to inspect it. So you're dragging police officers away in the police station now to come and look at a vehicle to see if the brake light is working. Let's say they are fine with that and they're okay and they can say, yes, it is working. He then asked, what if the station doesn't have certificates of compliance? Because, of course, that's a prescribed form. And they said, just like there weren't the fixed penalty notices for the fireworks legislation over the Christmas, which is one of the reasons why charges could not be given out for the illegal fireworks. He says, what then happens? So you rush, you find the money, you borrow the money, you fix the brake light, you rush down to police station. First one card with the second one card with the third one. Let's say they have a certificate of compliance. That police officer now has the responsibility, the burden and the liability of ensuring that is transmitted to licensing office within 1 day. Because in the automated system, I trust that they have, if it is not entered immediately, fixed penalty warning becomes a fixed penalty notice, i.e. a ticket to pay those thousands of dollars in fines. And again, the dishonesty by the previous speaker in trying to misconstrue the contribution for the member for Aruka Lopino and to say that all we have done is copy your legislation. That is a lie. That is an untruth. Because this legislation is completely new. For the first time, you are introducing something called a fixed penalty warning. So don't come and try to misconstrue and misinform the population as to what a previous speaker has said. We are raising concerns and serious concerns. Our concerns are not meant for a moment to water down the good work that has been done by the licensing authority. And at this juncture, I want to give kudos and to thank the licensing authority for the program that they've embarked on in the past few years in digitizing their IT systems that would allow for some of this to be done. Well done. Our issue is not the fines. Our issue is the level of the fines. And when those fines are issued, what it then means for the persons who are struggling to make ends meet. Because you see, in this world of criminal law, if they don't pay the fine, what is the next question? What happens to them? Is a warrant going to be issued for them? Are they then going to be dragged before the court in handcuffs because they didn't have the money to pay the fine? Because as I think it was the Honorable Minister piloting the bill, I believe that I saw you saying that somebody had asked over the period that you can't pay the fines in installments, and he's right. So use the opportunity now as you're coming to try to mitigate and try to give time. Provide more time is one of the suggestions we have. To provide more time so realistically people can conform to the law. Because I guarantee you it will be an extremely small percentage, if it even exists, of people who know that something is wrong with their vehicle and they will not fix it. There is a reason. So your windshield wiper is not working, or in this case is not there. You leave home, your windshield wiper is working fine, something happens along the way, during the course of the day, somebody even comes and steals your windshield wiper, as used to happen in the 1980s when things got hard. And I wouldn't be surprised if we return to that, because you're seeing more and more petty crime taking place. So somebody comes and does that, and what? You jump in your vehicle, driving down the road, a roadblock, and you get a fine for that? You look at this piece of legislation and the administration that is required to be able to implement this. And I repeat, this legislation only came into play because they bungled it on Christmas Day with the increases in fines. And the population rose up. And the population began with their outcry. Anyone driving past any licensing authority office, including on Ryson Road, from the start of the year, would see the long lines all the way down from the Hyatt, from Dock Road, go straight down to licensing office. Old people, 75, 80 years old, going there at 6 o'clock in the morning, at 9 o'clock, 10 o'clock, they're still waiting in line to transact business. The first few days, it was overwhelmed. We were discussing the night before in San Fernando, people lining up at 3 o'clock in the morning. And let us not pretend as well, because when we were discussing this particular bill a few days ago in caucus, one of our colleagues gave us an incident and a story that his constituent was telling. And said it in jest, but it was true. Stopped by an officer. The officer says, well, this will be $4,000 in fines. If, when you start to drive up the prices like this, and it reminded me of that security guard who was getting tickets for the back of his vehicle, he said being 2 centimeters over the line. Or things being made up on him because other persons who he was competing against in the taxi stand had friends in authority. Those are some of the realities. Our next problem with this, and we were discussing it a short while ago, I was being told that now when you decide to challenge the tickets, the court dates that you are getting are years from now. 6 years, we were being told, from now. So all you are seeking, all you are going to do, by what you think is a good provision and a good set of amendments to the law, is you're going to back up the judicial system once again, something that was cleared in the last 5 to 10 years. Magistrates' court with these types of matters now are overwhelmed. People are unsure what you have to do because now it's moved to a virtual system. So this morning I got a call from someone asking me what to do. They had received a ticket. They said they were going to challenge it and they didn't know what to do. I had to ask them, well, did you get a virtual link? Did you get a court date? They said, yes, it's this morning at 9. I said, well, call me back after it takes place and tell me what happened. They called back before 9. I said, what happened? They said, well, we logged on. Someone came on and said, all the cases set for today were heard yesterday. Because the magistrate couldn't come today, and the magistrate knew that yesterday. So he or she just adjourned all of the cases that were set for today, yesterday, to a week from now. That is the reality of what we're facing. And that's not the judiciary's fault. So what you want to do for these minor infractions now is, I didn't say this is government fault, but you have the policy decision as to what you want to do. You have the policy decision now that you're increasing fines by over 100%. Every single fine increased by over 100%. That's a policy decision. So keep putting the burden and the pressure on the citizens of Trinidad and Tobago. And when you started to get the backlash, you run with this piece of legislation and this bill, and you're giving people 3 days and 1 day to fix things, and then burdening the licensing office, burdening the police officers. Licensing office, despite the best efforts of the officers, the men and women down there, and those in administration who, again, I thank today, they have been overwhelmed over the past few weeks, and there is no sign of that easing up. And now you come with these provisions to add additional burdens on them. Because when I fix my vehicle, in the 3 days or the one, I now have to go and find a police officer or down at licensing office, make sure they issue a certificate of compliance, and they then have the responsibility to get that into the system at licensing office in 1 day's time. Otherwise, I translate straight to a fixed ticket penalty of these thousands of dollars. I then have to say, wait for my day in court. I wouldn't know, because you wouldn't know whether that 1 day period has been met. The next thing is, I assume somehow you get a summons from court, and you now have to go to court to convince the magistrate that you actually did what you were supposed to do in the time period. They can't find the police officer you went to in the Belmont police station because he or she was then transferred out. How are you going to prove what happened? You better hope you hold on to a certificate of compliance. So these are some of the problems we foresee with this. And today we have simply come here to advocate for the people of Trinidad and Tobago. Not the wealthy people, because as somebody said, the wealthy could pay it. And in fact, one of the things we are told about these increases in fines and the move away from the demerit system was that the wealthy preferred to pay fines than lose their license for the same thing that Barataria Sawa was talking about, for example, drink driving. Was that the policy decision? So our purpose here this evening and our opposition, because we are opposed to it in its current form, our opposition to this, apart from what my friends who spoke before me on this side have said, is increase the amount of time. You're trying to mitigate the effects. You're trying to provide for persons to right the wrongs, give them a sufficient period of time. We've heard about reasonable time in Antigua and St. Lucia. We've heard about 30 days in Florida, where every block there are stores that sell car parts and mechanics galore. If in that society where, as we heard, the minimum wage is 5 times that of Trinidad, they provide 30 days. Why here in Trinidad, with the tens of thousands of unemployed people struggling as a result of your policies, are you now punishing the citizens? And that is what the population is talking about. They are being punished by those on the other side. So, Madam Deputy Speaker, we say it is not realistic. We say it is unfair. We say the burdens, especially on the more vulnerable in society, are increasing by the day as a result of the policies being implemented. We on this side say, do what is right. You've come with theoretically a good policy in terms of allowing people an opportunity to fix what can be fixed. Look at the periods of time, amend the periods of time, give reasonable periods of time for people to fix their vehicles and fix what is wrong, understanding what we have articulated here today on behalf of our constituents and the citizens of Trinidad and Tobago. Madam Speaker, with those few words, I thank you.
Okay. I am also on my feet. Leader of the House.
Thank you kindly. Madam Deputy Speaker. Madam Deputy Speaker, in accordance with Standing Order 15.5, I beg to move that the House continue to sit until the completion of the business before it.
Honorable members, the question is that this House continue to sit until the completion of its business. Those in favor say aye. Aye. Those against say no. The ayes have it. Member for
Thank you, colleagues. Thank you, Madam Deputy Speaker, for the opportunity to make a brief intervention in this debate as the government seeks to remedy the lawless dump that is Trinidad and Tobago as described by the Prime Minister. Madam Deputy Speaker, permit me to begin by replying to a couple of the previous speakers from that side. The member for Tobago East, who spoke about the merit point system. And, he made a point that is essentially a talking point that we keep hearing repeated by the supporters of members opposite. That with respect to the fines, that the only persons who have to be concerned about fines are the lawbreakers. The same principle applies, Madam Deputy Speaker, for the demerit point system. If you didn't break the law, you would get no demerit points. Anybody on this side, Madam Deputy Speaker, got demerit points? So the same holds. But when they come and they try to make the insinuation that we on this side somehow support lawlessness, nothing could be further from the truth, Madam Deputy Speaker. The member for Tobago East, Madam Deputy Speaker, also spoke about, again, with the issue of the demerit points, but it wasn't so long ago, I think it was just about 2 years ago. Tobagonians were complaining about the men in white shirts coming up from Trinidad and terrorizing and oppressing Tobagonians. No less a person than the Chief Secretary was complaining about it. In fact, we had one of the secretaries in Tobago was saying that he would give instructions to the security at the airport in Tobago that when the men in white shirts arrive, put them back on the plane and send them back to Trinidad, not tolerating them coming to oppress. But today, what they called oppression under the last administration today is good governance, Madam Deputy Speaker. Again, on the issue of the demerit points, yes, the member for Tobago East, Madam Deputy Speaker, talked about how the demerit points were so punitive. They were so punitive. I'm responding to the member, right? Yeah, well, he spoke a lot of things there that needs to be corrected. He spoke about the demerit points being so punitive, Madam Deputy Speaker, and that you could find yourself having your license suspended with just one infraction. But, Madam Deputy Speaker, the Minister for Transport just last week had a press conference at the headquarters of the UNC in which he indicated that when he came into office, he was surprised to see the number of notices for suspension of licenses because of the demerit points. And based on what he saw, there was nothing in place to suspend these licenses. And he said, the minister, the former administration had no intentions of suspending people's licenses. The minister said that. So perhaps the member for Tobago, he should have had a chat with his colleague to his right before making that statement. Madam Deputy Speaker, the minister also said that the decision to, the Prime Minister would have made a promise on the campaign trail. And permit me to quote, I don't want to misrepresent. So just permit me to quote what the Prime Minister said, Madam Deputy Speaker. The fines were too high. And there was a promise to reduce those fines because it was oppressive, wicked. Traffic fines are too high. A UNC government will reduce traffic fines across the board and implement state-sponsored driver education programs instead. Two promises made. Neither one kept, neither one delivered. And we know at least one of them will not be delivered, and that is to reduce the fines. Exactly. Because the Prime Minister has been quite pellucid. I don't want to upset the member for Tabakita. I know he doesn't like when you say pellucidly clear. Pellucid right, that there will be no reduction in the fines. She has been quite clear about that, Madam Deputy Speaker. So the issue we have is that the fines are too draconian. Not with everything.
55(1)(b). We've heard that several times.
Yes, member, please continue. Please move on.
Madam Deputy Speaker. Madam Deputy Speaker, the minister indicated that while on the hustings, they did not have the data, the statistics, with respect to the level of lawlessness on the nation's roads. Hence the reason, the promise that was made by the Prime Minister to lower fines. And it was only coming into office that they came to this realization. You know, it was interesting listening to the member for Barataria San Juan because he quoted a lot of statistics. But it seems they lacked those skills before the 1st of May and only developed that ability post 1st of May. Because, permit me, Madam Deputy Speaker, to read an article dated June 6, 2024. Sinanan defends the merit point system. Minister of Works and Transport, Rohan Sinanan, wants the population to know that the demerit point system is under review. In fact, he says it has been under review every year since it was introduced in May 2020. He said as a result of this process, the ministry amended the minor offences list and removed the deducting of points for defective fittings or blown park or taillights in 2022. In the current review process, Sinanan said the ministry is looking at other adjustments. We are looking at extending that time of suspending a driver, and before you reach to that point, you can go and do a course, or you can go and do some rehabilitative driving. And there are several things that we are looking at. This is 2024. He explained during the 10th Road Safety Award ceremony.
55(b), while the member is quoting an article, his chief whip went into lengths to speak about the merits of the merits. 55(b), I stood on 55(b), repetition, he's repeating the same argument of Aruka Lopino.
Yes, member, we have heard this more than once. If you wish to contribute, let's move on. Please, thank you very much.
Madam Deputy Speaker, this article was not read, and I am reading the article to point
Madam
out
Deputy Speaker,
that
I'm not
the
speaking of
statistics they claim they did not have exist in the article.
55(b). It is not about the article. The merit of the article is the demerit point system, which the chief whip spoke about. So, Madam Deputy Speaker, it is tedious repetition to speak about the demerit point system yet again, regardless if you use Express,
Madam Deputy
Newsday,
Speaker,
or the
I
New York
object.
Times.
That is a completely different point the member is making. Completely different point. I object.
I am going to allow the member to refer to the article, but I will not allow you to be tediously repetitive. So I am allowing the article to be read, and then we move on.
Thank you, Madam Deputy Speaker. Madam Deputy Speaker, I am attempting to read into the record the statistics that existed prior to this government coming into office, so that when they make the claim that they did not have the statistics during the campaign, the statistics were there. If you did not look for it, or as the member for Barataria San Juan told us, the information is on the internet. You have laptops, you have iPads. So how is it you all did not have this? And therefore, if you are stating that you did not have these statistics, on what basis did you oppose the demerit point system? If you did not know the statistics with respect to lawlessness on the roads, why did you oppose the demerit point system? The PNM put the statistics out there to defend the demerit point system, but again, it was opposed for opposing's sake when they were on this side. As Sinanan reiterated the importance of the system, he said some 37,000 people had been facing suspension from driving and were due to face remedial courses. That is why we are reviewing the system, because there are some people who are driving with over 300 demerit points attached to their name. You can imagine how many violations, but to them it's no big thing. Crime is not only somebody who takes a gun and goes and kills somebody. We all have a part to play in crime, and almost every crime committed, a vehicle is used. He said at the moment, if the police cannot find the offenders, they cannot be penalized and so on. Giving an example of errant driving, Sinanan said a 2020 survey done between January and June 27 at the Ryson Road traffic lights near the Hyatt Regency found 24,581 violations. The statistics were there. That is people breaking the traffic light right outside there. Another statistic revealed that from 2020 to 2023, 70,000 people were ticketed for not wearing seat belts. And the list goes on, Madam Deputy Speaker. So for them to say that they didn't have the statistics, they didn't know, it was there and efforts were being made, and perhaps if you all did not oppose and attack the demerit system and give the population the impression that it was only to collect revenue, then it might have had the opportunity to work and we would not be a lawless dump today. Madam Deputy Speaker, the member for Barataria San Juan quoted some statistics with respect to the number of persons who have sought to renew their licenses over the last couple of weeks. Some 2,100 persons, varying from 6 months to 2 years, 3 years, and so on. And it means that these persons were driving with, well, not suspended, but expired licenses, Madam Deputy Speaker. Madam Deputy Speaker, it is a well-known fact that we have thousands of people in this country who are the holders of driver's licenses and do not have cars. They do not drive. It is a requirement in this country, for instance, banking, to have 2 forms of ID. Most people use a driver's license and their ID card. So that when someone who uses their license simply for the purpose of ID finds that their license has expired and perhaps they may not have had the money at the time to renew, so they don't see the necessity to run and renew it because I'm not driving, I don't have access to a vehicle. Some persons, their licenses are coming up to expire soon. And since they've heard now that if just 1 day late, you pay your $500 plus an additional $650, persons are saying to avoid the $650, let me go and run quick and get my license renewed. And that is one of the problems that we are facing. So to make it seem as if we have all these lawless drivers on the road, people driving with expired licenses is not a fact. And perhaps the minister could have brought the statistics here to show us how many of those persons actually own vehicles. He spoke about vehicles being transferred and people taking months to transfer vehicles that have been sold. I recall a certain former Attorney General, not this one, a previous incarnation of this administration, sold a Range Rover and took 15 months to transfer. The titular head of the bar, 15 months. I could go there if you want me to read the article, I could read it. It's there. Yes. That was dealt with. That was dealt with. 15 months. 15 months. You all said nothing about that. Really?
Madam Deputy
right.
Speaker, I rise on Standing Order 53, 1E and F. The member is trying to make his contribution and is consistently being disturbed by the member for Shogunas East and Toko Sangrani. Can we please allow the member to continue in silence, please?
Yes, member, you may continue.
So much, Madam Deputy Speaker. Madam Deputy Speaker, the minister said, of transport that is, that this legislation stems from the fact that they decided to listen to the citizens. How did you do that? Was there consultation with the citizens with respect to these increasing fines? None. It came like a thief in the night on Christmas night, a late night Christmas gift to the population. The member for Digomata Northeast called out those that were in the budget. The Minister for Transport, again at the very same press conference last week, spoke to the issue. He said, members of the media and the public are saying that we did not announce this, but it was in the budget and it was in the finance bill. The same finance bill that they brought in December and lumped together a whole lot of things. Correct. And made it difficult for us to treat this issue in the way that it should have been treated. Madam Deputy Speaker, the average citizen is not going to say, boy, I have some time on Christmas Day. Let me get a copy of the finance bill and a glass of sorrel and sit down and take a read. They're not going to do that. Yeah, that's what they voted you all. That's your policy. Madam Deputy Speaker, that's their policy. It is their responsibility to ensure that they inform the citizenry. That's not our job. Yes. Correct. That is their job. That is your policy. Madam Deputy Speaker, compliance with the law requires two things: knowledge of the law and infrastructure. People need to know the law in order to comply, which is why it was important for them to. And the Prime Minister acknowledged that, again, with the promise to have this program, this education program for the citizenry. Madam Deputy Speaker, recently I was invited to a meeting at the home of one of my constituents. Right? A few of the neighbors came together to discuss issues with respect to the community, and this very topic came up. And a couple of the persons who were there was a little back and forth. One person agreed in some measure with the increase in the fines, and others didn't. And I sought to give an example, and I asked them, can anybody here tell me what the speed limit is on Tumpuna Road, which is in my constituency? One gentleman attempted to answer the question, and he was incorrect, Madam Deputy Speaker. The others didn't. We all live in the same constituency. We all use Tumpuna Road on a regular basis. And I was the only person in the room who knew what the speed limit on Tumpuna Road is. And I only recently came to that knowledge, Madam Deputy Speaker, because, again, I was invited to the opening of a credit union now located on Tumpuna Road. And in his presentation, in his remarks, the President asked me if I could have a speed hump put in front of the entrance to the credit union, because as members cross the street to get to the credit union, the speed at which motorists drive on that road, persons could get knocked down. So he asked if I could do that. And I said I could possibly look into it, but I didn't really see the practicality of it. Later on, we were having a discussion, again, and the contractor for the building drew to my attention what the speed limit was by showing me a picture of a faded sign on Lower Tumpuna Road that said 35 kilometers per hour. Madam Deputy Speaker, I am certain the majority of people who use Tumpuna Road don't know that that is the speed limit. And in the absence of more signage, so we took a drive and that's the only sign that I saw. So if you are on higher up Tumpuna Road, probably swing off from the highway and you don't know, you're probably visiting a friend and it's your first time, and you are driving at 50 and you think that is the speed, and the police just happen to have a speed trap.
48-1, this has nothing to do with the bill before the House.
Member, I ask you to move on. We are not debating the speed limits and whether or not people know about the speed limits.
Said, if the citizens aren't aware of the law, if the infrastructure is not in place, and this is the point we are making, what the government should have done first, before increasing these fines and implementing these fines, should have had a more extensive, or at least a more considerate grace period, so that persons could get their house in order. Put the infrastructure in place, because we saw a gentleman got a ticket 4,005 for exceeding the speed limit by 31 kilometers. And this is something that could happen to people, and I'm making that point. If the government doesn't put the infrastructure in place, I'm driving down the highway this morning and looking for signs, and I'm seeing some speed signs hiding behind bush. Hiding behind bush because of well, we know what happened, Madam Deputy Speaker, right? And so therefore persons could find themselves getting a ticket for thousands of dollars through no fault of their own, because they believed that they were within the confines of the law. And they are not, and again, it's because the government is not doing what they're supposed to do with respect to that. So put your infrastructure in place. If you tell us that this is not about revenue collection, you would have given a more generous grace period, as the former administration used to do, in the instances when it came to persons having to go and get their vehicles inspected. And we would have seen, when it was announced that the licensing officers and the police were going to crack down, all of a sudden, all over the country, all of these inspection centers, long lines of cars, causing problems. The licensing office, same situation. And so what took place? The government listened to the people. Never mind the fact they said the last administration didn't. They listened to the people and they said, we'll give you a moratorium. An extra 3 months. Get your house in order. So if at the end of that 3 months, You find yourself in problems, you look for that. And that is what we are saying. We are not necessarily against the fines, even though it's a bit draconian. We are saying certain offenses, drunk driving and so on, take them to the cleaners. Because you're putting people's lives at risk. No problem. But then you all are also, but they maintain the demerit point system for that, but it's a bad thing. They complain that the demerit point system was double jeopardy because you're being made to pay the fine and also you have to incur the demerit points. But Madam Deputy Speaker, the former administration also had things in place for that. Because I could tell you, I have a cousin who found himself in the situation where he would have received a notice that his license was due to be suspended. And in the notice that he received, he was given the opportunity to write and to offer reasons why he thinks he ought not to have his license suspended. And I assisted him in drafting the letter, and he was successful, Madam Deputy Speaker. So to give the impression that once you meet the threshold, that's it, your license is going to be taken, that is not so. There were opportunities. Let us speak about that. So this high-handed approach of the government with these excessive fines, and they said they listen to the citizenry. What the citizenry is saying, you see, for these minor things, these fines are way too high. I'm not going to go down the list because they will accuse me of being repetitious. But clearly you didn't listen to the citizens. You know what they listened to? How did you, and again, I'll ask the question, how did you listen to the citizens? No consultation. You know what they listened to? Facebook. All their former activists who do it lives on a daily basis, cursing the government. Madam Deputy Speaker. Right? How quickly they have turned against the government because of these fines. Madam Deputy Speaker. Madam Deputy Speaker, I can ask Anne Sangri Grandi, please. Please. What boy? Hey. Madam Deputy Speaker, the Minister spoke about uneven discretion on the part of law enforcement as it pertains to the issuance of fixed penalty notices. Permit me to reference another article, Madam Deputy Speaker, entitled Wicked Traffic Cops, dated January 8, 2026. Prime Minister Kamala Prasad Bisesa yesterday said a small minority of wicked law enforcement officers are terrorizing motorists with fines for road traffic offences. As a result, she said her government will go to Parliament to provide a reprieve.
Madam Deputy Speaker, I have to rise on 55(1)B, tedious repetition. The member for Aruko Lopino and the member for Digomata Northeast went through that article extensively.
Yes, member for Malabar Mausika, please move on.
Madam Deputy Speaker, point I wish to make again, and responding to the Minister about the uneven discretion with respect to the exercise of the issuance of tickets, implying that some officers might exercise discretion in a more lenient way than others. All right? Now, if this is such a concern, we saw recently, just in August last year, where the member for Tunapuna would have rewarded officers of the TTPS for issuing some almost 5,000 fixed penalty notices, traffic offenses. Did they do any study to determine if any of these officers were wicked? How many of those 5,000 traffic offenses were legitimate? And how many of those were because of the uneven discretion in the issuance of tickets? But they didn't ask that question. We just rewarded everybody. What message did that send to the wider TTPS, Madam Deputy Speaker? That there is benefit in issuing tickets. Correct. The more you issue, so the government has to take some blame, some responsibility for this uneven discretion. Because you all send the wrong messages to officers. You go outside here, issue tickets, and it could benefit you, Madam Deputy Speaker. Madam Deputy Speaker, permit me to quote, since the ordinary citizen, the average citizen, doesn't have the facility to speak or to air their views directly in this House where it matters. You're correct, member for Chaguanas East. Perhaps you could quote if you speak in the debate. Yeah, I do. That's how we know that you're, anyway. I wouldn't go there.
Madam Deputy Speaker, 55(1)E, F, and G yet again. Madam Speaker, 53(1)E, F, and G yet again.
The member for Malabar Mausika is also engaging in the crosstalk.
Because it's not being protected by the Speaker. Anyway.
Thank you, Madam Deputy Speaker. I shall try to, in the absence of protection, to avoid. Madam Deputy Speaker, permit me to read into the record the position of one member of the public, which to me encapsulates the general feeling of the public with respect to these fines and this stopgap that the government is introducing today, because really the majority of offenses that they've presented in this bill for this new warning system really and truly is inconsequential. You promised relief, you delivered punishment. You cannot stand on a platform, look at citizens in the eye, promise lower fines and driver education, win an election and then turn around and say, now we know better. The people were not misinformed, they were misled. Claiming that the UNC did not have access to data while campaigning raises a serious question. What was
55(1)B, whether he is quoting it from an article or repeating it, he has made this point before and others have made it.
Member, you have quoted almost this exact article. It may be a different article, but the content is the same. I ask you repeatedly, please move on, create a new point. Thank you.
Thank you, Madam Deputy Speaker. Opposition is work, research, scrutiny, preparation, and if after almost a decade you are only now realizing the problem, that is not an excuse. It is a failure of responsibility. Expired permits and a lack of insurance are not new issues. They are
55(1)B, I think the member is disregarding your repeated rulings on this particular matter. Please.
Just for the clarification of all, the member has already spoken about expired driver's license. Member, if you have nothing new to contribute, I would have to ask you to resume your seat. You will have one last chance to continue. If not, please resume your seat.
Thank you, Madam Deputy Speaker. Madam Deputy Speaker, when working people miss a renewal because rent, groceries, and bills come first, that is not lawlessness. It is a reality. And policies must be grounded in reality. Road safety matters, but so does honesty.
Madam Deputy Speaker, I rise on a point of order 55(1)B. You've ruled on this issue already, and he's still reading it again.
Member, you have already spoken about this. I have warned you once, and I will only warn you once. I now ask you to resume your seat. Minister of Transport and Civil Aviation.
Madam Deputy Speaker, as I rise to reply and close, I won't be very long. I would like to first thank my colleagues on this side, Minister Hussein and MP Thomas, for their great contributions. I was looking forward to good contributions from colleagues opposite, but as usual, we got the regular commentary without any substance. Madam Deputy Speaker, I'd just like to reply to a few things that were said by the members opposite. I'll first like to start with the member for Diego Martin Northeast, who is the last person who should talk about road safety. I did not want to bring this up, but the member for Malabar Mausika brought up speed limits. The member who nearly lost his seat A few more maxis and you'd have lost your seat. Madam Deputy Speaker, do you know why the speed limit around the Savannah was increased in 2019? Because they're talking about legal notices. Let's talk about that legal notice in 2019. Do you know why it was increased from 50 kilometers per hour to 65 kilometers per hour? A member on that side got a speeding ticket, and an instruction was then given to increase the speed limit around the Savannah. Right?
48.6, imputing abuse or use of office.
There is, I do not believe any improper motive. The member is just quoting the information he has been given. Please continue, Minister.
Two more stories, Madam Deputy Speaker, that was brought to my attention. That was one. There's two more. A few years ago, the speed limits on the highways of this country was increased to 100 kilometers per hour from 80. The Traffic Management Branch recommended to the government, the then government, to keep it at 80 kilometers on certain segments of the highway. As you know, speed limits are determined by geometry, among many factors. The then government rejected that and increased it to 100 along the entire highway. And they want to talk about road safety. We're going to go further. In July of 2024, a note was submitted to Cabinet to add 2 new devices for breathalyzer and speed. This note was sent to the FNGP committee, where it remained until the most recent general election. When I requested this file at the ministry, it took weeks to find it, like if it was buried. When it was found, I was told that because the election was coming up, they did not want to do it. The speed device, was purchased by the TTPS 1 year ago, and it sat down. 20 devices sat down for 1 year and could not be used because it was not approved. And this speed camera had night flash capabilities. You know how much lives would have been saved if that was being used since 2024? But this government approved those devices. I would like to also just touch on the demerit points. Well, first, before I finish with the member for Diego Martin Northeast, he spoke about licensing authority and the system. Why doesn't he tell us when he collected $400 million in fixed penalty notices in the last 5 years, why didn't he give a couple million to upgrade that system in license office? And we go into the demerit point system. I want to touch on the demerit point system today because I'm very disappointed the Member of Parliament for Aruca Lupino. He was the Director of Legal at the Ministry of Works and Transport. He knows better, but I'm very, very disappointed. During the finance bill, his member for Laventille East Movers spoke close to 45 minutes about the demerit point system, and his colleague did not stand up and correct him. That demerit point system did not work. It was an unfair system, and the stats are here. The demerit point system came into effect, and I don't want to repeat too much of what my colleague said. 2021, 2022, 2023, and 2024, road fatalities increased 2024 by 22%, but in 2025 went down by 10%. Also, tickets issued in the last 5 years went up every single year from 2020 to 2024, which shows that the driver behavior did not change. The demerit point system did not work. Penalized some and not others. And my colleague, member from Malabar, Mausaka, said it. Some people with 300 points on the nation roads, and persons with just 12, 14, and 15 was suspended. I would now like to touch on just a couple other things regarding what's going on in license office. License office is extremely short-staffed. It's short-staffed because nothing was done in the last several years. In 2022, they conducted an interview process, interviewed over 1,400 people. No one was hired. No one was hired. The transport commissioners in this chamber today, no one was hired. But we have met with the Service Commission, and very soon, persons will be employed and will be dispatched to the licensing authority. I don't want to repeat too much again, but Minister Hussein mentioned when he was speaking about the 1 day to transmit the duplicate and affixing the notice to vehicles. That is already in the law. It is here in clause 81.6 and in clause 86.6. It's in the law. We mirror the exact law they did in 2017. It's right here. And I just want to go back on one item. Over the last couple weeks, there was a lot of misinformation in the public domain. That information originated from the opposition directly and indirectly through their trolls on social media. One of the trolls who received, Minister Hussein will correct me, $3 million by a particular ministry to come after us when we was in opposition. And that person actually went after the member for Port of Spain, North St. Anne's West as well. I'm sorry. If I was, I could not have sit so close to the person who probably signed that contract. I would have moved. Madam Deputy Speaker, there's so much I could say here today, but I don't want to be too long. But I want to touch now on, but one thing they said on social media with this misinformation, that I was a member of the PNM that just joined the UNC. I'm a member of this party for 16 years.
Madam Speaker, I'm sorry.
Longer than all of you all in your own party.
48-1, please. What is the relevance of this to this bill, Madam Speaker? 48-1. Who brought that up?
Okay, Minister, let's move on, please.
But, Madam Deputy Speaker, before I go on, the member for Malabar Mauska spoke about broken promises. Your party promised your party you were going to win in Tobago. You promised that. What happened with that promise?
Madam Speaker, 48-1, that has nothing to do with the debates. In all honesty, Madam Deputy Speaker, 48-1, that has nothing to do with the debate today.
It was just a response and a comparison to what the member was saying, but I will ask the Minister of Transport to continue, please. Thank you.
Madam Deputy Speaker, the article was actually April 8th, 2025, not 2024. And the reason why the then minister said that is a general election was just 3 weeks away. That's why he said that. And going back to the misinformation from the Member of Parliament from Lopino, Aruka Lopino, they sat in this house on December 5th when the Honourable Minister of Finance presented the finance bill, and their colleagues in the Senate, the other place on December 9th. The increase in fines for the late renewal is in the finance bill. I won't show it, but it's here in the finance. They didn't read the bill. And they went and told the population there was never a fine, a late fine for late renewals. But why doesn't the former Minister of Finance say that he collected $5 million last year and $9 million the year before for late renewal fines? Why doesn't he say that? But I'll move on, Madam Deputy Speaker. I would like to turn now to something that the member for Port of Spain, North St. Anne's West said. He mentioned, and I'll be wrapping up soon, the member spoke about speaking to one of his constituents who was in pain. I can understand that, member. But what about speaking to a mother who lost a child on the nation's roads? What about that pain, member? Since I have been minister, I have met with numerous families who has lost children, their parents, and I met one person who lost several members of his family in one road accident. So I don't understand the negativity. What we are doing here is to save lives. The only persons who have to worry are those who break the law. This is not a revenue exercise. If this works as intended, the government will collect less. There will be less violations, less accidents. That's what we are doing. And I'd like to also share what we are doing on this side regarding road safety before I close. This government started the National Rehabilitation Program. We started that, launched on August 18, 2025. Thus far, 254 participants with a pass rate of 89%. These are persons who would have been disqualified due to the demerit point system. We expanded the inspection stations framework. Taxis with a tare weight not exceeding 2,270 kilograms can go to any inspection station, and trucks now over 3,200 kilograms could go to VEMCOT. And I know why the member of Aruka Lopino is so angry today, is when he was the director of VEMCOT for all those years, he could have done nothing like this. Nothing at all. I'll go further. VEMCOT restored 52 police vehicles in 3 weeks. 3 weeks. These vehicles were parked up all over the country. One vehicle was parked up for 2 years, took 2 days to fix. One vehicle for 1 year took 1 day to fix. This is all part of what we're doing to improve road safety. When you were the director of VEMCOT, why didn't you do that? Why? We are also working tirelessly to fix PTSE. PTSE was left in a mess. $106 million given out, purchased in parts in 5 years. Madam, he opened the door.
Overruled.
Madam Deputy Speaker, the member opened the door. He mentioned PTSE. I am responding to him. $106 million was purchased in parts in 5 years. Several million to the then minister in the Ministry of Works and Transport. His own company benefited by over $5 million. Let me repeat that. The then minister in the Ministry of Works and Transport company benefited over $5 million in parts. Don't let me call the name of the company. I mentioned it in the other place. I have the documents, member. The minister, there was a minister in the Ministry of Works and Transport, company sells parts. And $5 million in parts was purchased by that company in a few years while he was minister. While he was minister. Yeah, while he was minister. 100 million in security for friends and financiers. But I'll move on. I will move on. We're going to increase the traffic management branch. We're going to increase the traffic warden division. We are working on the red light enforcement. We are working on the secure license plates. Working on the checkered band system. There's so much we are doing to improve road safety in this country. We're working on a park and ride system. There's so much we are doing. And I just want to touch before I close on the great work we're doing on the priority bus route. The road fatalities on the priority bus route went down by 40% in 2025. 40%. We removed close to 1,000 vehicles from the priority bus route. 1,000. The former government gave out over 7,000 PBR permits in less than 5 years at a cost of $2 million. $2 million, over 7,000. If you talk to PTSC or the maxi taxis, they will tell you it's a dream driving on the PBR now. It's a dream. Before it was traffic only congestion with vehicles because they received permits from members on the other side. And I also like to touch on one thing I'd like to touch on the increase in fees of the maxi taxis on the PBR. What they didn't tell you is those increases will not affect the maxi taxis anytime soon. Those maxi taxis renewed in October.
Madam Speaker,
2025.
53-1. I'm trying to hear the debate on the other side.
Yes, continue, member.
The maxi taxis who operate on the bus route renewed their permits in October of 2025 for the entire 2026, over 1,000 operators. The increase by a few dollars a day is not going to be in effect for them until October of this year. But as the misinformation members opposite was spreading in the public domain over the past 2 weeks. But before I close, Madam Deputy Speaker, everything we are doing is to improve road safety. And as we work on new initiatives, I'll be sharing it with the public. Madam Deputy Speaker, I beg to move.
Honourable members, the question is that the bill entitled An Act to Amend the Motor Vehicles and Road Traffic Act, Chapter 4850, for the introduction and implementation of fixed penalty warnings for specific traffic violations in the 9th schedule and related matters be now read a second time. Those in favour say aye. Aye. Any against say no. The ayes have it.
A bill entitled An Act to Amend the Motor Vehicles and Road Traffic Act, Chapter 4850, for the introduction and implementation of fixed penalty warnings for specific traffic violations in the 9th schedule and related matters.
Minister of Transport and Civil Aviation.
Madam Deputy Speaker, in accordance with Standing Order 68-1, I beg to move that the Motor Vehicles and Road Traffic Amendment Bill 2026 be committed to the Committee of the Whole to be considered clause by clause.
Honourable members, the question is that the Finance Bill 2025 be committed to the Committee of the Whole to be considered clause by clause. Those in favour say aye. Aye. Any against say no. I think the ayes have it. This House shall now go into the Committee of the Whole to consider the bill clause by clause.
Clauses 1 to 4.
The question is that clauses 1 to 4 stand part of the bill. The question is that clauses 1 to 4 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clauses 1 to 4 now stands part of the bill.
Clause 5.
The question is that clause 5 stand part of the bill. The question is that clause 5 now stand part of the bill. We have an amendment to clause 5.
Eric, we've taken out licensing authority, which is only open during the week, and we have left Saturday, Sunday, public holidays, Carnival Monday, Tuesday. Police stations are open, of course, all the time.
The question is that clause 5 No? Can we proceed, Chief Whip? The question is that clause 5 be amended as circulated. Those in favor say aye. Any against say no. I think the ayes have it.
Clause 6.
The question is that clause 6 stand part of the bill. Member for Ruka Lupino.
Thank you very much, Madam Chair. To the Attorney General. Attorney General, I'm looking at clause 6, ETA C. Clause 6, 1C, where you have, but A, you have the licensing authority, B, a police officer at any police station, that who can issue a warning, and C, such other person and such other location specified in this, in the fixed penalty warning. The clause obviously is dealing with the fact that the constable shall issue the driver with a fixed penalty warning that offers the driver the opportunity to remedy the traffic violation and to report and produce evidence of the remedying of the traffic violation within the number of days specified in the fixed penalty warning by presenting the vehicle for inspection by a licensing officer, or the licensing authority, I'm sorry, a police officer. And C, such other person and such other location specified in the fixed penalty warning. What other person or location would be empowered in law to provide the inspection?
It is meant to, if you look at ETB4, it's in the Act, my friend. ETB4, the bill, sorry. The person and the location specified under subsection 1D shall be in accordance with the third column of the 11th schedule. Now, if you look at the 11th schedule, you see licensing authority at any of its offices, police officer, and the thinking is that one can add at some point in the future by way of a resolution without parliamentary time.
So is it that C, in the way in which it is constructed, that the intention of the ministry is to authorize some other agency or body other than the licensing authority or police officer to be able to do the same work that is contemplated?
It may be traffic wardens or vehicle inspection sites. And this thing could be done at vehicle inspection sites.
So I'm just, and it's, I understand what I'm saying. So then, and that's it. So I want to suggest, Attorney General, quite respectfully, whether this provision could be a little bit more specific, because I don't want to assume that what is being referred to here is approved inspection station.
Okay. So
understand.
I'm hearing a lot of discussion. I'm speaking to you. I'm speaking to you. You are asking me a question.
I will be coming in.
And this is being in committee stage, and I'm hearing a lot of commentary from Pitt.
Just like you.
Over here.
No, I'm asking.
Well, this is not Pitt, my friend.
Stop being insulting.
Why don't you run?
You are insulting. Stop it.
I'm speaking. You can't tell me to shut up.
I did not say that. I said you're being insulting.
Stop it.
Member for Diego Martin, Northeast, would you like
Chairman, the minister is insulting me.
Would you like to interrupt your
I would
colleague
like to
from Aruka
comment on
Lupino
this.
to make a
I
statement,
would
or would
like
you
to
like him
comment
to finish?
I would like to comment on this.
So who? Aruka Lupino?
No, the Attorney General is responding.
The words are broad enough to allow for. The words are broad enough to allow for subsidiary legislation in the future. And the thinking is that there is no need to constrain the language, the broad language used in the expression in the bill.
Mm-hmm. But because, Attorney General, if you may, approved inspection stations are part of the landscape of motor vehicle enforcement and inspections and what have you, is it damaging? Because we have many inspection stations approved by the licensing authority all over the country. Is it damaging to, in the interest of being clear, that in addition to transport licensing officers, police officers, that approved inspection stations would be able to carry out that function?
Take advice from the experts, and I'll be guided by them. Said no, he prefers the language that is used.
Leave it broad?
Say again?
You want to leave it as broad as this?
Yes, he does. And the government is satisfied with that. Is there anybody else?
Don't be silly. I said I wanted to speak.
Listen.
He said,
Let us please have a productive discussion. A member for Diego Martin, Northeast. Do you have a contribution to make? Do you have a suggestion for the Attorney General?
Thank you, Madam Chairman. The way the thing is worded, without any specificity, it can mean any person, anywhere. For example, it could mean Minister Zakur at his gas station in Diego Martin. This is far too open-ended. Far too open-ended. This is a serious matter. People are going to get warning notices. They are going to be required to remedy the defects. And they are being told they could go anywhere. It is possible in the future that they could go anywhere and be dealt with by any person. And there's no framework for this. It could be anybody, anywhere.
I've taken advice from the expert. My friend from Diego Martin East may be an expert and a jack of all things, but he's a master of none.
Madam Chairman, you are allowing the Attorney General to insult an elected member. Nobody voted for him. You should not allow this.
There are no amendments. Okay. Member for Aruka Lupino.
Question to the Attorney General. Thank you, Madam Chair. Subclause 7. Subclause 7. In the same provision. Where driver or owner of a vehicle complies with a fixed penalty warning, he shall be provided with a certificate of compliance in a form approved by the minister and published in the Gazette. And where the certificate of compliance is issued by a person other than the licensing authority. So who is this person other than the licensing authority that will have the authority to issue this?
Well, at the present time, it would be the police.
Person, and I highly doubt that the technocrats would advise that you would refer to the police as a person. If it is a police, if it is the police having the authority, it needs to be very clear in the law that it is a function and a power to be exercised by the police. But I'm saying, AG, that this is saying, and where the certificate of compliance is a very serious matter. Because if you are not issued with a certificate of compliance, you are found in breach of this law, and automatically a fixed penalty ticket is generated. This provision is saying that where a certificate of compliance is issued by a person other than the licensing authority, who is this person?
Again, I'm sorry. The technocrats have advised that the wording is appropriate, and that is the policy of the government.
Attorney General, I hear what you're saying. Is it that the ministry or the government expects that at some point, apart from the licensing authority, some other body, some other person, if the legislation is saying that, will have the power to issue a certificate of compliance?
Member for Aruka Lopino, the law is always speaking, and we pass law not just for today, but we pass law to take into account circumstances which may develop later on. I'm not sure if, again, the comments, I don't want to say pit, I will not say pit.
You will not say it again in your insulting manner.
From the front.
Are you insulting? That's how it is.
That's your business.
You are insulting.
And so what?
The question is that Clause 6 now stand a part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 6 now stands part of the bill.
Clauses 7 and 8.
The question is that clauses 7 and 8 stand a part of the bill. The question is that clauses 7 and 8 now stand a part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 7 and 8 now stand part of the bill. Honourable members, the question is that the bill as amended be now reported to the House. Those in favour say aye. Aye. Those against say no. No. I think the ayes have it. The bill as amended will now be reported to the House. Aviation.
Madam Deputy Speaker, I wish to report that the Motor Vehicles and Road Traffic Amendment Bill 2026 was considered in the Committee of the Whole and approved with amendments. I now beg to move that the House agree with the committee's report.
Honourable members, the question is that this House agree with the committee's report on the Motor Vehicles and Road Traffic Amendment Bill 2026. Those in favour say aye. Aye. Any against say no. No. I think the ayes have it. Minister of Transport and Civil Aviation.
Madam Deputy Speaker, I beg to move that a bill entitled An Act to Amend the Motor Vehicles and Road Traffic Act, Chapter 4850, for the introduction and implementation of fixed penalty warnings for specific traffic violations in the 9th schedule and related matters, be now read a third time and passed.
Honourable members, the question is that the bill entitled An Act to Amend the Motor Vehicles and Road Traffic Act, Chapter 4850, for the introduction and implementation of fixed penalty warnings for specific traffic violations in the 9th schedule and related matters, be now read a third time and passed. Those in favour say aye. Aye. Any against say no. No. I think the ayes have it. Okay, a division has been called.
Mr. Badarat?
Yes.
Mrs. Prasad-Bissessa?
Yes.
Mr. Tanku?
Yes.
Ms. John?
Yes.
Dr. Munilal?
Yes.
Mr. Lee?
Yes.
Mr. Hussain?
Aye.
Ms. Amin?
Yes.
Mr. Alexander?
Yes.
Mr. Maraj?
Yes.
Ms. Mohit?
Yes.
Mr. Sturge?
Yes.
Dr. Buddle?
Yes.
Dr. Dowlat?
Yes.
Mr. Morris?
Yes.
Ms. Benjamin?
Yes.
Mr. Sobers?
Yes.
Mr. Watts?
Yes.
Dr. Sicharan?
Yes.
Mr. Kesar?
Yes.
Mr. Elder?
Yes.
Mrs. Sam?
Yes.
Mr. Narayan Singh?
Yes.
Dr. Narayan?
Yes.
Dr. Gosain?
Yes.
Mr. Thomas?
Yes.
Mr. Sampson?
Yes.
Mr. Gonzalez? Mrs. Beckles-Robinson? Mr. Imbert? Dr. Gadsby-Dolly?
No.
Mr. Young? Mr. Scotland?
No.
Mr. Dino Brega?
No.
Mr. Manning?
No.
Mr. Marcel?
No.
Mr. Devines?
No.
Mr. Birchwood? Mr. Romain?
Absolutely not.
Madam Deputy Speaker, the results of the division are as follows. 27 members voted for, 11 members. There were no abstentions.
The results of the division are 27 for, 11 against, no abstentions. The bill has been passed.
A bill entitled An Act to Amend the Motor Vehicles and Road Traffic Act, Chapter 4850, for the introduction and implementation of fixed penalty warnings for specific traffic violations in the 9th schedule and related matters.
Honourable Prime Minister.
Thank you all very much. Thank you.
Madam Deputy Speaker, I beg to move that a bill entitled An Act to Amend the Tobago House of Assembly Act, Chapter 2503, be now read a second time. Thank you, Madam Deputy Speaker. It is 8:36 p.m. and we've done very well. Congratulations on the passing of your bill with respect to giving people warnings. I hope nobody leaving the Parliament tonight will get a fixed penalty notice
On the other side.
from on the other side, because they don't feel if they get a chance or get a warning in order to comply with the law. So, thank you again, Madam Speaker.
We have more plans for you. More plans.
I rise to pilot this very important piece of legislation to bring amendments to the THA Act. Before I get to the clauses of the bill, the actual substance, I take a moment again to congratulate Chief Secretary Farley, Augustine, Tobago People's Party, on the historic clean sweep in Monday's THA elections, obliterating those on the other side and their party in Tobago. The people of Tobago have spoken with clarity, they've spoken with conviction, they've spoken with unity. It was clear that the anchor held in Tobago. Several of us were very pleased to join our brothers and sisters in Tobago yesterday to witness the swearing inaugural ceremony, as Tobago has now moved into a new chapter of leadership and governance. And we want to say clearly, without ambiguity, my government respects Tobago's choice, my government respects Tobago's mandate, and my government is committed to working with Tobago, the THA House Assembly, in a spirit of maturity and cooperation. This bill is an extension, Madam Deputy Speaker, of our deliberate and consistent approach that we have taken towards Tobago since we assumed office in April 2025. It reflects the seriousness with which we regard Tobago's development, Tobago's governance, and Tobago's future. This government does not treat Tobago as an afterthought. We do not approach Tobago only at election time. We respect Tobago's autonomy and the right to equal treatment. We will work with Tobago because we see Tobago as integral to our nation's prosperity, stability, and future. And Madam Speaker, Deputy Speaker, from the time we began this term in office in 2025, we made a clear commitment that Tobago would not be managed through tokenism, will not be managed through occasional engagement, but will be managed through a structured partnership grounded in respect, equality, and delivery. And you know why? Because we firmly believe that Tobago's progress demands more than expressions of goodwill. We believe that Tobago's progress requires sustained national investment, real policy commitments, and strong institutions that are capable of executing responsibilities efficiently, transparently, and of course, credibility. And that is why I take a moment to remind this House that on Tuesday, 4th November, some of us traveled to Tobago, and I delivered my first official address to the THA since that victory at the April 2025 election. And I did so a very special sitting in Scarborough at the THA. That visit was not ceremonial. It was grounded in partnership, institutional respect, and practical delivery. In that historic THA address, I made Tobago's position and Tobago's rights clear. We firmly believe, and I still do, that Tobago's development must be advanced through practical measures which strengthen self-determination, which improve service delivery, and which ensures Tobago receives a fair and sustainable share of national development. We committed to a relationship with Tobago built on respect and equality, and I stated that we must move beyond narrow population share debates toward a more just and transparent approach grounded in fairness and project-based development. Because you see, Madam Deputy Speaker, Tobago is not a footnote to national development. Tobago is a partner in the national development of Tobago and Trinidad, and Tobago. Madam Deputy Speaker, I did not simply speak. We did not just go to speak. We began by delivering. At that very sitting, I presented Chief Secretary Farley with an export license for Studley Park Enterprises Limited. Thereby enabling Tobago to market aggregate regionally and to strengthen its economic prospects, whilst unlocking practical opportunities for trade, investment, and local industry. That is how Tobago builds capacity. That is how Tobago strengthens its revenue potential. That is how Tobago develops not only through support, but through the ability to generate economic activity and expand opportunities for the people of Tobago. And so, Madam Deputy Speaker, Tobago's advancement cannot rest on single announcements or one-off measures. And that's why I have this bill today. Tobago's development requires consistent national support, reinforced year after year in the allocation of resources, in the structuring of programs, and the strength of institutions starts with delivery. And that is why my government ensures Tobago's financial position in the national budget was clear, serious, and substantial. And we want to thank our Honourable Minister of Finance. For fiscal 25 to 26, my government allocation to Tobago's, the overall allocation was approximately 3.724 billion, which is described as the highest in Tobago's history, representing 6.3% of the national budget, when expenditure by ministries and agencies is also taken into account. Within the national framework, the published budget summaries for 25-26 show that the THA itself received an allocation of $2.943 million, million or billion, $2.943 billion. I place those figures on the record deliberately because they demonstrate an essential truth. Tobago's development under my government is not based on sentiment. It is based on resources. It is based on investment. And it is based on delivery. Madam Deputy, I also address the practical development needs that affect the daily lives of Tobagonians, because development must be felt, not just measured on paper. I raise housing and reference restarting the Riseland housing project at Canby, because again, Tobago's development must be visible where it matters most, in families, in communities, and of course, in the dignity and security of home. At that time, I reaffirmed the commitment to advance a special needs center for Tobago, building on the National Enrichment Center model developed during my earlier tenure, because Tobago's children and families must never be left behind. I have tasked Mr. Vandana Mohit to assist us in getting this project done. Madam Deputy Speaker, I begin here deliberately because today's bill must be understood in that same social framework of partnership and delivery. When we speak of Tobago's progress, Tobago's governance, Tobago's autonomy trajectory, we must ensure that the institutions in Tobago are strong, modern, and fit for purpose. Tobago cannot deliver modern responsibilities through outdated institutional structures. So we begin with this bill for the structures in Tobago. Tobago cannot meet the expectation of its people if the legal architecture governing its executive and parliamentary functions is misaligned with its current membership, workload, and growing mandate. That is actually exactly what this bill attempts to do. Can you just move this one, please? What this bill attempts to do. This bill strengthens Tobago's administrative capacity by allowing greater portfolio specialization, having clearer divisions of responsibility, and more proportionate executive participation through an expanded number of secretaries who are equivalent of ministers. The bill seeks to ensure that the Executive Council can properly distribute workload, build expertise across critical development sectors, and provide stronger oversight in the delivery of services to the people of Tobago. Further, the bill attempts to strengthen Tobago's democratic legitimacy by increasing the quorum for conducting business, ensuring that Tobago's decisions are taken with clearer majority participation, stronger representative legitimacy, and a higher standard of democratic accountability. This is what a serious partnership, Madam Deputy Speaker, with Tobago looks like. It is delivery in resources, it is delivery in priorities, it is delivery in governance, and it is through institutional reforms to strengthen Tobago's democratic machinery and deepen Tobago's capacity to manage its own development with credibility, accountability, and effectiveness. These are the aims and objectives behind this bill today. This is but a start as we move to work with Tobago for greater self-autonomy by the people of Tobago in keeping with the mandate that was given to the people, by the people, and for the people of Tobago. So this is not the end. This is about the beginning for that autonomy for Tobago that has long been promised. It is delivery through institutional reforms to strengthen Tobago's democracy machinery and to deepen Tobago's capacity to manage its own development with credibility, accountability, and effectiveness. Madam Deputy Speaker, the bill is a very simple one. It seeks to make several amendments to the existing THA Act. First, it attempts to increase the number of secretaries in the THA Executive Council. Initially, we had proposed from 7 to 11 members. However, given the large mandate that the electorate gave to this present THA, we are proposing that the Act be amended to allow for secretaries without number, without limiting them to either to 7 or to 11. That will be in the discretion of the Chief Secretary and the THA in consultation with the President of the Republic of Trinidad and Tobago. And further, we are looking at increasing the quorum for THA sittings. Given the 20 members are sitting there now, the quorum of 9 would not be representative of a democracy to have 9 persons out of a 20-member legislature making decisions for that legislature and for the people. So we want to increase that quorum from 9 members, AG, to 12 members at this time for the quorum. These changes strengthen Tobago's administration, enhances democratic legitimacy in decision-making. And I would like to say that we propose 2 further amendments, which will be circulated shortly, AG. Can you have them circulated? When we met with the THA yesterday and the Chief Secretary, the Honorable Farley Augustine, there were many women sitting on the council. They had been elected and then others appointed as councillors. And they raised the question as to why they are called assemblymen. Now, I fully understand in law that the male refers to the female, but they were very strong, given the amount of females who have been elected and nominated, that we should move an amendment to change the word from assemblymen, because maybe in those days there were only men used to sit in political chambers, but now there are many. We have 2 female leaders right here in this house, and so we are seated. I want to make it clear, we fully understand in our law, male includes female by definition. But I think in keeping with the way the world has moved and the rise of women in the world in leadership positions, we should accede to their requests. And so we are moving an amendment further to wherever the word assemblyman occurs, it will be assembly member or assembly members. So wherever you find assemblyman, we will amend that. So the quorum to increase and the change with respect to changing the definition of the word assemblyman in the act itself. I move along, Madam Deputy. In 2021, you recall changes took place with respect to the composition of the THA, the legislature of the THA. 2021, Parliament amended the THA framework to expand the configuration of assembly from 17 to 20 members and to increase the number of elected assemblymen from 12 to 15. What that reform did was to expand representation in Tobago. The representation alone is not enough. That's what we're here today, to make sure that the representation is indeed proportionate and in balance. If Tobago's assembly is expanded, then Tobago's executive capacity and procedural safeguards must be expanded as well, so that Tobago's governance functions with discipline, fairness, and effectiveness. So this bill amends the Act. Clause 3 amends Section 33(1)(c) to increase other secretaries. Initially, we had proposed from 7 to 11. Our amendment, which we moved by the AG at the committee stage, would tell us that we will amend that section to just say that the secretaries will be appointed by the Chief Secretary in notice to the President for appointment. This is what happens with a government. As we come in as senators and MPs, the Prime Minister will recommend X, Y, P, and Q to be ministers, but there is no limit. And so we are not limited the number of persons who can serve as secretaries on the Executive Council of the THA, given now that there are 20 such persons sitting in the legislature. So we want to amend other secretaries, as I say, close it there. Initially, we were looking from 7 to 11. We are not doing that after further discussions and thought about it. We want to give the Chief Secretary and his team the authority to recommend as many of the assemblymen and assembly persons now to sit in the Executive Council. Further, Clause 4 amends Section 68 to increase the quorum from 9 to 12 members. What happens in the current situation, when we look at what is the composition of that legislature, Section 33 provides for an Executive Council. That will have the Chief Secretary, the Deputy Chief Secretary, and other secretaries appointed by the President acting in accordance with the advice of the Chief Secretary. This is the amendment we are now proposing. And the bill, as I say, will increase the quorum. Why are we doing this? We are looking at proportional executive balance, Mr. Speaker, Madam Deputy Speaker. The Assembly now has 20 members. Under the current chapter, only 7 plus the Chief Sec and Deputy Chief Sec can serve in the Executive Council. What that means, in effect, is only about 45% of the Assembly can serve within the executive leadership structure. Only 45%. That cannot be right. So the plan is to increase the number of secretaries, to restore a proportionate balance, and modernize the governance architecture in line with Tobago's expanded institutional mandate, so that we will have proportional executive balance. Further, the Chief Secretary and his team have discussed with us the need for more specialized portfolios, so there will be better delivery through focus. The THA administers wide and various responsibilities. Under the 5th schedule, there are 33 areas of responsibility, including state land, sport, agriculture, industrial development. As I say, about 33 areas of responsibility. But in the existing law, only 7 secretaries to be given portfolios. It means that those 7 persons will become overburdened, they will be overloaded and fragmented, and we are saying no. We must increase the number of secretaries to be at the discretion of the Chief Secretary in consultation with advice to the President of the Republic. So if we increase the number of secretaries, there will be clearer divisions of responsibilities. There will be more expert leadership within each sector, and there will be more consistent delivery to Tobagonians. Further, we will recall that the 2021 reforms to the law sought to improve representation and avert deadlocks. That is when we had the deadlock, where the THA was deadlocked, equal numbers, 6-6. And so the 2021 reforms, which increased the numbers, were supposed to improve representation and avert deadlocks. This 2026 bill strengthens Tobago's capacity to meet the demands of modern governance and expectations. So let's look at it. The Assembly has engaged in streamlining and internal realignment. No cap on the number of secretaries will provide the structural flexibility required for future transformation without coming back to the Parliament. Every time you have to make one structural change, you need to come back to the Parliament to dot an I and cross a T. So discussion was had in consultations, as I say, with the newly elected THA membership to do not cap the number of secretaries, i.e. the equivalent of ministers, not to cap it. So if they have their 20 members, the executive can only be chosen from the elected assembly persons, and those elected persons can be made administratively secretaries. We move on. Consistency with Tobago's autonomy direction. Tobago's long-standing aspirations for deeper self-governance require stronger systems. Increasing the limit, as I say, without a cap, will bring broader constitutional goals for a more robust entity capable of managing increased responsibilities. Quorum now, I move to that change we are making to the quorum. That is not a technical detail. Quorum is a minimum safeguard of democratic legitimacy. Under the current Act, quorum is 9 members. 9 out of 20 members. It means 9 persons alone can sit down and take a decision that will lock down all 20 members of the legislative chamber. Under the current law, as I say, that quorum is 9. In a 20-member assembly, 9 out of 20 means only a 45% of the membership can take final binding decisions for the entire membership of the THA. It means that business can lawfully proceed while more than half of their representatives are absent. More than half are absent, and decisions can be taken if we leave that quorum at 9. That is not the standard of democratic legitimacy that Tobago deserves. So what we want to do here in this bill is to raise the quorum to 12 members. The 12 of the 20 represent 60% of the Assembly. 60%, and therefore decisions are not taken by a narrow minority. Proceedings will reflect clear majority representation, and the institution's legitimacy is thereby challenged. Strengthened. The practical risk under the current quorum of 9 out of 20 is this. Tobago has 15 elected assemblymen, as I said, 4 appointed councillors. What that means, if we leave it at this number now, a quorum of 9 could allow a small faction to dominate proceedings if others are absent. A small quorum of 9. When we raise the quorum to 12, that will prevent distortion and will strengthen the integrity of Tobago's democratic process and democratic traditions. Madam Deputy Speaker, then we say, the people of Tobago, just like the people of Trinidad, deserve responsive administration, competent oversight, and decisions taken with proper participation and legitimacy. It is my respectful view that this bill strengthens Tobago's ability to deliver services more effectively and transparently. Deputy Speaker, whenever a Parliament considers a bill which strengthens institutions and modernizes governance, it is expected that questions will arise and there will be criticism advanced. That is part of the democratic debate. But Madam Deputy Speaker, It is also a duty in this House to respond to questions with clarity, logic, and facts. Some may suggest that this bill is merely adding more positions or expanding political space. Madam Deputy Speaker, that is not a serious reading of what is before us. Tobago's Assembly was expanded in 2021. The elected membership increased. The structure of the Assembly changed. The workload of governance expanded. It is therefore sound, responsible governance that the executive structure keeps pace with the institution it is meant to serve. This reform is about workload distribution, portfolio specialization, and delivery to the people of Tobago. It is not about optics. It is not about ensuring that the machinery is well oiled, but it's putting the structure in place, a proper structure to manage the responsibilities entrusted to it. Others may ask, why now? The answer is simple. Tobago cannot be expected to govern modern responsibilities without dated statutory limits. Tobago cannot operate an expanded assembly and a growing mandate while executive capacity remains restricted by a cap design for an earlier configuration. This bill modernizes Tobago's governance in light with the post-2021 reality and ensures that the legal framework matches the current structure and the practical needs of administration. Madam Deputy, some may ask that by increasing the quorum could slow down business or create inconvenience. But Madam, democracy is not supposed to be convenient for small groups. The purpose of a quorum is not administrative comfort. The purpose of a quorum is legitimacy. And Tobago's Assembly must not conduct its business in circumstances where decisions can be made without meaningful participation from Tobago's representatives. 12 members is not an excessive number. It ensures that Tobago's business proceeds with proper representation, clear majority presence, and the democratic credibility that the people of Tobago deserve. These reforms, Madam Deputy, are reasonable, they are balanced, and they are grounded in the basic principle that strong institutions deliver better outcomes. And this bill strengthens Tobago's governance, not for political theatre, but for the practical purpose of improving administration, enhancing representation, ensuring decisions are taken with legitimacy and participation that democratic governance requires. As I close, Madam Deputy Speaker, this bill is modest in drafting, but meaningful in impact. As I say, the best is yet to come. We only just begun in terms of reforming the position of Trinidad vis-a-vis Tobago and Tobago along with Trinidad. This will strengthen the THS executive capacity to deliver, strengthen the Assembly's legitimacy through a more representative quorum, and will modernize Tobago's governance in keeping with the post-21 institutional reality. It reflects government's commitment to practical reforms and improved service delivery to the people of Tobago. I support this bill wholeheartedly and commend it to this Honourable House. And I want to repeat the comment, this is not the end of our policies and programs to get towards Tobago. This is but the beginning towards putting it into our laws a better constitutional structure for Tobago and Trinidad and Tobago. I thank you and I beg to move.
Thank you, Honourable Prime Minister. Honourable, propose the question for debate. The question is that a bill entitled An Act to Amend the Tobago House of Assembly Act, Chapter 2503, be now read a second time. Arima.
Thank you. Thank you very much, Madam Deputy Speaker. As I join this debate on the Tobago House of Assembly Amendment Bill 2026, Madam Deputy Speaker, this bill is being debated following the swearing in of the Executive Council yesterday, which I had the opportunity, together with the Prime Minister and other members of Cabinet, to attend the swearing-in ceremony. Madam Deputy Speaker, and I would just say at the outset that the bill as amended would be supported by us on this side. I am hearing some of my colleagues on the other side saying that we have no choice. But I want to say to my colleagues opposite and share with you that when I was asked yesterday in Tobago and before I attended Parliament by the media, I made it abundantly clear, and that is before the amendment was brought, that the original bill was quite different from what our People's National Movement proposed. And actually, what is being proposed now, and I will read and share what was submitted at the time and indicate that it's actually the same. Madam Deputy Speaker, let me just say that the 2020 bill, when we proposed the amendment, and that amendment was to Chapter 11 of the Constitution, providing that the Chief Secretary would have the discretion to appoint any number of secretaries. Once they were members of the Tobago House of Assembly, and it stated that the Chief Secretary would have the sole discretion to choose secretaries from among the elected members of the Tobago House of Assembly. That is some 6 years ago. The proposed amendment, and if I can just read so we would be clear what the People's National Movement proposed at the time. And at that time, the then opposition, UNC, voted against it. And that was the Constitution Amendment Tobago Self-Government Bill 2020. And I quote, "The Tobago Executive Council provided for in Section 75(1)(a) shall consist of a Chief Secretary, a Deputy Chief Secretary, and such number of secretaries, one of whom shall be a Secretary of Legal Affairs, who shall be an attorney at law, admitted to practice in Trinidad and Tobago, appointed in accordance with the advice of the Chief Secretary from among the members of the House of Assembly, as the President acting in accordance with that advice." In that instance, Madam Deputy Speaker, it would have been prudent to note that the PNM had already set up the precedent. The intention was to create an executive authority for Tobago through an empowered Tobago Executive Council. And this, in my view, would have been the approach adopted in bringing this bill before the House today. Madam Deputy Speaker, Section 75(a) said there shall be a Tobago Executive Council which shall have the general direction and control of the Tobago Island government and shall be collectively responsible, therefore, to the Tobago legislature. And it proposed that, as then proposed, constitutionally created a Tobago Executive Council with general direction and control of the Tobago Island government. So, Madam Deputy Speaker, I just want to make it clear that the section at the time in that bill, in essence, does exactly what is being proposed now as amended, to give to the Chief Secretary basically a discretion to appoint secretaries as he sees fit. So there's really no difference from that bill that was submitted some 6 years ago. And as I indicated in my press conference before, that the section as rejected at the time is really what is here now. I just want to say that the Honorable Prime Minister mentioned in her comments that in 2025, her government indicated that they made a very clear commitment as it relates to Tobago and their national development. And let me say that in our proposal for that autonomy bill, that would have been one of the many sections, but we were always very clear in our mind that that was the only direction that the Tobago Council should go. And further to that, I would like to say that in arriving at that particular section, it would have been after months and months of consultations with the people of Tobago, and that is how we arrived at that particular section. We, therefore, are very conscious of the importance of the development of Tobago. We are very conscious that the people of Tobago have requested that, and that issue of autonomy has been being discussed for years. And when we arrived and we brought that bill before the Parliament, it would have been after years and years of work and years of submission and consultation, and based on the request of the people of Tobago. I also want to make the point, because the Prime Minister shared with the Parliament and this Honourable House several of projects and programs that her government intends to do for Tobago. And I just want to say that at that time, the former Minister of Public Utilities, and if I could just mention a few projects, because whilst the government can now speak of their intentions and their commitment, I will say that the People's National Movement has always been committed to Tobago. It is fair to say that Tobago may not have received everything that Tobago wanted, but we know that in consultations and discussions that we on this side can say that we are proud of the commitment we have had to Tobago, of the projects, of the many programs that has been completed under the People's National Movement. And if I could just, with your leave, Madam Deputy Speaker, make reference of a few of those projects and programs. And I want to recognize the work that was done by my colleague at that time, the Honorable Minister of Public Utilities at the time. Two very, very important projects, being the Southwest Tobago Wastewater Project and the Hillsborough Dam, which I'm sure our projects will continue, because one impacting, of course, on the issue of wastewater, and the other impacting on ensuring a reliable supply of water to the people of Tobago. Madam Deputy Speaker, as I said, I just ask your leave just to make reference to a few projects that I think is very important. Notably, that of the acquisition of the Cove Estate, which has been one of the most significant projects over the years done for the people of Tobago. The acquisition of the Cove Estate and its establishment of an eco-industrial hub for economic diversification, the landing of a 1 billion natural gas pipeline and natural gas processing facilities in collaboration with the National Gas Company, the construction of a dual-powered electricity generation plant at Cove, and the designation of the Cove an eco-industrial estate. And I can go on talking about several projects, but I know that what we are specifically doing today is to ensure that there is proper management and functioning of the Tobago House of Assembly. That is really what it is. And therefore, in dealing with the issue of the discretion to the Chief Secretary, also in dealing with the issue of ensuring that there is a quorum. And Madam Deputy Speaker, you would recall, because you were in the Parliament at the time, when there was a shifting of the boundaries that would have affected this particular election that took place a couple days ago, last week to be exact, Monday. And some time ago, the changing of the boundaries from the increasing of the number of seats from 12 to 15 as a result of what was a 6-6 outcome a couple of years ago. And at that time, there was not the change of the quorum. So therefore, in bringing the legislation to deal with the quorum, that is in truth and in fact absolutely necessary. And as I indicated, we therefore support the quorum as well as we support the giving of the discretion to the Chief Secretary, bearing in mind that that particular recommendation in particular was one that was submitted in our autonomy bill. Madam Deputy Speaker, the Honorable Prime Minister also made reference to the whole issue of responsibilities of the various secretaries. And I saw this morning in the newspapers the Chief Secretary indicating about the appointment of an attorney. And as I said, that when I gave the amendment, when I gave the particular provision of the bill, in that bill, that was also catered for by us. Madam Deputy Speaker, we all recognize that once you have increase in the number of secretaries, of course, it is also going to be a financial cost, and as well the increase in number of persons now to be employed in the THA. And therefore, I think it is important for us to all discuss and acknowledge that whilst we recognize the increase in the secretaries, then at some point in time, we expect that all the necessary expenditure that will result as a result of the changes of this piece of legislation will also, at some point in time, be brought to the Parliament for our information. Madam Deputy Speaker, the other issue, of course, is the increase at some point in time in what we would say is contract labor. And the reason why I raise the issue of contract labor, it is because we do remember that there has always been the debate of contract labor versus the whole issue of security of tenure. So it may be that the person who is speaking next, I'm not sure if anybody else is speaking, or if the Prime Minister may be wrapping up, if that is a matter that will be addressed. Madam Deputy Speaker, therefore, in concluding, I am saying that this bill presents an opportunity, and it's really about governance. It's really about strengthening of governance. It is really about ensuring that the people of Tobago are aware that these matters that would have been in the public domain, that may have been concerns, that is exactly what this is doing. I would also say, Madam Deputy Speaker, that whilst this is one aspect of the whole issue of autonomy that is being brought before this Honourable House, I would just like to make it clear that when the autonomy bill was brought by the People's National Movement, it would have addressed a multiplicity of issues, and the issue of the additional secretaries would just have been one. Right? And therefore, I want to say to the people of Tobago, who are no doubt listening, and especially the members of the council, assemblymen, or I think the Prime Minister say assembly members in terms, let me make sure I get it correct, and yeah, assembly members. And if I could just comment on that, I mean, it is a matter that is becoming very topical in the world because there are so many countries where you have increased participation of women in politics. Originally, in almost all pieces of legislation that we have had from time to time, we know that his includes hers. So it is a matter that I also support. The issue of ensuring that as we make pieces of legislation that we are very conscious of the increased participation of women in politics. So all in all, the three issues really would be the issue of the quorum, the issue of the discretion of the Chief Secretary, and of course changing the definition to ensure that you deal with the concerns raised by the several female councillors, which is the issue of assembly members. Madam Deputy Speaker, I would like to close by saying that we will continue to insist that the issue of autonomy for Tobago, and when I say autonomy, I mean not just these issues, but the multiplicity of other issues that exist, that this is an urgent matter that should be brought before the House within a reasonable time. This government clearly has the right to have their own perspective as it relates to that. We brought ours. They did not support it. We await their legislation. We await what they have to put forward as it relates to Tobago so that we can give it the consideration it deserves. My colleague mentioned a while ago, and I have said it, that we are prepared to support legislation, good legislation. We are willing to, where we are approached, to give serious consideration in terms of consultation, because as it relates to Tobago, this is a matter that I believe that requires consultation and an effort to ensure that whatever comes to this House, at the end of the day, the people of Tobago are satisfied that both as government and opposition, that we have considered about putting Tobago first. I thank you.
Member for Tobago West.
Madam Deputy Speaker, permit me to enter this debate with thanksgiving for the blessings of the Christmas season, the New Year, and the consecration of a 15-0 election victory for the Farley Chavez Agustin-led Tobago People's Party at the recently concluded Tobago House of Assembly elections held on January the 12th, 2026. But before I go on further, I want to address a couple of things mentioned by the member. And she stated that Tobago has always been on the agenda. And I'm wondering why they're on that side here and why the 15 demerit points they received on Monday permanently disregarding their political license in Tobago. Why are they seated on that side? But it just goes to show that Tobagonians wanted blue ones and not pennies. I rise today in support of the bill before this Honourable House, and in particular, the amendment proposed by the Honourable Prime Minister to remove a fixed statutory limit on the number of secretaries that may be appointed by the Chief Secretary, the increase in the quorum in the Assembly Legislature, and the renaming of assemblymen to assembly members is welcome. This goes to show the progressive move made by the collaboration between all parties involved to ensure that the good governance signaled by the election in Tobago is supported. Madam Deputy Speaker, this is not a partisan issue, but a mathematical one. It requires the increase in the quorum that constitutes the Executive Council to ensure that the decisions made are numerically represented. It stems from both the increase in the number of seats in the Tobago House of Assembly's electoral map and the situation in which the Tobago People's Party has earned all 15 seats. Before addressing that amendment directly, it is important to place this debate in its proper historical and developmental context. Madam Deputy Speaker, the last time this Parliament amended the law to adjust the structure of the Executive Council of the Tobago House of Assembly was Act number 17 of 2006, passed in September 2006, 19 years ago. 19 years ago, Tobago was a very different place. Tobago now is headed in the direction of becoming the greatest little island on the planet. Since then, Tobago has grown. Our budgetary allocation has grown thanks to this government of the day. Our population has grown. The demands on the Tobago House of Assembly have grown. The scale and complexity of service delivery have grown. Even the number of members of the Assembly itself has grown following the 2021 amendments. Even the color has changed from red to blue. Yet until today, Madam Speaker, the executive framework governing Tobago remained anchored to assumptions made nearly 2 decades ago. Madam Speaker, Madam Deputy Speaker, the amendment now before us recognizes a simple but powerful truth. Governance should be driven by function, not by arithmetic, frozen in statute. The Tobago House of Assembly is responsible for 33 areas of responsibility under the 5th schedule of Act 40 of 1996. Those responsibilities are not static. They expand, contract, and evolve based on economic conditions, development priorities, population needs, and national policy direction. A fixed numerical cap on secretaries assumes that Tobago's governance challenges can be permanently solved with a single number. Experience has shown that this is not the case. Removing the cap allows the Chief Secretary to configure the Executive Council based on operational reality, not legislative rigidity. Madam Deputy Speaker, to appreciate why this flexibility is necessary, one need only examine how Tobago divisions operate in practice. In seeking to cover all 33 areas of responsibility, many divisions of the Tobago House of Assembly function as the equivalent of multiple ministries in Trinidad. For example, the Division of Settlements, Public Utilities, and Rural Development carries responsibilities equivalent to approximately 3 ministries. The Division of Tourism, Culture, Antiquities, and Transportation combines functions that will normally be handled by 3 separate ministries. The Division of Food Security, Natural Resources, the Environment, and Sustainable Development mirrors the remit of 3 ministries. The Division of Infrastructure, Quarries, and Urban Development reflects the workload of 2 to 3 ministries. The Division of Education, Research, and Technology similarly spans 2 to 3 ministerial portfolios. The Division of Community Development, Youth Development, and Sport often functions as 2 ministries, and at times even 3. The Division of Health, Wellness, and Social Protection carries responsibilities equivalent to 3 ministries. The Division of Finance, Trade, and Economy performs the work of 2 ministries, while the Office of the Chief Secretary itself coordinates responsibilities comparable to as many as 5 ministries. Madam Speaker, Deputy Speaker, this is the lived administrative reality of Tobago. Removing a fixed cap allows the executive to be structured in a way that responds to this reality, promotes clearer lines of responsibility, and strengthens accountability. Madam Deputy Speaker, it is important to emphasize that flexibility does not mean absence of accountability. The Chief Secretary remains accountable to the Tobago House of Assembly,
the budgetary and appropriation process, parliamentary scrutiny, and ultimately the people of Tobago. Any decision to create, expand, or realign executive portfolios must still be justified through policy outcomes, financial discipline, and democratic oversight. The safeguard lies not in arbitrary numerical ceiling, but in the strength of Tobago's institutions and the vigilance of this Parliament. Madam Deputy Speaker, the amendment also reflects institutional maturity. Rather than requiring Parliament to revisit the same structural question every time Tobago's responsibilities evolve, this approach creates a future-ready framework. It allows the Executive Council to adapt as Tobago grows, without repeated legislative amendments, simply to change numbers. That is why the autonomy for Tobago is so important to us. This is consistent with modern practices of devolved governance and aligns Tobago's statutory framework with the realities of an island exercising increasing administrative responsibility. Madam Deputy Speaker, the amendment before us is therefore not an expansion for its own sake. It is a recognition that Tobago's governance must be allowed to evolve in step with Tobago's development. I thank the government for bringing this amendment to the Parliament. I thank the Chief Secretary for his insight and astute leadership. I thank the opposition for its support. The law was last adjusted in 2006. Tobago in 2026 is not Tobago in 2006. For these reasons, Madam Deputy Speaker, I support the bill as amended and commend it to this Honourable House. I thank you.
Honourable Prime Minister. Sorry.
He didn't get up? Nobody.
Thank you, Madam Deputy Speaker.
There we go.
This person that catches the eye of the speaker. I did not see you. I looked around, I did not see you.
Thank you, Madam Deputy Speaker. At 9:34 a.m., I thank the Honourable Prime Minister, the Honourable Opposition Leader. Madam Deputy Speaker.
Madam Prime Minister, you may continue.
Thank you very much. Thank you very much. I thank the Honourable Opposition Leader for her support for provisions of the bill, and I do agree that some of these issues were raised previously. Mention of when it was brought by the former PNM government, it was rejected here. I brought it when I was Prime Minister, it was rejected here. So it happened to all of us, and I'm very happy for your collaborative approach today. Let's hope as the rest of it come, the bigger issues come, we can work it out together for the benefit of Tobago. So I thank you very much, and I beg to move.
Honourable members, the question is that a bill entitled An Act to Amend the Tobago House of Assembly Act, Chapter 2503, be now read a second time. Those in favour say aye. Aye. Any against say no. I think the ayes have it.
To amend the Tobago House of Assembly Act, Chapter 2503.
Honourable Prime Minister.
Thank you, Deputy. I beg to move that the bill be committed to the Committee of the Whole of the House, please.
Honourable members, the question is that the Tobago House of Assembly Amendment Bill 2026 to be committed to the Committee of the Whole to be considered clause by clause. Those in favour say aye. Aye. Those against say no. I think the ayes have it. This House shall now go into the Committee of the Whole to consider the bill clause by clause.
Clauses 1 and 2.
The question is that clauses 1 and 2 stand a part of the bill. The question is that clauses 1 and 2 now stand a part of the bill. Those in favor say aye. Aye. Any against say no. I think the ayes have it. Clauses 1 and 2 now stand a part of the bill.
Clause 3.
The question is that clause 3 stand part of the bill.
There's an amendment, ma'am.
Yes, Attorney General.
As circulated, it's self-explanatory. It's been spoken to by the mover of the bill, the Honorable Prime Minister, and I believe it's been agreed to and claimed by the minister, by the member for Arima.
The question is that clause 3 be amended as circulated. Those in favor say aye. Aye. Any against say no. I think the ayes have it. Honourable members, the question is that clause 3 as amended now stand a part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 3 as amended now stands part of the bill.
Clause 4.
The question is that clause 4 stand part of the bill.
Again, ma'am, there's an amendment. It's been circulated. Self-explanatory.
The question is that clause 4. The question is that clause 4 be amended as circulated. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Honourable members, the question is that clause 4 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 4 as amended now stands part of the bill.
New clause 4, section 33 amended.
question is that new clause 4 be read a second time. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The clause will now be read a second time.
New clause 4, section 33 amended.
The question is that new clause 4 be added to the bill. Those in favor say aye. Aye. Any against say no. I think the ayes have it. The question is that new clause 4 now stand part of the bill. Those in favor say aye.
Aye. Now you say that the question is that new clause 4 stand part of the bill.
The question is that new clause 4 stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. New clause 4 now stands part of the bill.
New clause 6, act amended.
The question is that new clause 6 be read a second time. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The clause will now be read a second time.
New clause 6, act amended. The question is that new clause 6 stand part of the bill.
The question is that new clause 6 now stand part of the bill.
And you just wait if there are any comments. Okay, now you go here.
The question is that new clause 6 stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The new clause 6 now stands part of the bill.
Let me just go straight to the conclusion.
Honourable members, the question is that the bill amended now be reported to the House. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The bill as amended will now be reported to the House. Honourable Prime Minister.
I wish to report that the bill amending the THA Act was considered in committee and amendments were made as the bill was considered close by course. I beg to move it be read third time or second? Third time and pass. No? Second? I'm just reporting from the committee. Right. I beg to move that the House do agree with the committee's report. Thank you.
Honourable members, the question is that this House agree with the committee's report on the Tobago House of Assembly Amendment Bill 2026. Those in favour say aye. Aye. Any against say no. I think the ayes have it. Honourable Prime Minister.
I beg to move that the bill be now read a third time and passed.
Honourable members, the question is that a bill entitled An Act to Amend the Tobago House of Assembly Act, Chapter 2503, be now read a third time and passed. Those in favour say aye. Aye. Any against say no. A division has been called.
Mr. Padarat?
Yes.
Mrs. Prasad-Bissessar?
Yes.
Mr. Tanku?
Yes.
Ms. John?
Yes.
Dr. Munilal?
Yes.
Mr. Lee?
Yes.
Mr. Hussain?
Aye.
Ms. Amin?
Yes.
Mr. Alexander?
Yes.
Mr. Maraj?
Yes.
Ms. Mohit?
Yes.
Mr. Sturge?
Yes.
Dr. Bodo?
Yes.
Dr. Dowlat?
Yes.
Mr. Morris?
Yes.
Ms. Benjamin?
Yes.
Mr. Sobers?
Yes.
Mr. Watts?
Yes.
Dr. Sicharan?
Yes.
Mr. Kesar?
Yes.
Mr. Elder?
Yes.
Mrs. Sam,
Yes.
Mr. Narayan Singh,
Yes.
Dr. Rup Narayan,
Yes.
Dr. Gosain,
Yes.
Mr. Thomas,
Yes.
Mr. Sampson,
Yes.
Mr. Gonzalez, Mrs. Beckles Robinson,
Yes.
Mr. Imbert,
Yes.
Dr. Gatsby Dolly,
Yes.
Mr. Young,
Yes.
Mr. Scotland,
Aye.
Mr. Dana Brager,
Aye.
Mr. Manning,
Yes.
Mr. Marcel,
Yes.
Mr. Devine,
Yes.
Mr. Romain,
Yes.
Members, the result of the division is that 38 members voted for, no members voted against, and there were no abstention. The bill has passed.
an act to amend the Tobago House of Assembly Act, Chapter 2503.
Honorable Attorney General.
Madam Deputy Speaker, I beg to move that a bill entitled An Act to Provide for Special Measures for Upholding and Preserving the Rule of Law, Public Order, Citizen Security, and Public Safety within certain geographically defined areas of Trinidad and Tobago and for other related matters be now read a second time. Madam Deputy Speaker, the bill before this House tonight has as its backdrop the declaration of a state of public emergency by Her Excellency the President in July of 2025. At that time, the President, acting on the advice of the government, declared that a state of public emergency existed in Trinidad and Tobago. That advice came as a direct result of intelligence gathered by the Trinidad and Tobago Police Service of an imminent existential threat to the state, to state actors, and to assets of the state. The threat emanated from within the prison walls and, as previously discussed, was a result of collusion and collaboration among gang leaders within the prison system, their affiliates and gang members within the society, to persons who held office and to property in the society at large. The state of emergency was extended twice by this House. It is expected to come to an end in 2 weeks, that is to say, at the end of January 2026. It is the government's position and that of the majority of the population that the state of emergency was effective not just at dismantling that threat, but also at frontally attacking criminal gang organizations and their activities throughout the length and breadth of Trinidad and Tobago. The Trinidad and Tobago Police Service and the Defense Force, along with effective intelligence gathering and utilization by our security services, have significantly reduced the number of murders, robberies, kidnappings, and heinous crimes by some 42% in most categories during the year. On the 31st of December 2025, the Honorable Prime Minister stated as follows. She said, "I promised that my government would act decisively to reduce crime, and we have delivered on that commitment. As indicated," she said then, "by midnight, our national murder rate will be down by 42%, the largest decline in our nation's history, and one of the most significant drops globally this year." She paid tribute to the efforts of the TTPS for their relentless work, discipline, and determination, which she said had been critical in lowering both the murder rate and serious crime across Trinidad and Tobago. She concluded by saying, "Our fight continues. Our country deserves safety. It deserves stability and peace, and we are making it happen." Madam Deputy Speaker, the fight against crime does continue. Strategic operations by the TTPS and Defense Force have provided critical insight to us into the operations, funding, locations, bases, identities, and affiliates of the gangs who have been running amok in this country unchecked for some 10 years. Consequently, law enforcement has been able to virtually pinpoint the operation bases of various gangs and to more fully understand their patterns and movements. It is no secret that many communities across Trinidad and Tobago have been plagued by criminal activity for many years, with gangs headquartered in and operating in hotspots. Gun violence, bloody murders, reprisal killings, extortion, and induction of young men into gangs are the order of the day. Most of us would never even venture into the areas which are known as hotspots. Too many communities in Trinidad and Tobago bear the scars of intergenerational trauma, systemic poverty, and vicious cycles of broken homes and lost children. Those law-abiding citizens who are seeking a better, honest life do so at their own risk and face the stigmas in broader society of coming from this place or that place. But we say, Madam Deputy Speaker, that these are our people. They are our citizens. They are our constituents, and that they have been overlooked for far too long. My colleagues opposite talk glibly about crime plans and the absence of a crime plan. They sat there and did nothing virtually nothing for 10 long years, allowing this country to descend into bloodbaths, seeing our grandmothers, our friends, our daughters, our colleagues brutally raped and murdered and not lifting a finger. We have brought the incidence of violent crime down to their lowest levels in a decade. And we have done so within less than 9 months of taking office. Madam Deputy Speaker, we are not going back. There are many who see everything in this society from a lens of color and race and would predictably attempt to bring that and those matters into this debate. I would like to ask them today to try looking at things from the perspective of what is actually taking place. They speak for themselves. The numbers do not lie. And you know what else cannot lie? The fact that every single digit, every single number, every drop by 1% in these statistics refers to a life. Many lives, many human beings, all citizens of this country, mothers, fathers, friends, children, grandparents, people that each and every one of us in this chamber know. Madam Deputy Speaker, there are legislative precedents for what we seek to do tonight. And there is, in this part of the world, a legislative precedent in the Commonwealth Caribbean. The Law Reform Commission would have studied and considered similar legislation, and they fastened on the Jamaica model. The bill is based on the Law Reform Zones of Special Operations Measures Act 2017 of Jamaica. And that piece of legislation has been seen by many as a valid and effective constitutional tool in the fight against crime, especially serious crime. Now, if you look at the premise of the bill that is before the House tonight, it seeks to balance the need for security operations to address serious crimes within defined communities. Now, it balances that concern with the rights of our citizens. It aims to preserve fundamental rights and freedoms of persons residing in those communities. Most significantly, the bill also takes into account the need for social intervention and community development. It contemplates measures which can turn at-risk communities around to preserve public order and to promote the rule of law. Members would have noticed that parts 2, 3, and 4 of the bill provide for enhanced security and enforcement measures. That's achieved by proposing the establishment of zones of special operations in a specified geographic area. Part 5 of the bill proposes a community development aspect. The schedule to the bill establishes the structure of a social transformation committee tasked with treating with the conditions which facilitate the breeding and perpetuation of crime in the affected areas. I wish to make it clear, the bill does not seek to marginalize the citizens of any community in Trinidad and Tobago. That is not and will never be the intention of this government. It is instead a demonstration of our recognition of these communities as deserving of better. The bill is a design solution aimed at cleaning up crime in at-risk communities on the one hand, while addressing their specific socioeconomic problems that have been ignored and allowed to fester under the last administration and for the past decade. The government, through this bill, seeks to bring an end to entrenched cycles of violence sustained by poverty, despair, and poor environmental conditions. Persons in these communities will be given a chance to be a part of the changes we seek to implement by providing opportunities for them to engage with the government, civil society, and members of the community at large. I should like to turn now to a clause-by-clause analysis of the bill. The bill has 28 clauses. Yes, I know. It's late at night.
And we don't want to do much questions.
A lot of my colleagues are exhausted.
No. Not on this side. Not on this side.
And I know at least one person on the other side who might be having a particularly difficult night. I don't want him to have a particularly difficult night. I'm trying to get him home to bed at a decent time. Part 1 contains clauses 1 to 5 and provides for preliminary matters in the bill. Part 2, 6 to 9, for the establishment of zones of special operations. 6 empowers the Prime Minister to make an order to declare an area a zone when there are reasonable grounds to believe that A, there is rampant criminality, such as murder, gang warfare, or high or escalating violence, or B, the rule of law and public order is under threat. An order made must clearly define the boundaries of the zone. A zone cannot cover the entire country. For that, there will have to be a state of emergency. The order will state the period for which it will operate. It cannot exceed 180 days in duration. Clause 7 allows the Prime Minister, in council and after consultation with the Commissioner of Police and the Chief of Defence Staff, to amend the boundaries or duration of a zone. The duration of a zone may be extended in increments of up to 180 days. An order made under this section is subject to affirmative resolution of the Parliament. The Parliament has a say. It is similar to the legislation in Jamaica. Not identical, similar to the legislation in Jamaica. Clause 8 requires the Prime Minister or the Minister responsible for national security to present a statement to Parliament within 14 days after a zone is declared. 9 allows the Prime Minister in Council to revoke a zone at any time, either on her own motion or B, based on the recommendation from the Commissioner of Police and his Chief of Defence Staff. Part 3 contains clauses 10 to 13 and provides for the administration of special operations within a zone. Clause 10 provides that the Prime Minister can create a joint command comprising 2 senior officers, one each from the police service and the defense force, to be jointly in charge of operations within the zone. The members of the joint force must have specialized training in human rights, use of force, and community development. Clause 11 imposes a duty on the Joint Command to submit a written report to the National Security Council every 30 days while a zone is active. Clause 12 provides the Prime Minister with the power to A, suspend operations within a declared zone on her own motion or on the recommendation of the Commissioner of Police and the Chief of Defense Staff, or change the members of the Joint Command under certain circumstances. The clause ensures that decisions to pause operations are informed by senior security officials with direct operational knowledge, and also provides flexibility to respond to emergent circumstances or unforeseen risk. Clause 13 requires the Commissioner of Police and the CDS, with the approval of the NSC, the National Security Council, to establish a method for identifying each member of the joint force operating within a zone. Part 4 contains clauses 14 to 24 and provides the powers of a joint force in a zone. 14 empowers the Joint Command and senior security officials to control movement within a declared zone through cordons and the imposition of curfews. Once established, a notice must be published and displayed in conspicuous locations to inform residents and those seeking entry that they are going into a zone. The notice would state, for example, the hours during which persons must remain in premises, the hours of the curfew, the boundaries of a cordon, etc. Breach of the notice would be a summary offense. Members of the joint force enforcing cordons or curfews will have the powers of a constable. Clause 14 ensures the security forces can control access and movement in zones to maintain public order, while providing formal notice, enforcement powers, and penalties for non-compliance. Clause 15 provides that the duration of cordons would be no longer than 24 hours and a curfew no more than 72 hours. Clause 16 empowers members of the joint force to conduct searches of places, vehicles, or persons within a zone without a warrant, provided there is reasonable suspicion that an offense is being, has been, or is about to be committed. The member in charge of search must, as far as reasonably possible, ensure the presence of the owner, occupier, or person in possession, or their agent during the search. Further, those persons present should be allowed to observe the search. It should be noted that female persons must be searched by female officers. Officers may seize vehicles, articles, or documents that could prevent or control public disorder or aid in criminal investigations. This clause provides for specified items to be protected from seizure, including tools of trade or business and materials subject to legal professional privilege. A list of all seized items must be compiled and as a consequence, receipts must be given to the owner, person in possession, or their agent as soon as possible. This clause balances the need for effective law enforcement in zones with procedural safeguards to protect property rights, legal privileges, and transparency. Clause 17 governs the custody, storage, disposal, and return of vehicles, articles, or documents seized under Clause 16. Under Clause 17, seized items must be secured in a location approved by an officer designated by the Joint Command while investigations, examinations, or legal proceedings are ongoing. Perishable items may be disposed of in a manner approved by the designated officer. In circumstances where a designated officer believes a seized item is no longer needed for controlling public disorder or as evidence, it must be returned to the owner, possessor, or their agent with a receipt signed. This clause ensures accountability, proper handling, and a legal mechanism for the return of seized property. Clause 18 provides the procedures and safeguards for arresting or detaining individuals within a zone and sets out grounds for arrest or detention, together with standard criminal procedures which will be applicable when an arrest is made. The arrested person must be brought promptly before a magistrate, who will determine whether the arrest or detention is justified. It is different from a state of emergency. There is no emergency tribunal. The ordinary processes of the law kick in on arrest. Where a magistrate determines that detention is necessary in the interest of justice, the magistrate may A, remand the person in custody for up to 48 hours, or B, require that after 48 hours, the person be brought before a high court judge for further proceedings. The person must be taken to a prison or police station immediately with the event recorded in the station diary. If the magistrate is not satisfied that detention is justified, the person must be released immediately. The power of arrest and detention also extend to persons fleeing the zone, because such persons would be treated as if they were still operating within the zone at the time of arrest. This clause ensures that arrests and detentions in a zone are based on reasonable grounds, subject to judicial oversight, and documented for accountability. Clause 19 seeks to create summary offenses against the joint command or joint force, such as to threaten, assault, obstruct, or hinder any member of the command or force or anyone in performing duties under the Act. Clause 20 establishes oversight and safeguards for individuals held in custody where a person has been in custody for 36 hours without a magistrate's order. The officer in charge must inform a senior officer not below the rank of assistant superintendent and must record this fact in the station diary. The senior officer must investigate the circumstances and ensure the person is immediately brought before a magistrate. This ensures timely judicial oversight for anyone detained beyond 36 hours. Clause 21 sets out the rights and protections for individuals arrested or detained in a zone. For example, all complaints by or concerning a detained person must be recorded in the station diary. A detainee may receive visits as permitted by the prescribed officer. A detainee is entitled to receive food, clothing, and other items necessary for health and welfare and medical attention. Clause 21 emphasizes accountability, respect for human rights, and access to essential support for detained individuals. Clause 22 provides for the use of body-worn cameras by the joint force during operations in zones. Under this clause, protocols and procedures to govern the use of body-worn cameras may be developed to cover A, when cameras can be used, B, who can access the recorded data and under what circumstances, C, how the data may be used, D, rules for activating or deactivating cameras, E, instances where members must inform the public about the recording, and F, documentation of time and reason for deactivating cameras. This clause ensures accountability, transparency, and the regulated use of recording devices during operations in zones. Clause 23 provides for the registration of weapons assigned to members of the joint force to be registered with the Trinidad and Tobago Forensic Science Center before operations in a zone, unless the Chief of Defense Staff or Commissioner of Police decide otherwise. This clause will promote accountability and traceability of weapons used in operations. Clause 24, which is the last clause in Part 4, provides that joint force members may require anyone in a zone whose identity is unknown to provide their full name and address if there are reasonable grounds to suspect the person's involvement in an offense or to aid in the investigation of an offense. It is a summary offense to fail to comply with such a request unless the person has a reasonable excuse. This clause ensures that the joint force can verify identities to support law enforcement and investigations within a zone. Part 5 is the last part of the legislation. It contains clauses 25 through 28. Those clauses establish the Social Transformation Committee. Clause 25 provides that the Prime Minister must establish a Social Transformation Committee within 5 working days after a zone is declared. Further, the rules governing the committee are set out in the schedule to the bill. 26 sets out the functions of the committee, such as to assess conditions in the zone, identify threats to sustainable development, create a comprehensive development plan covering areas such as health, environment, social and infrastructural improvement, education, and economic development. The committee is required to pay particular attention to vulnerable persons in the zone. Clauses 27 and 28 are the general provisions. 27 confers a regulatory making power to the minister responsible for national security. In our case, that will be the minister who has portfolio responsibility for Homeland Security. Clause 28 provides for parliamentary review and oversight of the Act. There's a schedule to the legislation. The schedule sets out the constitution of the Social Transformation Committee. It also outlines the process of appointment of members of the committee, including the chair and deputy chair, and establishes procedural rules in relation to the internal operations, management, and meetings of the committee. Now, I am well aware that this legislation is groundbreaking legislation in Trinidad and Tobago. As I say, it is legislation that has been attempted with resounding success on the ground in Jamaica. My colleague, the Minister of Homeland Security, will give some statistics which reveal that homicides have essentially dropped off the cliff, woundings, serious woundings, and violent crime have dropped off the cliff in Jamaica. There are constitutional issues, and I wish to touch that now. The government is well aware of the impact this bill has on our constitutional rights and freedoms. This is evident by our insertion into the bill of the constitutional preamble, the clause expressing the bill's inconsistency with the Constitution and the parliamentary certificate. But it is a well-established principle that our Constitution is interpreted following a broad and purposive approach. There are several cases. In A.G. and Whiteman, 1991, the Privy Council said that the language of our Constitution falls to be construed not in a narrow and legalistic way, but broadly, so as to give effect to its spirit, and this is particularly true of those provisions which are concerned with the protection of human rights. In Suraj and the Attorney General, the Privy Council held that constitutional rights have all an inherent limitation, and such limitation can be exercised where the public interest so requires. We think that the public interest requires a limitation on the traditional rights, given the realities which face us in this country. Importantly, Mr. Speaker, in Suraj, by a unanimous decision, the Privy Council reasoned that the fundamental rights, including the right to life, the right to free movement, and the like, can be infringed by ordinary or subsidiary legislation without the requirement of a special majority vote, once the legislation satisfies a proportionality test. This judgment further bolsters the earlier decision of the Privy Council in Surat and the Attorney General, in which Baroness Hale famously said that it cannot be the case that every act of Parliament which impinges in any way upon the rights protected in sections 4 and 5, of which these are rights protected in 4 and 5, of the Constitution is for that reason alone unconstitutional. Legislation frequently affects rights such as freedom of thought and expression and the enjoyment of property. These are qualified rights which may be limited either by general legislation or, in the particular case, provided that the limitation pursues a legitimate aim and is proportionate to it. And then she says these words: it is for Parliament in the first instance to strike the balance between individual rights and the general interest. We think that it is a matter for this Parliament to strike the rights between the individuals to live in a manner which is free from gang warfare, which threatens to envelop all of us, and the rights protected by sections 4 and 5. Now, there is a case in the local court of appeal, Naidiki versus Attorney General of Trinidad and Tobago, which concerns the unlawful detention and deprivation of liberty without due process. Now, in his judgment, Mr. Justice of Appeal Jamada, as he then was, he's now in the Caribbean Court of Justice, said these words. He said, "In my opinion, the liberty of the person, which is really their freedom, is one of the most essential of the fundamental rights. It is therefore no accident that protection of liberty is the first right that is recognized and declared under Section 4A of the Constitution. Deprivation of liberty without due process is therefore one of the most serious of constitutional violations. The court emphasized that any detention of a person must be reasonable, proportionate, and subject to judicial oversight, and that any arbitrary or indefinite detention will be in breach of Section 4A of the Constitution." And then he went on to say that for the reasons stated above, I say that an arrest or detention under this bill will be reasonable, proportionate, and subject to judicial oversight. That is him saying that or me saying that. The point that I wish to make is that we have sought to subject all of the powers which we have granted to the police and army in this new dispensation to judicial oversight. There are limits on the amount of time that they can hold a prisoner for. When they hold a prisoner, they must carry that prisoner to a magistrate, and thereafter to a judge. We say that those...
Honorable Attorney General, you have 4 more minutes, okay?
Sure. We say that those are proportionate measures and that they are justifiable in a society that has a proper respect for the rule of law, when faced in particular with the nature of the threat that we face. The government acknowledges, Madam President, that the bill breaches the freedom of movement guaranteed under 4(9) of the Constitution, and clause 14 of the Constitution clause 14 of the bill empowers a joint command to establish a cordon around or in a zone that is a breach of the Section 49 right. But we say that that is proportionate and an appropriate measure to treat with the difficulties which we now face as a society. At its core, this bill is committed to safeguarding the right to life of every citizen. In doing so, the bill seeks to reinforce the authority of the state in all communities and to prevent criminals from regaining the influence which they had a short year and some ago. Therefore, the purpose of the bill is to restore public order through enhanced security measures while simultaneously addressing the root causes of crime through community development. Madam President, the proliferation of crime in Trinidad and Tobago in the past, and in the past decade in particular, demand immediate legislative intervention to adequately address and combat the flagrant acts committed by offenders against law-abiding citizens. There is no singular approach to this problem which we face as a society. In order to effectively and expeditiously deal with this multi-layered and complex issue, the government introduces this piece of legislation as one of the tools to deal with the issues that give rise to serious crime in our communities. The bill is not intended to be a quick, conventional, or reactive measure to crime. It is a comprehensive tool that enables a coordinated strategy aimed at reducing crime while protecting lives. The government took office with a number one priority. That priority was to protect the lives of our citizens. We say that this bill is a measure that does that. It is designed to protect and to enhance the quality of life in our most vulnerable communities. Its purpose is not to stigmatize these areas, but to strengthen engagement, to build confidence between citizens and the state. Beyond the benefits to communities, this legislative initiative is envisioned to also contribute to the improvement of procedures and protocols within the security forces. All law-abiding citizens are encouraged to support the security forces, to embrace this initiative, and to embrace their roles as stakeholders in the new dawn which we see in this country. Madam Deputy Speaker, with these words, I beg to move.
Thank you, Honorable Attorney General. Honorable members, I shall now propose the question for debate. The question is that a bill entitled An Act to Provide for Special Measures for Upholding and Preserving the Rule of Law, Public Order, Citizen Security, and Public Safety within certain geographically defined areas in Trinidad and Tobago and for other related matters be now read a second time. Members, the time is now 10:36 p.m. We will take a break for 10 minutes, so we will resume at 10:47 p.m. Member for Port-au-Prince South.
Thank you, Madam Deputy Speaker. Madam Deputy Speaker, we are not here to bring color and race into this debate. We are here to bring reality to Trinidad and Tobago. And from the submissions made by the Honorable Attorney General, it seems that the reality is that this government really doesn't know how to govern Trinidad and Tobago. I wish to caution this House against replacing one extraordinary security measure with another under a different name, but with similar dire consequences. And through this bill, not only does this government seek to curtail the right of the freedom of movement, what about the right of enjoyment of property? What about the right to due process? All these are rights that we say will be affected by this legislation if it is passed in its current form. And Honorable Attorney General, for your information, in Jamaica, the Court of Appeal, in the case of Dayton Campbell and the Attorney General, did not hold that the provisions of the special zones were constitutional. In fact, it held the opposite. It held that these provisions were unconstitutional. And that is something maybe you ought to take into account as you approach the implementation or the presentation of this bill to this Parliament. As we end a state of emergency on January the 31st, 2026, Madam Deputy Speaker, timing is everything. We are told that this government is now considering zones of special operation, modeled after the Jamaican experience. This demands scrutiny. Why now? The first state of emergency, if we do an analysis, was proclaimed by this government in July 2025, and it was based on an alleged prison-based criminal network threatening national security. Subsequently, on 2 further extensions in July and in October, carrying us to the end of January 2026, it was said to this Parliament that the law enforcement agencies requested the extension so they can continue their work. What now is the reason for this sibling of another state of emergency to continue not just for 3 months, but for 180 days in the first instance, with a further extension for another 180 days? Throughout this period that we existed under, law enforcement was granted exceptional powers for extended searches, arrest, detention without any constitutional safeguards. The government acknowledged ad nauseum that the state of emergency was never intended to be a long-term crime plan. That is on the Hansard, but a temporary response to intelligence that was gathered. What has happened to that now? That is a crucial point, Madam Deputy Speaker, because zones of special operations risk becoming permanent extension style of state of emergencies. That is exactly what it is. Long after the initial legal emergency has extinguished. The Honorable Minister of Homeland Security, the Honorable Attorney General, has boasted about a 42% reduce in homicide in 2025. What they didn't tell us is that 3 out of those months was a state of emergency under a People's National Movement government, which started that trend. It didn't happen from April. To be honest, it happened because the People's National Movement instituted policies, real policies, that led to that reduction that they are now laying claim to. And that is something that we wish to put on record. But here is the real question. Here's the real question. Do we preserve those gains? Let us give them credit for all the gains. Take credit. June to April in 2025 never existed. How do we preserve those gains mentioned by the Honorable Attorney General? By normalizing exceptional powers? Or is it not by strengthening ordinary law enforcement within the rule of law? On this side, we say strengthening ordinary law enforcement within the rule of law and not normalizing exceptional powers to make it now the reality of life in Trinidad and Tobago. Zones of special operations come with serious, far-reaching concerns and consequences. Firstly, there's the issue of civil liberties. Zones of special operations by design permit heightened police and military presence, expanded stop and search powers, curfews, restriction of movements within designated communities. And here is the thing about Trinidad and Tobago and its communities as opposed to Jamaica. The reality of Trinidad and Tobago is that in our communities, criminal activities intertwined in same spaces where there are law-abiding citizens. How does the law-abiding citizen who will be cordoned off in those areas avoid the stigma, avoid the harsh, dire consequences when they have done nothing wrong? Is that proportionate legislation, Madam Deputy Speaker? It means then, and this is our submission, that law-abiding citizens already who live in marginalized and stigmatized areas will now live under perpetual collective suspicion. That is what is being created. And the prejudicial effect of this legislation far outweighs any probative value that it may bring to this government. Is it now, Madam Deputy Speaker, knowing that crime is ubiquitous, that we will all live in zones of special operations? Is that what is going to happen? And are we all going to be living under collective suspicion? The proposed legislation runs the risk of eroding trust between the law-abiding citizens and the very institutions that were created to protect them. That is something that has escaped the submissions of the Honorable Attorney General. Secondly, there's the danger of mission creep, overkill, and wanton disregard of the fundamental constitutional rights of a law-abiding citizen. When the state of emergency was reintroduced in July, and it morphed in October based on the requests for an extension by the law enforcement agencies, we were told and we expected in Trinidad and Tobago something different, that this phase will come to an end. We will have a chance to breathe constitutionally. But that expectation, obviously, is short-lived. Now, even before this current state of emergency expires, we are debating a new framework that preserves many of the most intrusive features of a state of emergency, without strict time limits, without parliamentary oversight, and without any clear exit strategies. These zones of special operations can quietly become mini-states of states of emergencies. Mini-states of states of emergencies. A rose by any other name is still a rose. So said the indomitable Endel Thomas. A rose, a state of emergency by any other name, is a state of emergency. What about my third submission, Madam Deputy Speaker? of unequal application and inequality. Zones, and these zones are never declared in perceived affluent neighborhoods, That's a reality. Never. And we have to grapple with that, Madam Deputy Speaker. They are imposed on specific communities, often poor, young, and already over-policed areas. It raises a profound question about equality before the law and the social consequences of stigmatizing areas as these hotspots. And we have history to be our teacher in this regard. Madam Deputy Speaker, do you recall in 2011, there was a state of emergency declared by a UNC government led by the Honorable Kamla Prasad-Bisasa? And there were particular areas identified as hotspots throughout this country. Let me refresh your recollection as to the areas that were so designated in 2011. Of the cities and boroughs, the city of Port of Spain, the city of San Fernando, the borough of Arima, the borough of Chaguanas. Of the regional corporations, they signaled and they took out two: the Diego Martin Regional Corporation, San Juan Lavantel Regional Corporation. The specific areas identified as hotspots were as follows: Arima, Aruca, Caranage, Beetham, Diego Martin, Enterprise, Grand Couver, Hermitage, Icacus, Lavantil, Maloney, Trin City, Morvan, Sealots, Pigeon Point. Madam Deputy Speaker, what is the common denominator in most of these areas that were signaled and singled out in 2011? Can you do the math? I would let the population do the conclusion on its own. But these were the areas. Is it now that history is going to be repeated without just cause? Let us see. Time will tell. But we have the areas that were singled out as hotspots in 2011. And today, and it was done by this government. Let us see what areas will be singled out as special zones under this incarnation. Many of our citizens, many of the constituents who I have the honor to represent, already have to cope with stigmatization and the unfair effect pinned to their neighborhoods. They cannot obtain employment just because of where they were born. They have to get scholarships that individuals and people who are they practice philanthropy in order for them to go and obtain education at other institutions, higher institutions that are not covered by, of course, the PNM government tried its best. We couldn't pay for everything. They face challenges of obtaining assistance from financial and other institutions just because they happen to live in a certain area. That is the reality of Trinidad and Tobago, and no amount of mollycoddling could erase that fact. What is to become of those persons now when their areas will be designated zones of special interest? Fourthly, we must confront the actual international evidence of the Jamaica experience, because in Jamaica, the experience was not all positive. It was not all rosy. In Jamaica, the zones of special operations produced short-term reductions in violent crime and gang activity. But Jamaican civil society organizations, legal advocates, and even parliamentary committees raised concerns in the following way. They complained of prolonged military deployment in civilian spaces. Does that sound familiar, Madam Deputy Speaker? Reports of abuse and excessive force used by the Defense Forces apparatus. Weak mechanisms for civil oversight and limited long-term socio-economic transformation once the zones were lifted. But more importantly, the courts in Jamaica raised concerns, and in the case of Dayton Campbell versus the Attorney General, the citation is 2025 JMFC Full Court number 2, a full court of the Court of Appeal in Jamaica in a landmark ruling in May 2025. The Constitutional Court of Jamaica declared that the government's repeated and extended use of states of emergency as a routine crime-fighting tool between 2018 and 2023 was unconstitutional. Let me repeat this, Madam Deputy Speaker. In the Dayton Campbell ruling, contrary to what was espoused by the Honorable Attorney General, the Jamaican Court of Appeal, dealing particularly with the Constitution of Jamaica, held that repeated and extended use of states of emergency as a routine crime-fighting tool between 2018 and 2023 was unconstitutional. The court went on and found that this practice breached the doctrine of the separation of powers by allowing the executive to bypass necessary parliamentary approval for extensions, thereby usurping legislative authority. The courts clarified and held, and it is now the law, the common law has now been codified, that a state of emergency is an extraordinary measure for an existential threat to the state and not a response to crime. And not a response to crime. I cite this case for the legal propositions and the learning that it provides as we do this debate and discuss this very serious issue. In several Jamaican communities, crime displacement occurred. Violence just moved from one area to another rather than disappeared. And in Trinidad and Tobago, Madam Deputy Speaker, if you go on Facebook and all these other social media platforms, the putrid comments that are coming now on these platforms, PNM cockroaches moving from one area to the next, man, you will close your phone. It is creating more divisiveness in a society that is already on edge. It is creating more division in a society that in itself does not need further division. And we cannot bury our heads in the sand and say that all is well in the state of Trinidad and Tobago, because all is not well. Just for 1 minute, the bill has not been passed as yet. And these are the comments coming. People are saying now that they will use stand your ground. And before you even come, they're dealing with you. Those are the comments. I couldn't believe it. Is this government going to hide and bury its head in the sand and not acknowledge that this legislation may do more harm than good? And more importantly, in Jamaica, there was a heavy investment in social programs. This government is not heavy in investing in social programs, you know. In fact, they're the opposite. They are the opposite. And another distinction between Trinidad and Tobago and Jamaica is this. In Trinidad and Tobago, we are merely 1,980 square miles. In Jamaica, there are 4,400. We have a population of maybe 1.4 million, Jamaica's population is 2.8, 2.9 million. It's a bigger place where you can have these zones because you do not have criminals and law-abiding citizens literally living in the same communities. In Jamaica, there are particular communities which you know, not side by side. And that is a distinction that has not been taken into account. If there is legislation, on this side, we say it ought to be tailored to be in consonance with the socio-economic, geographical, and historical reality that is Trinidad and Tobago. This legislation is not it. In fact, it represents, in our view here, the epitome of counterintuitiveness, counterproductiveness, lazy and incompetent governance, which is bereft of any capacity to grapple with the uniqueness and the metaphysical subtleties that is crime in Trinidad and Tobago. It's a lazy piece of legislation. Here is why I say this, Madam Deputy Speaker. And you know what? They try now to hoodwink us. In local parlance, Madam Deputy Speaker, it's called Mama Guy. And let me take you to the Mama Guy. Let's go to the bill itself, Madam Deputy Speaker. On the one hand, this government seeks to have the powers to declare particular parts of Trinidad and Tobago zones of special operation and give the Honorable Prime Minister the powers, and by extension the state, sweeping powers. And the rationale will be, of course, that the people who reside in those special zones are criminal and are intent on committing criminal activity. Okay? Here is the disconnect. Here is the Mama Guy. Here's the fly in the ointment. More so, they seek to tell this country that Clause 5, and they actually put the clause, Clause 5, F, and G, seeks to, the objects of the Act. Clause 5, Madam Deputy Speaker, take a look at Clause 5. To facilitate the redirection of young persons out of criminal activity. That's Clause 5, yes? And Clause G, to promote social and economic development in a zone through the efforts of various government agencies and civil society. So they want to promote economic development. Here how they're promoting to facilitate the youth. They cut 45 million in the funding for youth sector activity. They reduced provisions for contract across the ministries responsible for education, tertiary training, and youth development. No allocations for the agencies such as the National Training Agency, YTEP, or MIC. How are the young persons supposed to redirect their energies out of criminal activity when the government doing that? But let's look at G. G takes the cake to promote social and economic development in these zones. Here they're promoting social and economic development. 336 CPEP contractors go home. 15,000 workers who live in those zones go home. 35,000 URP workers go home. Every person who great-grandfather, uncle, cousin resembles somebody who look like a PNM, they fire them as a CEO. And you hear that? Every person who great-grandfather, uncle, cousin look like a PNM, they check your DNA. They check your DNA and they fire you. Yet they say, Madam Deputy Speaker, to promote social and economic development from Hilaire, the central bank, right down. Everybody fired. Once you look and you smell like your great-grandfather had a cousin who looked like a PNM, who attended church and school with you. That is what they bring here. And they say they want to promote. And here's what they do. Just to make the Mama Guy full, just to bring it to full fruition, they create committees. But here what the committee has, I checked it. They have A to X. It fall in her gut. When you throw a stone, only the pig that gets lashed does ball. Madam Deputy Speaker, look at this. They create a committee. In the committee, if you check the legislation, the members go up to X. When I did X in the alphabet, I think X takes you to about 20. All right, 2022, right? So look at this. The committee for each zone will have about 22 people on it, A to X. What that committee going and do, Madam Deputy Speaker? When the roll call finished, the meeting done, that's an hour just to call the roll. What they're going to tell them? Not to rehire the people who you fired, that you must train young people to be gainfully employed under YTEP or under MIC? What is that committee to tell them, Madam Deputy Speaker, other than that? They want to do that. So my point is, come clean. Tell us. You're targeting us. You don't care about we. Tell us that. Tell us that. But don't mama guy us with the committee established under Section 23 and Object F and G. That is what it is. Object F and G of the Act. I have just shown you how counterintuitive and how insincere that is by the examples I've given you of the actions of the government and their words. Now, so, it seems to my mind, Madam Deputy Speaker, that this government, incapacitated by a bankruptcy of ideas, have just brought now a sibling to a state of emergency and has presented as a plan that will attack crime. In other words, they never had a plan for the reduction of criminal activity in Trinidad and Tobago in the first place. Let me be clear. The objection on this side is not that we must do nothing, you know. It's an argument that says, let us go buckle down and do some intelligence-led policing. Let's target warrants instead of blanket powers. Let's do some proper resourcing, as was being done by the People's National Movement government. Ministry of National Security for years received the third or the second highest budget every year. Am I not correct, sir? Third or second highest budget because the resources were there. Madam Deputy Speaker, I am hearing a bray. Madam Deputy Speaker, I'm hearing a braying, a brain. Where is it coming from? Who is braying? Oh. No, not a brain, you know, a braying. Madam Deputy Speaker.
Madam Speaker, Standing Order 48-4. This continued disgusting behavior by the member for Port of Spain South. 48-4, please.
Member for Port of Spain South. Member for Port of Spain South. It is quite late at night. You have 15 minutes left if you would like your 15 minutes. I do not wish to continue shouting for the remaining of the night. Member, would you like your additional 15 minutes?
Madam Deputy Speaker, I'm very good.
Madam Deputy Speaker, 48-4. The member has to apologize and withdraw. Who is he referring to as braying in the house? That disgusting behavior.
I have it. Mr. Speaker, Madam Speaker,
Is anyone Is anyone seeing me standing right now? I am short, but I am standing. Member, please refrain from your offensive and insulting language. And please withdraw the statement.
Madam, which statement do you want me to withdraw, Madam Deputy? Which statement?
The statement implying that a member on the government bench, what word did you use? Yes.
Madam Deputy Speaker, I humbly and genuinely apologize for accusing any member on the opposite side from braying.
Madam Deputy Speaker, 55-4.
I withdraw any concept of any member from the other side of braying.
For a statement, you cannot use the same word that you used.
Thank you. Madam Deputy Speaker, as the state of emergency...
Madam Deputy Speaker, 55-4. Might I draw your attention to 55-4? Gross disorder. Conduct shall be deemed to be grossly disorderly if, during the proceeding, the member concerned uses or threatens violence against a member. He said, I will deal with you. He pointed at the leader of government business. I said, I will deal with you. 55-4. Acts in a manner that displays flagrant disobedience to the rulings of the chair. Acts in any other way to the serious detriment of the dignity of the procedure of the House.
Thank you, Mayaro. Member, please continue.
Madam Deputy Speaker, as the state of emergency comes to an end on the 31st of January 2026, and we are going from emergency as an exception to an exception as permanence, I wish to caution Trinidad and Tobago as to the slippery slope that this government has taken us down. And because of this, I would like now to deal with what I call the nuts and bolts of this bill to show how pernicious this bill is. Madam Speaker, let me start with clause 3, which expressly declares this act shall have the effect, even though inconsistent with sections 4 and 5 of the Constitution. That's a troubling provision in and of itself, because what it tells you is that enshrined fundamental rights and freedoms of the people of Trinidad and Tobago are being affected. The freedom of movement, protection from arbitrary search and detention, and due process those are being affected. And those are not conveniences, you know. Those are constitutional guarantees, hard won by Eric Eustace Williams when this constitution was proclaimed. Hard won. Nevertheless, to insist on a constitutional override sends a dangerous signal, and the government wishes to immunize itself from any constitutional scrutiny, not because it must, but because it prefers to and it has no other alternative because of its incompetence. Madam Deputy Speaker, it is not good for law and it's not good lawmaking. Excessive powers, and we look at clauses 6, 7, 9, and 12, which gives the Honorable Prime Minister sweeping authority to do the following: declare a zone, extend its duration and geographical limits, suspend operations, change the joint command, revoke a zone entirely, while Clause 7 requires an affirmative resolution of Parliament for extensions. The initial declaration occurs under Clause 6. So all Parliament is coming to do thereafter is to rubber stamp it and to extend it. Parliament is merely being informed after the fact under Clause 8. Madam Deputy Speaker, this House is reduced to a spectator whilst extraordinary powers are activated on the ground. This is not parliamentary supremacy. It is executive dominance, and there's a creeping disquiet about what is happening here, Madam Deputy Speaker. Curfews and cordon off and collective punishment. Clauses 14 and 15 allows for cordons and curfews backed by criminal penalties of up to $50,000. These powers do not only apply to criminals, but to entire communities. And remember, Madam Deputy Speaker, I told you about the peculiarity of life in Trinidad and Tobago. It affects children. It will affect workers, small business owners, and persons who have committed no offense but happen to live in these areas that have been declared zones. Where is the proportionality in this? Where is the test that can make it pass the rubric of the Surat and Suraj test? We say it doesn't. The bill limits the duration of cordons and curfews, yes. But if you repeat short curfews, it can easily amount to a permanent condition of restricted liberties, especially in vulnerable communities. And here is the main nut and bolt of this. In a community such as Port of Spain South, Madam Deputy Speaker, it is impossible to cordon off Block 8 without cordoning off Block 9, you know. It's impossible to cordon off Africa without cordoning off John. How do you get there? It's impossible to cordon off Canada if you don't cordon off Foster Quavo. Did they think about this? Or is it that they really just don't care? Is it that they really just don't care? Warrantless search and arrest under clauses 16 and 18, members of the joint force are empowered to search without warrant and to arrest and to detain people. Here's what? By reasonable suspicion. Whilst we know that reasonable suspicion is a term learned and known in legal quarters, used by an officer on the ground, it can result in profiling, high risk of abuse, and errors, particularly in marginal communities where people have already been stigmatized. The presence of the safeguards do not erase the reality that ordinary constitutional protections are being diluted in practice, even if they remain there on paper. And let us go to the afterthought, the social transformation. If you want to transform socially, give people jobs, not take away jobs. Sometimes I think they all think that we're stupid, you know, Madam Deputy Speaker. They think that we are dumb. You fire 35,000, yet you apply, you have a committee to say what? Not rehire these people because they're not working? They have nothing to do? What is it? What am I missing, Madam Deputy Speaker? That you have a committee here with 20 people? Huh? Madam Deputy Speaker, I say to you respectfully that the Social Transformation Committee is just a ruse. It's an afterthought setup to try to mitigate the unmitigatable. So, Madam Deputy Speaker, how much more time do I have? Ah, good. I am on a lot of time. Madam Deputy Speaker, when you consider this bill in its totality, it means that since this government came into office in April, for almost the entire term, they governed under a perpetual state of emergency. What about the crime plan that the Honorable Member for Tunapuna got up here and mouthed? You remember the crime plan? He doing this, he doing that. None of that crime plan involved this, you know. I wonder, where is the real plan that would divest the young people's attention, their energies from criminal activity, make it less attractive, and send them towards more productive, law-abiding activities? It certainly will not be this. It certainly will not be this when you lock down their areas and tell them that they are lesser than the other parts of Trinidad and Tobago. All it will create is resentment. In concluding, I say that the constitutional override in Clause 3 is unjustified and it's dangerous. The bill concentrates power in the hands of the executive and normalizes extraordinary measures and risks turning communities into control zones rather than partners in the national security and the national society that is Trinidad and Tobago. It does not seriously take into account the following: the constitutional framework of Trinidad and Tobago. The Constitution represents the will and the aspirations of the people. Why are you taking that away from them? Why? It enshrines rights to liberty, security of person, security of movement, protection from arbitrary arrests. Section 5 and 4 of the Constitution are robust and historically jealously guarded and defended. Not so now. The infringement of those sections will become now 180 days by 2. And you know what got me when I was reading the bill? The Honorable Attorney General spoke about the wearing of body cams. You know what the rider to that he didn't tell the Parliament? That it is as available. That was the rider to that. And what got me to just concretize it in my head, that is going to be a long-term measure. Do you know that the time for review of the efficacy of this legislation is 3 years? It means Trinidad and Tobago for 3 years. We're going and live in jail, you know. For 3 years, we're going to live in jail. And the size and the demographics of Trinidad and Tobago, our policing culture, the history of emergency powers in Trinidad and Tobago, we have repeatedly experienced states of emergencies, and each iteration has shown that it becomes harder and harder to relinquish it. This government, by its incompetence, it just can't relinquish it, Madam Deputy Speaker. This is not an argument against action, you know. Trinidad and Tobago must fight crime vigorously, but not by normalizing extraordinary powers and turning entire neighborhoods into zones of suspicion. Madam Deputy Speaker, that cannot be the answer. They can live in their ivory towers and say, no, it's not so, but it is so. And the security and liberty, they are not mutually incompatible entities, you know. They are not mutually exclusive. Sacrificing constitutional safeguards for short-term calm risks long-term harm. And that is my submission before you. As the state of emergency ends in January 2026, this Parliament must resist any temptation to move from emergency to exception and then exception to permanence. Let's strengthen the rule of law instead of doing that. For these reasons, Madam Deputy Speaker, intellectually, jurisprudentially, I will give Tunapuna a headache just now with these words. It is impossible to support this legislation because of where and how it's geared towards. We have put before the Hansard the communities that were designated in 2011. Let us see as hotspots. Let us see what emanates if this legislation passes in both houses. We, on this side, caution against it. And we caution not in a way that is meant to gaslight any situation, but we caution in a measured way. We think that this government ought to rethink its approach before it takes us down that slippery slope of constitutional infringement being the order of the day, Madam Deputy Speaker. Madam Deputy Speaker, I wish to thank you. Madam Deputy Speaker, Madam Deputy Speaker, I thank you, and with those few words, these are my respectful submissions against the implementation of this legislation.
Member for Barataria Sawa.
Thank you very much, Madam Deputy Speaker. Madam Deputy Speaker, for the second time for the day, I have to bring back some level of logic and common sense and soberness to this particular debate, Madam Speaker. Madam Speaker, I listened in silence. I expect... I don't indulge myself in your kind of behavior. Short, stocky men. You know your name was called, eh? Okay. Let me don't go down there. Let me don't go down there. Right? Madam Speaker. Madam Deputy Speaker. Madam Deputy Speaker.
Member for Port of Spain South, you have just finished talking. And you are seated. Please let the member for Sawa Barataria start his contribution.
Madam Deputy Speaker. Madam Deputy Speaker, when we thought we couldn't get worse than Fitzgerald Hines, we have Port of Spain South. For a senior counsel, Madam Speaker, his submissions were bereft of any legal logic whatsoever. He cannot understand basic constitutional principles, and he comes into this parliament as though he's some level of authority when he knows nothing about what is before him. His preparedness was lacking, his analysis was poor, and he could use all the big words because I don't know if he even understands half of them. Madam Speaker, as a former Minister of National Security, Madam Deputy Speaker, it's getting a bit tiresome to listen to the member for Port of Spain South while I'm trying to contribute. And I don't want to go down any road with him because we will have serious difficulties here this evening, Madam Speaker. Madam Deputy Speaker, as a former Minister of National Security, he has done absolutely nothing to bring down the crime rate. Nothing. He get what you call a Kobo sweat in football. He was minister for a few days driving around in a nice Prado and that's it. Did nothing. Did absolutely nothing. Not one bandit they catch. Not one murder they stop. Madam Deputy Speaker, we were able to reduce the murder rate in 2025, our first few months in government, by 42%. The lowest in a decade. They had states of emergencies with curfew, locked down the entire country, and they could not have brought down the murder rate to what we did in just 8 months. And I want to congratulate the member for Siparia and the member for Tunapuna and the Attorney General for their very hard work in coordinated approaches, in serious policies, in bringing definitive laws in order to tackle the criminal situation that they left us in for the last 10 years. That is what they left us in. They left us in. And Madam Speaker, you would think that they will come here with responsible submissions. But tonight, I have no qualms in calling out the contribution of Port of Spain South by trying to introduce racism into this debate.
What point of order?
Madam Deputy Speaker, when the criminal come in your home, they don't care who you look like, what you look like. They're coming for your possession, they're coming for your life. So this issue that we're dealing with here does not deal with someone's color. So when Port of Spain South did that, I was exceedingly disappointed because it's a dangerous narrative that he has introduced to the parliamentary record.
44-8. A member who has spoken on a question may again be heard to offer an explanation of some material part of his speech which he claims has been misrepresented, Madam Deputy Speaker. I never once, Madam Deputy Speaker, I never once mentioned race
Member for Port of Spain South. Overruled. And in your first sentence, you can check the Hansard. I am standing. You can check the Hansard. I am standing. You mentioned the word color, and in context. Member for Barataria, continue, please.
Thank you very much. And Madam Deputy Speaker, you see when you speak the truth in this house, how they get jumpy? When you call them out on their nonsense and their hypocrisy, it is a dangerous narrative. It's a totally dangerous narrative. It's a dangerous narrative.
Madam Deputy Speaker,
I
rise on standing order 55-4A. That member is creating continuous actual disorder in this house.
The member for Sawa Barataria did not have a chance to complete one paragraph. Member for Port of Spain South, I give one warning, and that is all I am going to give. I do not want to have to ask you to take a walk. So let's let the member continue, please.
Thank you very much, Madam Deputy Speaker. And Madam Deputy Speaker, the member for Port of Spain South was so wrong with his interpretation of the law. You know, he's quoting a case from Jamaica about the repeated state of emergency, and that is the case of Dayton Campbell against the Attorney General of Jamaica. And this dealt with repeated states of emergencies being extended over a 5-year period. A 5-year period. And what the court said was, in fact, that was unconstitutional. The court said you cannot continuously repeat it like that. What this bill is doing is not doing that. This bill is saying declare a particular geographical area as a zone, not the whole country, and when that zone is declared as a particular area, it is declared for not more than 180 days.
Not 5 years.
So, oh gosh, this is not even getting into the analysis of the law. This is just basic English language. Basic English language. You mean to tell me that Port of Spain South is a senior counsel and he couldn't understand the distinction between that Court of Appeal decision in Jamaica and the bill before us? The only silk he have is a silky smooth parata. It can't be senior counsel. Madam Deputy Speaker, the member for Port of Spain South was so wrong in his interpretation of this particular matter. The case is clearly distinguishable from what we have here. When the PNM was in power for the last 10 years, you know what they used to do? They used to bring legislation to this house, trampling on sections 4 and 5 of the Constitution, breaching human rights, breaching fundamental constitutional rights, and you know what they used to do? Remove the special majority. Remove it. And then the jump up here, Surat, Suraj, Surat, Suraj. We took a decision as a cabinet that we understand that the bill and the effects of the bill will, of course, breach sections 4 and 5 of the Constitution. It says that very clearly. But at the same time, we implemented provisions in the bill that it is a proportional piece of legislation where the legislative aim and the measures taken on the bill is proportional. This bill, almost every clause, will give you some sense of due process. And I will go through this with you, Madam Deputy Speaker, because the member for Port of Spain South did not. Rather than talking about how a PNM does look and all them kind of nonsense, Madam Deputy Speaker, we not engage in that kind of talk. We want to ensure that the people of Trinidad and Tobago feel safe, and if we have to take decisive, strong action and measures, we will do it. But they have been totally against this government when it comes to fighting crime, and we must ask ourselves why. We must ask this government when it comes to fighting crime, and we must ask ourselves why. We must ask ourselves why. Because when we brought the state of emergency extension in November, you know what they did? They voted against it. You know, when we brought the home invasion stand your ground law, you know what they do that? They voted against that. Do you know when we brought the AJIPA, the Amendment to the Administration of Justice Indictable Proceedings Act, you know what they did? They voted against that also, Madam Deputy Speaker. So every time we are bringing legislation to this Parliament to lock up the criminals, to make our citizens feel safe, you have the PNM bench saying no to that. Why are they protecting the criminals? Why are they not lending us that support? Why are they not engaged in bipartisan support to ensure that we could lock up the criminals? Look, today, Madam Deputy Speaker, we brought a piece of legislation. For the whole Christmas, instead of singing parang, they're talking about fines. When we brought legislation to say no insurance, pay X amount of fines, no driver's permit, pay X amount of fines, they say we shouldn't do that because they are encouraging the lawlessness, Madam Deputy Speaker. They're encouraging it. And this piece of legislation, a progressive piece of legislation, a piece of legislation that will ensure that citizens can feel safe at night. Even the same people, the law-abiding citizens who may live in these zones, may welcome this legislation because they know that at that point in time they can go to sleep comfortably knowing that they are safe in their own homes. And what is wrong with that? Why you can't support that? Why you can't support that? Because they have ulterior motives to play politics with crime fighting. That is what they're trying to do. And if you all think that you all could get back in office somehow by doing that, think again. Reflect on what happened on Monday. Reflect. Part of the major reasons why you all were voted out in office in April last year was because of crime. Because you could not do nothing about crime. You could not do anything. That is why we can, as an administration today, boast that we took crime and murders down by 42%, the lowest ever in a decade. That is why we can boast of that. That is why we can boast that the amount of gang-related murders have decreased significantly from the period 2020 to 2025. And I will give you the numbers. In 2020, there were 130 gang-related murders. 2021, 189, it went up. 2022, 244, it went higher. 2023, 261, it went higher. 2024, 273, it went even higher. That was their last full year in government. Remember that figure? 273. 2025, 8 months into government, we sent it down by 108 gang-related murders. And part of that was because of the tangential benefits we got because of the state of emergency, and we were able to do that without a curfew. It is business as usual, you know, for the law-abiding citizens, but not for the criminals. Think about it, you know. Have your lives been disrupted for Christmas? Have your lives been disrupted for this period? No. But the criminals' lives are being disrupted. And why don't you join us in helping us disrupt the criminals and the activities? Madam Deputy Speaker, one has to understand why they don't want that. And then you're telling us that, oh, because CPEP, URP, whatever. All of that happened. We got rid of all of the ghosts. We are starting to incorporate most of these individuals through the Ministry of Works and Infrastructure in terms of giving them proper jobs, and the Ministry of Rural Development and Local Government. With decent pay. With decent pay. They could get a loan. They could buy a car. They could get financing and so on. Have you seen a spike in crime or any correlation between those two programs? Hold on. Between those two programs and the crime actually reduced. The crime has actually reduced. So you cannot say that there's a correlation between that. You cannot say that. You cannot at all say that.
The podcast man, there's so
you see, this government is a lawful government, a government engaged in constitutional exercise. And if the opposition, if you're named man and you want to show off your silk, it's simple, go to court and test the legislation. If you have all the submission to make in here, all of this case to talk about in Jamaica, go to court, put on your robe, and test it. Simple. The government's duty is to make the citizens feel safe, and if we believe this is one of the measures to do it, then the government in the House has the majority in order to do that. We were elected here to ensure that we make people feel safe, and this is one of the measures we think will work, and we are going to pass it tonight. So, Madam Deputy Speaker, with all of that I had to say in terms of these additional issues, I want to get into some of the other matters in the bill itself, because I promised you I'll go through the various clauses of the bill. You see, when you look at clause 6 of the bill, the member for Port of Spain South made it sound as though that the Prime Minister on her own volition will act. And the Prime Minister on her own volition will say, okay, I'm going to declare the Red House a zone. No, just read. The legislation says that the Prime Minister in council. What is the council? The council is defined in the legislation. The council is defined as, and if you look at the clause, you will see council is defined as the National Security Council. Means the Prime Minister presiding as chairman of the National Security Council. And that is where the Prime Minister and members of the National Security Council receive sensitive information, intelligence on national security. So therefore, the Prime Minister will act in accordance with the advice and the intelligence received at those meetings. But if the government or the Prime Minister in council wants to extend the period, what has to happen? You can't do it just so. It goes on to clause 7. It says the order for the extension shall be subject to what? Affirmative resolution of the Parliament. What does that mean? It means that you have to summon the whole Parliament, bring the order before the Parliament, and every single member of Parliament will have the opportunity to debate it. It's simple as that. Now, there's a level of laziness across there, and I can tell you why. Because if I'm not mistaken, the fines and the fees and so on in the Motor Vehicle Act was subject to negative resolution. You know, not one of them brought a motion to negative it after all that noise. But what we have done here is we are, as a government, we could have said negative resolution. We could have said that. But what we did to balance it for transparency, for justification, for public debate, is to bring the order for any extension for affirmative resolution of what? The Parliament. Not just the House. When you have to extend the SOE, what happens? You have to come to the House only. That is not a matter for the Senate. We are saying any extension of the zone comes to the Parliament. And yet you have a problem with that? There's a check and balance built in within the legislation. Then it doesn't stop there. It does, if you look at clause 8, it then says where an order is made under section 6. So Prime Minister and Council says we're going to zone an area. What has to happen? The Prime Minister or the minister assigned with responsibility for national security has to come to the Parliament and make a statement within 14 days of making the order. So there's another check and balance. So the Prime Minister must inform the nation through the Parliament or the minister, listen, we have declared a particular area to be a zone, and therefore we give the reasons and so on based on the statement. Transparency, a level of check and balance. We operate within a democracy. When you come for an extension or so on, you don't need to give a statement. You just lay on a SOE, sorry, just lay the motion for that. Then, during the period that a zone is declared at clause 11, the Joint Command shall submit a report to the National Security Council every 30 days. So there's constant reporting that has to take place now. So therefore, the Joint Command cannot go out and do what they like, how they please. They are still bound by the four corners of the law, and now they must report to the National Security Council, listen, I have done this, X, Y, and Z. Another check and balance built in with the legislation. So when we're looking at rights that may in fact be infringed upon, the right to liberty, you also now have a check and balance on the measures that you are taking when you limit those rights. Not every citizen, you know. It's not every citizen. It's not every citizen. You can't just go and on any volition declare a zone. Public and administrative law don't work so. Any public official acting in any capacity must be acting in a manner that is reasonable, basic constitutional law. You must be able to justify your decision. Then, when you look in terms of custody or disposal or arrest and detention at Clause 17 and Clause 18, where a person, for example, is arrested or detained in a zone, and I'm looking at Clause 18.2, that person shall, at the time of his arrest or detention, or as soon as reasonably practicable, be told in a language in which he understands, or for the reasons for his arrest or detention, unless circumstances are such that the person should know, B, immediately as soon as is reasonably practicable, be taken before a magistrate who shall determine whether or not there are reasonable grounds for the arrest or detention. So again, person is detained, so therefore you have to first give what? The reasons for the detention or the arrest, and secondly, immediately take that person before where? A court of law. Again, you deprive a person of his liberty with cause, but you're affording them the process of, you're giving them their due process. And when the magistrate is satisfied that the arrest or detention of a person in a zone is reasonably required in the interest of justice, he may, having regard to such further investigation, order that the person be remanded for what? Not exceeding 48 hours, and at the expiration of the 48 hours, he shall do what? Be able to take him to a judge. A higher level of the judiciary. Check and balance. Proportionality, due process. So I can't understand when my colleagues across the floor, they're saying that this thing is totally draconian. It's not. There are avenues. I could also tell you, Madam Deputy Speaker, that a writ of habeas corpus lies. Yeah? In a state of emergency, you don't have that remedy. Once a state of emergency is declared, you're detained, you have to go before the emergency tribunal. In these cases, you go before what? A court of law, a judicial officer. So therefore, there are inbuilt check and balance within the law. Then this is a very progressive clause, and I want to commend the Attorney General, because you don't see this in legislation. At Clause 21, it talks about the treatment of the persons arrested or detained. Very important. As a government, we have taken a decision to legislate and give that statutory right in terms of treatment of the persons detained. My friend from Tunapuna will tell you that they will look at the police standing orders and so on for the treatment of prisoners. In this case, we are putting it in primary legislation, and I think that deserves commendation by the Attorney General. Because this talks about the security and safety of the person. It gives, in terms of persons' requests for registered medical practitioner of his choice, other than one provided by the state, and the person shall be responsible for his expenses, of course, and so on, and gives indication of records that has to be taken in terms of the welfare, the reception of various articles, and so on. The use of body-worn cameras. I heard Port of Spain South say, well, that's subject to availability. In the law, we have legislated that they have to use the body cameras as far as possible. But I want to tell you something, Madam Deputy Speaker. Because when they bought the body cameras, you know what they did? You know what they did, Madam Deputy Speaker? They bought body cameras, you know. But you know what they do? They forget to buy the charger. They forget to buy the charger. I can't make this thing up. The man who buy the body camera, I think he sleep away. And then Port of Spain South bought not a single body camera and has the goal to come today to tell us that it is based or subject to availability. You see, sometimes, Madam Deputy, the old people they say, dog eat your shame. And in this case, this is a clear example of dog eat your shame. And Madam Deputy Speaker, it then goes on at part 5 of the bill that a social transformation committee must be established. So therefore, while we take the hard approach towards crime fighting, Ms. John will tell you that you also have to take the softer approaches. That you now have the engagement of the community. And if you look at the makeup of the committee, because it has a statutory mandate, you have the minister assigned for the responsibility of national security, the MP of the constituency within the zone is located, the mayor or the chairman or so on, the CDS or his nominee, the commissioner of police, an attorney at law of not less than 7 years standing, a representative of the ministry responsible for social security, a representative of the ministry responsible for national security, a representative of the ministry responsible for health, a representative from the Ministry for Economic Growth, a director of town and country planning, the chief medical officer, a representative of the ministry responsible for social development, a representative from the National Works and Infrastructure Ministry, a representative of the LSA, well, I will be present. My ministry will be present. A representative from Public Utilities, a ministry representative from the Education, a person who the minister is satisfied as a representative of a bona fide community group active in the zone, a person who the minister is satisfied lives or works in the zone, any other person who or the agency that in the opinion of the minister can assist the work of the committee, a representative of the Children's Authority, a member of the Joint Force Training Sensitivity to matters relating to gender-based violence, a mental health professional, a representative of the National Center for Persons with Disability. Progressive.
Member, would you like your additional 15 minutes?
Yes, please, Madam Deputy Speaker. And these meetings, Madam Deputy Speaker, has to take place. The law is being placed that these meetings have to take place. I can tell you, it's a no Berkey go be on a committee. Right? It's a no Berkey on a committee. It will be ensure that we have responsible people and not a talk shop, Madam Deputy Speaker, because when you go into those zones, you don't just want to take out the criminals alone. You want to ensure that persons who may be afflicted because of social displacement, because they may not have means, that these persons are properly assessed. So therefore we get into the root causes of what may be criminality or delinquency. You would be surprised to know that I went into a school, I'm not going to disclose the school, for a visit, not when I was in government, when I was in opposition. And I am told that there are students in that particular school before the court for criminal offenses. And we cannot have that happening. We really, as a government, and when I say government, as a parliament, we have to take this issue seriously. You all have the whole evening to provide amendments, provide suggestions, tell us what you think we can change in the legislation. It may or may not be accepted. But at the end of the day, this fight against crime, this landmark piece of legislation, will ensure that we can bring down the criminality even more. We have already made a major dent disrupting the criminal syndicate. At this point in time, we don't want to lose those wins. We don't want to lose those benefits. Because when we win in terms of fighting crime, your constituencies win, our constituencies win, Trinidad and Tobago will win. We will win. Everybody will win. Everybody will win. And you have to understand that the criminals have become so complex in terms of their operations that it cannot be business as usual as normal policing. We have to have the technology. We have to give them the laws. We have to give them a fighting chance to ensure that they have the necessary tools in their arsenal, be it the legislation and be it the resources to attack and arrest this criminal situation, Madam Deputy Speaker. Madam Deputy Speaker, the objects of the Act are clear. You can see it is spelled out at Section 5 or Clause 5 of the bill. The declaration of the zones, as I told you, it's not going to be any decision taken lightly. Section 1 spells out the grounds. It says where the zone has rampant criminality such as murder, gang warfare, or high or escalating levels of violence, or the threat to the rule of law and public order, that is where the zones will be declared as that geographical area will be declared as a zone. So, in conclusion, Madam Deputy Speaker, we as a government we have taken very serious legislative measures in the last 8 to 9 months as a government. Those measures have been working. We have seen the benefits. We have seen that the tangential benefits of the state of emergency is to bring down the criminal activity and behavior in Trinidad and Tobago. We take note of the concerns our friends have opposite with respect to the constitutional issues. The Attorney General would have explained very comprehensively those particular matters. I was able to distinguish the difference between this legislation and the Campbell case that came out of the Jamaica jurisdiction, one being a repeated SOE. This is not a repeated SOE. This is a declaration of a zone for a limited period of time with the necessary checks and balances within the legislation. Madam Deputy Speaker, while we agree, while the legislation has declared that we may be tripping some rights in accordance to Section 4 and 5 of the Constitution, we believe the legislation is proportional and will pass that test to be a constitutional piece of law when passed in this Parliament. Madam Deputy Speaker, this government is not abdicating its responsibility when it comes to fighting crime. We will never have a Minister of National Security that will go on television and tell the nation that his job is not to make citizens feel safe. We will never have a Prime Minister who will say that his job is not to fight crime, that is the police work. We have a Prime Minister who is leading from the front. We have a Minister of National Security or Homeland Security that is awake at all times. We have a Minister of Homeland Security and a Minister of Defense who works exceedingly hard to ensure that law enforcement has the support. And most importantly, we have an Attorney General who knows the law. In fact, he even passed maths. So, Madam Deputy Speaker, Madam Deputy Speaker, this particular piece of legislation is a progressive landmark piece of legislation, and we call upon all right-thinking citizens in Trinidad and Tobago to lend us the support so that we can put the criminals behind bars and establish Trinidad and Tobago as a safe zone once again. I thank you very much.
Member for Laventille West.
Good morning, Madam Deputy Speaker. I rise in this house this morning, at this very early morning, as the Member of Parliament for a constituency which would have some serious concerns based on the trajectory, based on the history of members opposite. But before I get into the trajectory of the members opposite, I want to take you directly, Madam Deputy Speaker, to a Selwyn Ryan report of 2013, Youth at Risk
no time to quit. And I want to define, using the committees, a very experienced and distinguished committee led by Professor Selwyn Ryan and a team of respected intellectuals in this country. And this committee defined a hotspot as, and I quote, "A crime hotspot is generally defined as an area containing dense clusters of criminal incidents. It may extend to an area adjacent to one where criminal activity is geographically concentrated and incidents occur on a frequent or relatively regular basis. Identification of hotspots helps public safety institutions allocate resources for crime prevention activities. The geographical analysis is usually made based on crime pin maps of reported crime events over a certain period. During the state of emergency in August 2011, Prime Minister Mrs. Kamla Persad-Bissessar announced a 9 a.m. to 5 p.m. curfew in certain hotspot areas, which she identified in the city of Port of Spain, the city of San Fernando, the borough of Arima, the borough of Chaguanas, the San Juan Laventille Regional Corporation, and the Diego Martin Regional Corporation, as it then was." End quote. I was quoting. But Madam Deputy Speaker, I bring this to this Honourable House attention to put into context the foundation of my serious concerns, not on behalf of any member opposite or any member on this side, but on behalf of a constituency that I represent and that I'm extremely proud to represent. I hail from a community called Beetham Gardens, Madam Deputy Speaker. And during the last, don't worry about that now. And I would say, Madam Deputy Speaker, that these concerns, and you see, Madam Deputy Speaker, I would not be sidelined or distracted by crosstalk. This is serious business that affects the rights of my constituents. It is no laughing matter here tonight, and I intend to be serious and to ignore the likes of St. Augustine and her colleagues. Yes. This is serious business. Madam Deputy Speaker, we have explored thoroughly, explained, and looked at this bill in its present form. And this is not the first time that this bill is before the population of Trinidad and Tobago for consideration. You see, some people have short memory. Because I have in my possession, apart from the Jamaica bill that was referred to, but this bill was also considered in 2017 and was originally drafted by the then Attorney General, or the Office of the then Attorney General, Mr. Faris Salwari. It was sent in August of 2017 to the then President of the Law Association, Mr. Douglas Mendez, Senior Counsel, for comment and consideration. It was also sent to the members opposite for consideration. When this very same bill, the only difference, Madam Deputy Speaker, the only difference between the bill brought here today by the Honourable Attorney General and the bill then is that the major difference is that instead of giving the Prime Minister the authority to grant to declare a zone of special operations for 180 days as is documented in this bill, is that when you look at the original draft bill, it was 60 days. And of course, 60 days extension. But Upon proper consultations, Madam Deputy Speaker, and serious concerns raised by the Law Association, serious concerns raised by members then opposite, and then when it reached to Cabinet, the Cabinet rejected it. So to come here and to play Christopher Columbus of this bill, that you come for the second time with it, and you discover it and you must get commendation, is hypocritical. But I can tell you that even if, in terms of the drafting, I can say without a shadow of a doubt, Madam Deputy Speaker, that it was nonsense then, and it is nonsense now.
Correct.
It was dangerous then, and it is dangerous now. And I will tell you some of the concerns, because you see, sometimes these are just clauses to some persons. But these are lived realities for my constituents. Because you see, Madam Deputy Speaker, before we even get to the local analogies and examples, I want to take you to a place and a country where this exact legislation have been implemented, which is Jamaica. And I am going to draw your attention, Madam Deputy Speaker, to a U.S. Department of State human rights report that was generated in 2021. And the U.S. at that time, Madam Deputy Speaker, examined what were the consequences, what were the realities lived in Jamaica relative to the implementation of this legislation. And with your leave, Madam Deputy Speaker, I'm going to draw your attention and quote, and I quote, "There were numerous reports during the year that the government security forces committed arbitrary and unlawful killings, and there were hundreds of complaints of abuse of wrongful harm. The Jamaica Constabulary Force was cited in most reports in its role both as an independent agency and as part of the joint military police activity. There are several reported incidents involving Jamaica Defense Force. Overall, the total number of fatalities involving security forces, justifiable or otherwise, increased with 123 reports as of December 9th, 2021. Police fatally shot a taxi driver in September after he failed to obey an order to stop. A passenger was wounded in that same event, which drew significant community protests. In 2020, the government reported 115 fatal shooting incidents and 92 non-fatal shooting incidents involving security forces, an increase from the number of incidents reported in 2019. Charges against members of the security forces took years to process, primarily due to investigatory backlogs, trial delays, and appellate measures. I'm going to go as well to speak about and to look at in this report some further serious allegations in relation to how this special operation zones operate. There were allegations of cruel, inhumane, and degrading treatment or punishment of individuals in police custody and in correctional facilities. The U.S. Department of State went on, Madam Deputy Speaker, to speak about cases against security forces were infrequently recommended for criminal trial and often saw substantial procedural delays. There were reports of unlawful arrests for which officers were not punished or disciplined. And this report, and Member for Battery will appreciate that when I come here, I do my research, and I prepare, and I use the Parliament laptop, and I use the resources, and I came well prepared. Because you see, Madam Deputy Speaker, these are the real concerns that face persons in communities where the special zones are instituted. And when we look, and we don't have to look very far, Madam Deputy Speaker, in Trinidad and Tobago, we are in a state of emergency. We have spent more than, in terms of from the last state of emergency under the last administration, this state of emergency and the extension, almost a year in a state of emergency where persons' rights and constitutional rights were suspended and affected. And as members of Parliament, we come to this House and we must do a balancing act. We understand the issues of crime plaguing our society. We understand that we must unite in the fight against crime. But that must also be balanced as well as to our society and how these legislative agendas may affect our constituents, our citizens of this great republic, Madam Deputy Speaker. So, in looking at this bill, and even as the news broke in terms of the government's press conference, the UNC press conference, and the rollout of the communication strategy ahead. And it's not by chance, Madam Deputy Speaker, that at 12:18, that we are in this Parliament on a Friday into a Saturday morning in the midst of Carnival, discussing this serious agenda, this legislation that will have serious implications to the citizens. But you want to discuss it and debate it when citizens are asleep. But I will tell you that they can bring it in the morning, the night, or in between. We will stand in defense of the citizens of this Republic of Trinidad and Tobago. And we will speak, and we would spread the message that is necessary for citizens to understand what is taking place in their house. Because whether you call it a special zone, whether you call it a hotspot, whether you call it an at-risk community, whether you call it a ghetto, whether you call it a hood, whether you call it behind the bridge, whether you call it impoverished communities, we see through the dog whistle and we know which communities will be affected gravely and the most by this. And I am not, Madam Deputy Speaker, limiting what I'm saying to any member opposite. But we live in a society, and the member for Bataria San Juan got up a while ago and infer that the member for Port of Spain South was inferring some sort of racism in relation to his remarks. And I want to reject that. Because we live in Trinidad and Tobago, Madam Deputy Speaker, and in Trinidad and Tobago, it is the most beautiful Twin Island Republic any part of the world you could find. But we are not perfect. And it doesn't mean that we cannot call and look in the mirror and look within in terms of our different sectors in the society and point out the true and real issues that are plaguing our society. And guess what? In 2026, racism and classism and discriminatory and stigmatization, all of these things exist in Trinidad and Tobago, whether we want to admit it or not. So when I stand here in defense of the vast majority of my constituents who are law-abiding, decent, hard-working members and citizens of this republic who will be affected by this legislation where a prime minister can declare, and if we watch at 2011 and we have to mirror any aspect in terms of where these zones would be allocated, I can say without a shadow of a doubt that if that is the same approach from 2011, every single constituency, every single community within my constituency, every single street, every single track, every single hill, every single road, every single house in my constituency will be affected by this legislation. So I stand here in defense and to speak up on behalf of not anybody who is engaged in any wrongdoing. Because I want the police to attack them with full force. However, Madam Deputy Speaker, we also have to, Madam Deputy Speaker, understand the rights, the freedoms, and what are the realities that are going to be faced, and what are the risks as the U.S. Department of State outlined it. The U.S. Department of State outlined the risk associated with this legislation. And I hope that we can do better. But these are the realities. So is it that we ignore this? Is it that when we stand up in defense of our constituents that we are going to be accused of pulling the race card? If I have to be persecuted for that, then stamp it on us. Because we are in defense of every citizen of this country, regardless of your creed, color, or race.
Madam Deputy Speaker, 53, 1E and F, the member for Chaguanas East is consistently throwing words behind the member.
I have heard the member for Chaguanas East speak once. Member for Laventel West, kindly continue.
I would not be distracted, Madam Deputy Speaker. I am on a mission, and I am here because, according to Bataya Sanwan, I did my research, and I came here prepared to stand in defense of every single constituent of mine that are law-abiding. So, Madam Deputy Speaker, this bill that came to Parliament with two days' notice has the potential of trampling upon the constitutional rights of every single constituent of Laventel West. I am duty-bound to stand up in defense of the vast majority of my constituents who, as I said, are law-abiding. This bill undoubtedly is an attempt to place our country in a permanent state of emergency. It is even, in some of the cases, Madam Deputy Speaker, more dangerous, dictatorial, and restrictive than a state of emergency. And I will explain why very soon. This bill offends every principle of fairness, equality, and due process in this country, Madam Deputy Speaker. It is a direct attack on the rule of law and the separation of powers without any constitutional safeguards in place.
None.
None whatsoever. So, this bill will establish a joint force to operate within these special zones, Madam Deputy Speaker. The joint force will include not only police officers who are trained, who are familiar with the judge's rules, who are familiar with the Constitution, who are familiar with AJIPA, who are familiar with the Police Service Act and the Offences Against the Persons Act, the Summary Offences Act, etc. And certain training. But it also includes members of the Trinidad and Tobago Defence Force. And Clause 14.2 of the bill, Madam Deputy Speaker, gives soldiers, coast guards, air guards, etc., the power of arrest and the same powers as police officers within the special zones when curfews are imposed or where areas are cordoned off. Madam Deputy Speaker, in case members were not paying attention, I'm going to repeat that very dangerous provision in clause 14, subsection 2 of this bill. It empowers not only police, it empowers the joint force is made up of not only police officers, it is made up of soldiers who we are giving the powers, the same powers as a police constable. The power to enter your home without a warrant. The power to arrest you without warrant. You see, sometimes when we speak about these things here, people, some members who have not lived it, have not experienced it, think, oh gosh, they're exaggerating. What are so concerned about? But I know it all too well. Because in 2011, I was a Form 5 student of Trinity College, Mocha. The best of the best, Simon, I'm sorry to say that. But I was a student at Trinity College, Mocha. And even when I took off my school shirt and I was home, I was personally affected by a state of emergency. Where police officers came on the block, they may consider it a block we playing in the street. I'm talking about the police officers. And wrapped up a whole set of young men. 15 years, 14 years, 16 years, 17 years. And took us down to a police station, questioned and then released us. It was the wrong set. They told it was supposed to be a different street. So these are the realities when we are saying in a state of emergency, it is cause for serious concerns. And it is not by VAPs that we are asked and we are pointing to these serious concerns. If my friend from Bataya Sanwan said, if we have recommendations that we should bring it and he will consider it, they will consider it or not. If this were the case and you really wanted true consultation, true and meaningful consultation, wouldn't it have been better if we had met on this before? If we had consulted in a bipartisan manner so that we can raise the concerns? Is it that it was not relevant to tap into the different stakeholders in this country? This bill threatens the very fabric of our society. A prime minister declaring a state, a community, or a constituency if she feels like, or municipal corporation if she feels like, including, you can imagine going into a local government election and a prime minister could put a curfew as to when and how and where members of a particular municipal corporation can leave their home or not, that could attend a meeting or not, that could protest or not. I'm not imputing that the Honorable Prime Minister will conduct herself in that manner, but I'm saying that this bill gives an unfettered discretion to the office of the Prime Minister, an elected politician, to determine whether my constituents can come outside at night, or whether Port of Spain North, St. Anne's West constituents can come out at night. So whether any PNM municipal corporation can come out at night. That is a recipe for disaster. That is in no way upkeeping the rule of law and respecting the principles of the separations of power, Madam Deputy Speaker. So these are things that we must look at. Further to which, each special zone will have a joint command overseeing the zone. The joint command pursuant to clause 10.1 would include a senior police officer and a senior member of the defense force. There is no indication as to who will have the power over whom when it comes to decision making. You put a senior police officer, you put a senior member of the defense force. No indication in that clause as to who has the real power within the district once a special zone is implemented. I have seen during state of emergency that police and soldiers at war in terms of I have seen, Madam Deputy Speaker, that vehicles assigned to the Trinidad and Tobago Regiment patrolling in some communities and soldiers taking off the number plates and putting on masks and beating people left, right, and center, going in what house they want, doing what they want. Are there any regiment complaints authority? What are the disciplinary functions in place? What are the safeguards in place? Are the members of the Defense Force, Madam Deputy Speaker, are they trained in policing? Are they trained? Are they trained to investigate, arrest, and prosecute? Are soldiers taught and trained to interact with civilians? Are soldiers trained to use reasonable force, or are they choose to use deadly force? Are soldiers trained to exercise restraint or to attack with full force? Are soldiers familiar with the CPR, with the judge's rule, any of the common law guidance as in relation to how an officer is supposed to have reasonable cause to suspect? What are the process that members of my constituency would be able to raise concerns concerning soldiers' brutality? Are there any? And this goes back very hand in hand with what the U.S. Department of State have reported that what was transpiring in certain parts in Jamaica with the very same implementation. So you have a widespread police killing, widespread defense force killing, and you can't, that is one of the major findings of the report, that when persons report it, when they're believed to be extrajudicial killings, that there is not a timely disciplinary matters, and or that the members of the regiment are not being held accountable in a timely fashion in terms of whether it is arrest and or conviction or prosecution. So these are real concerns, Madam Deputy Speaker. These are true concerns that we must raise. Further, by way of clause 14.1a, the Joint Command can cordon off any community. They said any geographical area, which means that it could be any community, any constituency, any municipal corporation, any geographical location that the Prime Minister or the Joint Force determines that they want to. Meaning that persons will not be permitted to leave nor enter that particular cordon off zone unless authorized in writing by a member of the Joint Force who is in charge of the special zone. And again, you have a senior police officer, you have a senior member of the Defense Force, no indication.
Member, would you like your additional 15 minutes?
In defense of Laventille West, most certainly, please. This special zone, in terms of cordoning off, can last up to 24 hours. There's no restriction in that clause, Madam Deputy Speaker, in terms of how often you can bring the cordon off. You can have it today, cordon off for 24 hours, and decide that next week again, and you keep going. You could have curfew for 3 days, break for 1 day, start back again. These are dangerous precedents that will go unchecked, and we must stand in defense of that, Madam Deputy Speaker. Madam Deputy Speaker, this bill empowers the Commissioner of Police and the Chief of Defense Staff to impose a limitless curfew. There is no, in this bill, there is no indication as if the curfew could only be at night. There's no indication. A curfew, they could say that a curfew is from 2 p.m. to 2 a.m. or 2 p.m. to 6 a.m. No limit. This requires us to have proper consultation on these matters, to have true. We are led on this side by an opposition leader and a political leader that is a leader extraordinaire. She puts country first every single time. We have demonstrated this time and time again that when good legislation comes to this house, we on this side, we support it. And we give you an example just today. We have supported and joined with our friends in order to support and to give greater autonomy to Tobago. Correct. And every single time we close off the year, and I remember it was such I remember as a parliamentarian, it was such a refreshing moment to end 2025 when I could have seen bipartisan and respectful coordination in the best interest of the country between the opposition and the government. Correct. We supported their legislation. We gave recommendations. And every single time that this government comes and they propose any bill that we believe that is in the best interest of Trinidad and Tobago and that we have some concern, and although that may be the case, but we have certain concerns, we are duty bound to raise them. And that is what we have been doing. So if the Honorable Attorney General wishes, as the member for Bataria Sanwal, signal for some level of consultation, then the proper thing to do, and I'm seeing that the Attorney General is signaling no. I'm seeing that the Attorney General is signaling no. But we too will signal no, and we ask the independent senators when it reaches to signal no as well, Madam Deputy Speaker. What you see, Mr. Speaker, some citizens may wonder who are these likely communities to be affected by these measures. And there are no schedules attached to this bill to identify the possible communities or zones that would be affected. This bill ought to be data-driven, Madam Deputy Speaker. We need to know in terms of the numbers from the Trinidad and Tobago Police Service and so on, as to which are the potential zones that may be affected by this. It is not that it will be implemented, but the possibility based on the data to suggest which zones are likely to be affected. Because it cannot be that there's only one type of communities and one type of crime and one type of small fishes that they will use this opportunity to go after, whilst the others run free. Madam Deputy Speaker, I am asking all of the Honorable Attorney General has signaled no, that this requires meaningful dialogue, meaningful consultations. And it's just an attempt. And you see, and Madam Deputy Speaker, I want to put this in context as I wrap up. Because this legislation is brought on the heel at the end of a state of emergency. During the state of emergency, Madam Deputy Speaker, the government has taken, as is the government right, some very harsh social and economic decisions over the last 9 months. That's a fact. Everywhere you go, whether it's on Charlotte Street, Independence Square, the Dial Harris Promenade, the ground in Trinidad is rumbling. Yes. People cannot wait till the end of this month. They are dusting off their marching shoes because they want to tell the most unpopular government in the history of Trinidad and Tobago that they had enough of them. And this attempt and this legislation, this bill, Madam Deputy Speaker, this bill is an attempt to further tell citizens, hey, behave yourself. Yes. Not a talk back. Don't raise your voice, because if we want, we declare from the Red House and all our zone. with no limitations.
None.
And I would say, most certainly, Madam Deputy Speaker, that it raises serious cause for concern. And as a responsible opposition, as the watchdogs of democracy, as the watchdog against constitutional supremacy, as the watchdogs against the rule of law, the separation of power, and the constitutional rights, Madam Deputy Speaker, we stand in defense of the vast majority of the law-abiding citizens of this country to say that, like an animal farm, we know that some animals are not equal as they deem. All animals are equal, but some animals are more equal than others. Right? And in light of that, Madam Deputy Speaker, I am asking, most respectfully, that we pay close attention to our brothers and sisters in Jamaica, that we learn from their mistakes as identified in the U.S. Department of State, as we look at the U.S. Department of State report in terms of the incidents and the risk associated with it. And we are warning this administration, we are warning this administration that there are serious cause for concerns. Let us look at it, and let us come up with the right strategy in terms of a bipartisan approach in terms of ensuring the safety and security of all citizens of this great republic. With that few words, Madam Deputy Speaker, I thank you very kindly for the opportunity to contribute to this debate.
Member for Tunapuna.
Madam Deputy Speaker, let me thank you for the opportunity and the privilege as Minister of Homeland Security to contribute to this so important bill this evening. This bill seems to be one that has the persons on the other side so caught up that they seem to forget. So let me start helping them very early. Port of Spain South, Laventille West, those are the two areas where joint patrol started in Trinidad and Tobago. Are you aware of that? Joint Army and Police patrol started there. I spent 32 and a half years of service to the people of Trinidad and Tobago and attained the rank of Senior Superintendent. One of my responsibilities was the Port of Spain Division, among other operational teams. So when my colleague on the other side spoke of how the operations are at those areas, I tend to disagree. Because look at this. If we were targeting areas that he mentioned, why is he sitting here today as a representative and we didn't target him? Why is he sitting here today and able to represent the good people of the Beatum? And I want to also tell him this. I too know that there are good people there. Look at you. And you, Port of Spain South, my colleague, there are good people there too. But he must remember the base for which this joint police patrol started was in those two areas, Madam Deputy Speaker. But I also want to go this far. Madam Deputy Speaker, I recall in the last 10 years, my colleagues and I, we waited. We tried over and over to treat with crime and criminality in Trinidad and Tobago. And while we waited, I saw persons on the other side who was on this side, sitting, some of them standing, some of them sleeping. But no legislation, no laws to assist law enforcement and the protection of our citizens. Madam Deputy Speaker, sometimes it disturbs me to hear them speak now, because when you compare me to them, I was here for years fighting the good fight, and I know what they did not do. As I stand here this evening, I want to thank the men and women of all the agencies under the Ministry of Homeland Security for their bravery, their devotion to service, willing to give their life in protection of our citizens. And also, I will take piece of my colleague from the Defense, Ministry of Defense. I want to commend members of the Trinidad and Tobago Defense Force and Coast Guard. They continue to put their life on the line in defense of this nation. Their selfless display of gratitude, productivity continues to show the type of individuals we are. It doesn't matter where we come from. And I want to tell Port of Spain South, there is no other person on this side that can grow an afro other than myself and the AG. We can grow afros. So when you talk about the PNM lookalikes, and you indicated in your statement what they look like, well then you are seeing persons here. I might even have to call on Tabakit and our representative, we call Double J. Yeah, and there's not much persons here. But you know what we did? This bill don't see race. This bill sees the protection of our citizens. We stood here in this parliament for the whole day. And I'm telling you, it is confusing sometimes to hear some of you speak. You continue to make statements, and I wonder where you were all these years. There are times, Madam Speaker, when we stood here as members, I used to look at persons on the other side making comments in this house, this honorable house. And that's when I knew for sure that all they had for the crime plan was a program they probably had called Crime Watch, the PNM Crime Watch. Because for years, all they did was watch crime happen time after time, week after week, month after month, year after year. Watching crime, while the public tremble, afraid to walk out of their home. And as my colleagues say, every time that we come here before this house and presented something meaningful in defense of the people, they never support. They don't want to support. It's if to who dead, dead. That is a statement they would have made some time ago. And they're supporting that statement. We are hoping, Deputy Speaker, that good sense will prevail in this situation and allow things to flow. The Joint Army Patrol has already created the platform for this joint command. It's nothing new. And we are hoping that members of the public understand. When we look at the phones, there are persons in your constituency, your constituency, your constituency, and your constituency already asking for the zones of operation to be the first place to deploy. And to ensure that we do not have any race attached to that, the Prime Minister's constituency might be the first one. But let me also bring to the attention of this honorable House what my colleague was just mentioning a short while ago. This bill does not seek to marginalize or target any specific community by law enforcement simply because of crime is more prevalent in these areas. This is not the government's intention. So if you read the act, if you took a little read of the act, you would have seen that we would have discussed this early. There are key features of this bill. Port of Spain South, he said, we are only targeting certain areas. But let me ask you this. Port of Spain South, I wonder if you went to Mocha Fete over the past week. And if you did, the only persons who are affected by the SOEs that we're having and the zones of operations we intend to have are the criminal elements. You all are free to go about your lawful business. But, again, nobody is stopping anybody's freedom with respect to the zones of special operation. Time and time again, we come to this house and we hear the same thing over and over. I sat here for almost 5-6 hours and everybody just repeating themselves. The same old storyline over and over. Nothing new attached to it, but we still have to sit and listen. Port of Spain South said that we are causing unemployment because the zones of special operations require some social involvement, and we are causing unemployment. However, we are causing unemployment because we want persons to have an honest day's work for an honest day's pay. So when you see persons no longer employed, it's because the fraud and chaos that you all caused while you was in office. And let me just send something down my friend's way here. The night before election, Persons in your community, a dark man, was making some utterances to overthrow the government. And a person in your community also, sometime before, engaged a man who was in possession of some contraband, and they were supporting each other. I am wondering if the People's National Movement continues to support the criminal element. Every effort that they make, every effort that we bring, continues to be a fight down and an embrace of the criminal element and their behavior. Every time we bring a crime plan, they want to hear about the crime plan. But the funny thing is, none of the crime plan presented by the past regime have worked. None. Not one. But yet they come here this evening and talk about, oh, we need to see the crime plan, and we need to see this. The crime plan that you had resulted in 624 murders. And before that, 500 and some, and before that, 400 and before, and so we were going. That is what your crime plan presented to the people of Trinidad and Tobago. This government, under the Prime Minister of Trinidad and Tobago, Ms. Kamala Persad-Bissessar, we are coming differently. In July of 2025, my Prime Minister sent me to Jamaica, where I met and spoke to the National Security Minister, Mr. Horace Chan. He presented a number of initiatives. One of them is zones of special operations, and explained to me in detail how they approached that situation. Educating the forces on the ground, together with the civilian population. That is one way how they managed to achieve their goal. A massive reduction in crime and criminal activity in every area where the zones of special operations was conducted. Every single area. Before the zones of special operations, Jamaica could not even count their murder rate. And now, after 9 years or more, according to the Minister of National Security, they now have some level of control as to crime in Jamaica. If you listen to that, doesn't that speak volumes? If you're coming from a country that is heading in that same direction. And they are not alone, Madam Speaker, Madam Deputy Speaker. We have areas like Baileys, we have Ecuador, Honduras, Peru, all these places, that have the same type of operations. with the same results in terms of the deduction in, the time, in serious crimes all over these countries. So, Madam Deputy Speaker, it was also mentioned by my colleagues that the power of the Prime Minister will determine where these zones of special operations are to be kept. What I didn't hear my colleagues mention is that the Prime Minister makes the determination if the Commissioner of Police and the Chief of Defense Staff agrees. So she are not making it in a vacuum. It must be in writing. They must give her in writing that the areas should be so declared. So when you make this statement that the Prime Minister could get up one morning and say, that zone there, and that zone there, and San Fernando East. That is unthinkable. There are responsibilities placed on everybody in order to achieve their goal. Huh? So, what place are you? I think you're all tired. You all start to behave strange.
Deputy Speaker, 53F, 53F. 53F.
Madam Deputy Speaker, as I stand there, I also want to mention my constituency of Tunapuna. The constituency of Tunapuna has become, in the space of 8 months, a model community. Only last year, I suggest that they could come and get some ideas as to how to govern their constituency. Yeah? Madam Speaker, last year, in fact, 2024, 24 murders. In 2025, 4. Before, Madam Deputy Speaker, before I came to Tunapuna, the constituency, and I was elected, rapid report of crime and extortion. I spoke to the young men in the area. You know now what we are benefiting from in Tunapuna? An increase in investment by the opening of new business all over Tunapuna. So when we're talking criminal and criminality, Madam Deputy Speaker, we often make efforts. We did not sit by and watch like my colleagues on the other side. The Prime Minister told us we have to find solutions. That is how I end up in Jamaica. And that is why I came back. And now the AG have this bill before this Honorable House. Madam Deputy Speaker, the police service, members of the Defense Force, they are ready to take up whatever responsibility is placed on them, because they too have the vision of a better Trinidad and Tobago. All they need is the support that they already have from the government of the day, and hopefully from the other side, and the citizens who understand what is necessary to ensure that their protection, and they can walk safely and go about their normal business in and around Trinidad and Tobago. That is what they want, Madam Deputy Speaker, and that is what we intend to give to them. No small talk on that side, no noise and no pointing of the fingers and all of that will rule us. We'll stay right on track with respect to our intentions, which is to ensure that crime and criminality goes down, and persons who intend to disrupt must feel the full brunt of the law. And that fear of crime must leave the thought of every citizen, knowing that the government of the day will stand with them and not against them. They have already seen it by the various laws that we have put before this Parliament successfully. So going forward, Madam Deputy Speaker, the government of Trinidad and Tobago, the Ministry of Homeland Security, we will stand up with our citizens and defend them with every drop of blood and air left in us to ensure that they are safe and secure. Thank you.
Port of Spain, now at St. Anne's West.
Thank you very much, Madam Deputy Speaker. Madam Deputy Speaker, the seriousness of this piece of legislation is what has the House here at 10 minutes past 1 on Saturday morning. And it is not a single member on this side will shirk his or her responsibility to the citizens to highlight the importance of this historic piece of legislation. Because you see, the first question that arises when debating a piece of legislation such as this and looking at a piece of legislation such as this that affects our fundamental, entrenched constitutional rights, and the question that needs to immediately be answered is why can't the things that they require to be done under the existing law, when we already have very extensive laws on our books, and one only needs to look at the state of emergency that we're coming out of now, that we've been in for 6 months, and the measurement is how many charges have been laid against those persons who have been incarcerated without their constitutional rights and protection, including, for example, a social media blogger who the important phrase of public order was used to detain her under a preventive detention order. And what Trinidad and Tobago needs to understand respectfully is states of emergency require specific constitutional ticking of boxes to get there, including that you must come to Parliament. You must justify to the population through the elected members of Parliament, albeit via a simple majority, why you require a state of emergency. And I want to put the population on notice immediately. This bill that we're looking at this hour in the morning is a bill that empowers the Prime Minister as chairman of the National Security Council, to declare any zone, any geographic zone in Trinidad and Tobago as a special zone under this legislation to achieve and to give powers to the police and the defense force to cordon off areas and to have curfews. That is what this legislation is about. And the difference that this legislation puts in place now is it is directly putting on the executive, and in particular on the highest office of the executive, the Prime Minister, serious liability. Serious liability for which there is no protection. So it was the member for Barataria Sawa who said, put on your robes and go to court. There will be a lot of putting on robes and going to court under this legislation. Because every single time a zone is declared, it is now open to judicial review of the Prime Minister and the National Security Council. Every single time, one can challenge the reasonableness, the rationality of the decision, the illegality of the decision when it is so declared. And what is stark and concerning, despite what we've heard of the speakers on the other side and what they want the population to believe, is there is no parliamentary oversight in the initial declaration of a zone. None. It gives the broadest possible powers to the Prime Minister, where there are reasonable grounds to believe that there is a rampant criminality, such as, so it means not limited to, murder, gang warfare, or high or escalating levels of violence, or B, the threat to the rule of law and public order. And it's that B that gives you the widest possible scope to declare a zone. And when you look at this legislation, it is the implementation of it that has us on this side concerned. And you heard the previous identification from speakers before me of that word hotspots, a word that was avoided in the last 10 years because of the type of stigma that it paints on persons in that area. And I can tell you, as a representative for Port of Spain, North St. Anne's West, how difficult the implementation of this will be when you cordon off zones. Because when you get to the notice provisions, as we all know, and the member for Tunapuna, who knows this very well in his previous role, where he traversed areas in Trinidad, he would know that there are persons who cannot cross from this street to that street in very, very small confined spaces. And that has us particularly concerned. And as we heard previous speakers say, when you cordon off a neighborhood and an area, it is not every member in that area who engages in criminality. In fact, it is a minority. And you know what is the immediate failure of legislation like this, which has been seen in Jamaica, which is a very, very different jurisdiction? The same Dr. Horace Chang that the member for Tunapuna referred to, the Deputy Prime Minister and Minister of National Security in Jamaica. Someone I have constant communication and conversations with. Population of Trinidad and Tobago, Jamaica's success in bringing down an astronomical murder rate over years is not based on the ZOZA Act that came in place in 2017. They have spent billions of dollars in high-tech technology, and I'm sure he told you about that. He may have even taken you to the buildings where they have it. Assets, air assets, fixed-wing aircraft, rotary-wing aircraft, and all sorts of money spent. But also the geography of Jamaica is extremely different. The member for Port of Spain South touched on it. In Jamaica, they had zones which were garrisons. Garrisons that the armed forces, including the defense force, could not go into. That does not exist in Trinidad and Tobago. And I am sure that in his previous role, the member for Tunapuna could have gone in any area in Trinidad and Tobago, along with his colleagues. Legislation that is before us, which has me very concerned, and you see it at clause 14, 1B, that says the Commissioner of Police and the Chief of Defense Staff, and that power can be delegated by them to the rank of an Assistant Commissioner of Police or Lieutenant Colonel in the Defense Force. It is them who may impose a curfew in the zone between such hours as may be specified, requiring persons within the zone to remain within their premises during the hours so specified, unless otherwise authorized in writing by the member of the joint force who is in charge of enforcing the curfew. And this is the notice provision. 2, shall, as soon as reasonably practicable after the curfew is imposed, cause a notice of the imposition of the curfew to be published by any means and displayed in such one or more conspicuous locations in around the zone. There are geographic areas in some of the areas that will be targeted, the neighborhoods, that where are you going to put these notices? Notifying those citizens who live in that area cordoning off of the curfew. Because the person in this street cannot walk across to that street. And to get to this street, you have to pass that street, which is on the outskirts. So if you put it on that street, the notice, and notice what the language is, by any means. What does that mean in today's day and age? How are you going to cordon off this area? How are you going to notify all of us in the neighborhood that you've now put us under a curfew, what hours they are, that the curfew can only be for a specific period of time before you reverse it and you come back again? And you're confining us to our homes. It is not legislation that can be easily imported from a very different jurisdiction. And if you go to the Jamaican experience, it was passed, first of all, in 2017. It faced a lot of issues, which led to Dr. Horace Chang piloting 17 amendments by 2023. Now, looking at it, I will say that the Attorney General and his staff did take into consideration, looking at it, some of what the case law talks about, but it is not sufficient. It hasn't gone far enough. And what they said is they passed this in July 2017, and as a previous speaker, the member for Lavantil West, alluded to, we had looked at it. We had sent it to the then opposition for their comments when Jamaica came out with it. But when we studied it, and the constitutional provisions, and the breaches, and the imposition only on certain zones in Trinidad and Tobago, we felt it was not proportional, and I personally was one of the main advocates against it. And the reason is a simple one. I do not believe that we must suspend persons' constitutional rights when we have sufficient laws on the books. And the challenge, unfortunately, to the police service, who constitutionally are the body that must engage in law enforcement, with the support of the defense force, yes, but even with the joint patrols, the speaker for Tunapuna, the member for Tunapuna spoke about, there are safeguards there. Defense force personnel are trained for war and very, very different to urban and civilian settings. And this piece of legislation now is giving them wholesale the powers of a constable, a police officer. We've heard first-hand experience from one of our members saying what he has witnessed with abuses under states of emergency. And now we are putting in place legislation that allows this to happen without the oversight of Parliament. The case that has been referred to by two previous speakers from the Supreme Court of Jamaica, and I was correcting my friend from Port of Spain South when he sat down, because they have a very different court system to us. So even though it was 3 judges that decided the case, it wasn't the Court of Appeal. There are important utterances in the decision out of this case that held the rolling of states of emergency was unconstitutional, and importantly, a breach of the separation of powers. And the breach of the separation of powers was that the Parliament has to be involved. The first involvement of the Parliament having oversight in this, oversight meaning that you can question, you can debate, and you can propose changes to those who are in charge that they may or they may not take on board, is after 6 months of a zone being in place. That is the first oversight we have. It is only on the extension that you have to have an affirmative resolution of Parliament for an order extending a zone. And there are going to be simultaneous zones all over Trinidad and Tobago. So when you talk about the resources that are required to properly man this, but let me stick to the Jamaican case first, because it's very important, some of what was said in this case. 3 judges looked at it, and this case was brought by the opposition in Jamaica. I want to go to paragraph 69, and this is what the court said. There was no need, they were addressing the unconstitutionality of regulations, and they said there was no need to address it because that had already been determined in a previous case, and this is the important part. The courts held that states of public emergency, by their very nature, involve infringement of citizens' rights. So they're cautioning about that, something we say so loosely here. They went on to say, it is now well established that any action of the state which violates a constitutional right must be tested by the principle of proportionality. The Attorney General touched on this in his piloting. This means that the state's interference with one's constitutional rights must go no further than is necessary to achieve the desired goal. This bill that we have before us today is going to infringe on the rights of many people in society. But unfortunately, it is going to be people in society, in neighborhoods, that may have very little say. And that is why it is incumbent upon us to advocate for them and to ensure that their rights are protected and to ask the question, why? Why is this piece of legislation necessary? Why is it necessary for a Prime Minister to declare any area in Trinidad and Tobago a zone, and a zone where police officers and defense force officers decide of their own volition where to cordon off, where to have curfews, and in those areas suspend our constitutional rights in that they can search us, they can search our property, our vehicles, etc., without warrants. And yes, I heard the member for Barataria Sawa talk about safeguards and provisions. But when you are in that cordoned off area, under curfew, eventually hoping to get to court, it is not going to be a nice situation and scenario. And you know what is the biggest problem and the biggest weakness of this legislation that has shown to happen in Jamaica? And we don't even need to go to Jamaica. Because I'm sure the government, when they speak to the intelligence services, will say, from the time you put heat on one area, all the criminal element does is they migrate to another area. So you lock down this neighborhood, they literally migrate outside of the cordon-off zone, outside of the curfew zone, and they operate elsewhere. Happens all of the time. But the law-abiding citizens living in that area are having their rights, their freedom of movement trampled on, and they may not even know it until they fall foul of the law because they haven't seen the notice. And the Jamaica experience talks about that, and they caution and they moved away from expanding the zones in Jamaica. You know what they said? The government has yet to graduate a single zone. Is that what we want? So in Jamaica, in the 6 zones that they use, they have not yet graduated a single zone out of being out a cordoned-off area under curfew. That is going to be the experience here in Trinidad and Tobago. That is going to be the experience with our citizens in Port of Spain, North St. Anne's West, in Diego Martin, Northeast, in St. Anne's East, in Port of Spain South, in Laventille West, Laventille East, Mova. The areas that we know they're quick to say are crime hotspots, never graduate out of a zone. It just keeps rolling and rolling. The government stood here in this exact house and chamber and told the country that the state of emergency is not their crime plan. The evidence and history has proven it to be untrue. It is their crime plan. And today we are here to pass legislation that is taking away even the protection that the Constitution provides in a state of emergency. And we're giving persons without oversight the ability and the power to just lock down areas in Trinidad and Tobago. My colleague from Diego Martin Northeast uses a phrase, and I want to put it on the Hansard here today, and I hope it doesn't come to pass. But listening to the experience of others, it has. Are we becoming a police state? In Jamaica, they talk about the difficulties. They say that the security forces squeeze the spaces with checkpoints, 24/7 patrols, constant surveillance, and this creates 3 specific types of displacement. Spatial displacement, geography, gang members simply move their operations to the street immediately outside the zone boundary. Residents often report that while their specific block is safe, the adjoining community has seen a spike in shootings. Temporary displacement. Criminals change when they commit crimes. If patrols are heavy during the day, activity shift to the very early morning or during shift changes of the security forces. Tactical displacement methods. Gangs switch from high-profile activities like open street warfare to quiet crimes that don't trigger a massive military response, such as cybercrime, lottery scamming, extorting businesses via digital messaging rather than in-person intimidation. The criminals migrated to rural parishes. The border effect in Westmoreland and Savannah, Lamar, Zosa significantly reduced murders within the town, but the surrounding communities of Grange Hill and Morgan's Bridge experienced retaliatory violence as gangs pushed outward. They're going to have economic fallout as well, potentially, in these neighborhoods and these zones. This is what was felt. While big businesses benefit from stability, the informal or night economy often suffers due to security restrictions. The curfew crunch, they call it. Loss of revenue for small shops, pan chicken vendors, bar owners, For us, that is the parlors, the small stores, small businesses in some of these neighborhoods will suffer. Concerns with the warrantless searches, etc. And of course, the legislation found that there was a breach of separation of powers. Turning back to the Jamaican experience and the Supreme Court, while we accept that democratic rights may be limited or restricted in order to ensure public safety and maintain public order, the restrictions should be temporary so that affected rights are impaired at least as is reasonably possible. It is unquestionable that the constitutional rights of members of certain marginalized communities will be disproportionately affected as there is increased policing of such communities. That is exactly what will happen here. Our marginalized communities will be the ones affected. They are the ones who are going to suffer once again. The Attorney General in piloting said that during the state of emergency, they have identified the areas, they've identified the members, etc. So why can't we, under the current legislation, and in particular the anti-gang legislation, target those persons, those individuals now, hit them hard and put them where they need to be, off of the streets and out of the communities? Why are we now going to declare zones and lock down law-abiding citizens of Trinidad and Tobago? They go on to say, there is likely to be an erosion of public trust in government. There will be negative implications for social and economic stability. The executives or legislators' assertion that they're solving something so important that fundamental rights and freedoms can be trespassed upon is not sufficient. This is the ultimate logic of constitutional supremacy. A naked assertion by the legislature and or the executive without tangible evidence is not likely to be sufficient in many cases. We can learn from their experience and the caution and not make the same mistakes. And that is what we're supposed to be doing here this evening, Madam Deputy Speaker. And to get, this morning, early this morning. To get now to the specific bill in front of us. The bill is named, the act may be cited as a law reform, zones of special operations. And then we see the insertion and the spin, the PR spin, special security and community development measures. That is not what it is. The committee that they've referred to as the special committee, as was pointed out to me by my friend from Diego Martin Central, the Social Transformation Committee, where it is from A to X or whatever. All it says is the committee shall be comprised of at least 10 persons selected. So it doesn't mean that the MP will be selected. It's 10 persons out of that. And as we all know, any large committee is not going to be efficient and effective. And what is the committee going to do? They have no say over the Quad North zone. They have no say over the curfew. They have no say over the breach of rights taking place within these zones. And looking at the legislation, and you get to the objects of the Act at Clause 5. It starts by saying to empower the Prime Minister and Council to declare an area as a zone. Why are we putting the executive in that position? Why are we putting the Prime Minister in a position that now she will have to be swearing affidavits for judicial review to justify illegal zones that they've put in place? And you're not going to be able to claim national security privilege here, because a court is going to have to judge whether the decision you have taken is a legal decision, whether it's a rational decision, whether it's a reasonable decision. It goes on to talk about upholding the rule of law while protecting the fundamental rights and freedoms of persons who reside, raise families, work, or conduct lawful business in a zone. So you're accepting that the rights and freedoms of persons who reside, raise families, work, or conduct lawful business in a zone, their rights are the ones that are going to be affected disproportionately.
Member, would you like your additional 15 minutes?
Yes, please, Madam Deputy Speaker. And then you go on to say, conduct law enforcement activities to rid a zone of all illegal activities, firearms, weapons, ammunition, and other contraband. When I read that, I thought to myself, isn't that what you're already supposed to be doing? So why you need this piece of legislation to do that? That is your job. And the caution from the member for Laventille West is a real caution, because it is the executive that can declare a zone and then send in the police and the defense force to lock it down without coming to Parliament. Suppose now that is abused and misused. Suppose now that is used in political settings strategically for local election and other things. It is very easy, especially in a marginal constituency, to identify which areas are the supporters of your opposition party. And then to say, well, that is where the criminality takes place, as has been said. As has been said. We sit here, even today, yesterday, and listen to the member for St. Augustine making these wild aspersions about criminality and programs. Not a single charge. Not a single charge. And is that what is going to happen? Is this legislation being put in place to prosecute, persecute, and to abuse the rights of citizens? To marginalize our citizens more? To divide our society more? Because that is the type of legislation I am concerned that we continue to see. The same thing with the Stand Your Ground legislation. We warned about it. You go on. So it is the Prime Minister declaring in the first instance an order under subsection 1, this is clause 6 now, 2, shall specify the geographical limits of the zone and shall not exceed 180 days. 6 months. 6 months. You're in curfew. You're locked down. You can't come out your neighborhood. Right? And you just come, make a statement, say this is what I've done. Right? It is only, parliamentary oversight only comes in at 7.3 when an order is made to extend. Right? After 6 months, correct. And all they're required to do, and listen, all the Prime Minister is required to do, or the Minister assigned with responsibility for national security, is make a statement to Parliament within 14 days of the date of the order. You hear the types of statements? Right now, the standing orders say the Speaker must approve the statement after the Minister gives the statement on the open floor of Parliament. We're supposed to get a copy of the statement. We have not gotten a single copy in 9 months. And worse yet, what applied in 10 years of practice in this Parliament that I was a member of, where you could not drift outside of a single word in your written statement, we see the injustice taking place here of people making it up, just stopping in the middle of something because something take off in their head and they just utter it. And we still have not gotten a copy. I'm sure the email wouldn't say what the Prime Minister was saying today. I could guarantee you that. Right? This is not boy. Save your boy for down the road. Right? The next thing is, of course, the order declaring a zone may be revoked at any time by the Prime Minister on his or her on his motion on the recommendation of the Commissioner or the Chief of Defence Staff. And then they talk about the designation of a joint command. A joint command has to be someone from the Defence Force as well as the police service. We all know it. The member for Tunapuna will know it. I know it as a former Minister of National Security. The difficulties you have even in IATF operations. But worse yet, when you're trying to put together joint patrols, that the police will say, well, the Defence Force are contacting them, or the Defence Force will say the police not contacting them. When they go on patrols, it is very different methodologies of operation. Defence Force officers are on patrol. Police have a shift system. So when there's a change of shift with the police, or the police getting overtime, it becomes a problem with the Defence Force officers. All of these are the realities. And then, if something goes wrong on that joint patrol, right, because they talked about this written accountability and reporting system, listen to what it says, the legislation. Clause 10.5, a person who fails to comply with Section 4, and you know what subsection 4 is? The Joint Command and every member of the Joint Force shall comply with the written accountability and reporting system referred to in subsection 3. Right? It's a written accountability and reporting system as specified by the National Security Council. If you breach that, this is what it says, you're liable to disciplinary action. What does disciplinary action mean in legislation like this? Even with the police service, what does it mean? You just put disciplinary action. Sloppy legislation. And by whom and in what order? Right? During a period that the zone is declared, the Joint Command shall submit a written report to the National Security Council every 30 days. So is that going to be discoverable? Is that going to be discoverable? What is the protection for the population? Because I'm sure if you request that under FOIA, the first thing they will do is issue a national security certificate saying you can't see it. So where is the protection? And as I say, this is placing direct liability on the Prime Minister. And then it talks about the powers of the joint force in a zone, establishing the cordon off around the areas, publishing a notice and putting it in a conspicuous location. As I say, that could be missed by 90%, if not more, of those affected and their rights affected. They say the notice, they have to prescribe these forms, they have to specify the boundaries, the hours of the curfew. Of course, the duration of the cordon and the curfew at clause 15, a cordon off area shall endure for a period not exceeding 24 hours. What that means is you can lock down an area for 24 hours. Nobody in, nobody out. On 24-hour periods. It doesn't mean you can't do it continuously. If you take a break, so from 12 midnight to 12 midnight the next day, and you start at 1 a.m. the following day. How are the children going to go to school? How are law-abiding citizens supposed to go to work? Businesses supposed to operate? The legislation attempts, and this is, I assume, for expected litigation, meaning the constitutional challenged it, to put in place certain safeguards. But they're undefined safeguards. These are safeguards that don't apply when you're in the zone in the cordon off area. It's if you're arrested, if you have to be brought before a magistrate 48 hours after arrest, etc. Of course, the Social Transformation Committee, complete waste of time. Because a committee of that size and nature for every zone could never be effective and efficient. This cannot be this country's crime plan. The trampling and continued trampling on our constitutional rights and marginalizing the most vulnerable societies in Trinidad and Tobago could never be democratic. It could never be upheld as being proportional. So, Madam Deputy Speaker, we on this side express serious concern, and it is not being obstructionist. It is literally genuine concern for our constituents who we know will be affected. And knowing the terrain and the ground in which we operate and they operate, how difficult it will be to implement this without serious issues and breaching of persons' rights. So, Madam Deputy Speaker, at this hour, early hour in the morning, I express my reservation. I ask the government to press pause, maybe send it to a joint select committee. Let us sit and work and see what can really be done. But we will not support this legislation in its current form. I thank you.
Member for Toko Sandagrandi.
Madam Deputy Speaker, let me start, before I address my friend from Port of Spain North, St. Anne's West, let me start by addressing a statement which was perhaps a Freudian slip on the part of the member for Laventille West. Because the member for Laventille West, toward the end of his contribution, said that the opposition is a watchdog against the rule of law. And that speaks volumes, because what I have heard here today suggests that this government does not want any government to succeed on crime. Sorry, sorry. Right. Well, it's 10 minutes to 2. It's 10 minutes to 2, and I was watching the former Prime Minister, and that's why I said this government. So maybe I should have said small pin. But it's quite clear, and let me tell you why. Let me tell you why the PNM doesn't want any government to succeed on crime. Because they hold the records. Let me tell you what the records are. For the last 10 years, the rule of law was out the window. The criminals were in charge. The last 10 years was a reign of terror. And their record on crime, let me start, they have, if crime were an Olympic race, they have the first 8 lanes. The highest murder rate last year, 624. 605. 577 in 2023. 550 in 2008. 539 in 2019. 518 in 2018. 509 in 2009. 497 in 2017. That's their record. This year, we cut that by 42%. So, when it comes to murder, they filled all of the top 8 positions. Their record again, they were the first to cross 300 murders a year. They were the first to cross 400 murders a year. They were the first to cross 500 murders a year, and the first to cross 600 murders a year.
down and what it was in the past. Every single one.
Yes, we have been debating on this for a while, member. Let's move on, please.
I'll move on. I'll move on because I know it's hurting them. That's the reason I'll move on, because it's hurting them. So they want us to fail. But you see, the thing is, there's something called a rule of law, and that is specifically mentioned in the bill. That is specifically mentioned because, according to 5B, as one of the objects of the Act, it is to uphold the rule of law whilst protecting the fundamental rights and freedoms of persons who raise families, work or conduct lawful business in the zone. So all of this scare tactics, which the member for the former Prime Minister, one-day Prime Minister, Kobo Sweat, Smallpin,
Madam Speaker, Madam Deputy
yes.
Speaker.
Yes. Yes, so
48-4 and 48-5, Madam Speaker.
Member for Toko San Grande, please withdraw that statement.
I'll withdraw it and move on. Yes. So the short point is this. They have serious challenges with crime. They have serious challenges with anybody who is trying to ensure, as a government should do, that the law-abiding citizens enjoy the constitutionally enshrined rights as guaranteed by 4 and 5. Because right now, for the last 10 years, the citizens have not been enjoying their rights. So all of the scare tactics that the former speaker just alluded to, every time he spoke, he said in essence that the law-abiding persons would be affected. The objects of the bill make it very clear. It targets certain zones where there's rampant criminality, where there's high and escalating crime, where there's serious incidents of murder. And the way this is going to be carried out, there are safeguards in the bill so that when my learned friend from Port of Spain, North St. Anne's West said anybody could be targeted, that's not true. Because when you read the bill, there are safeguards. If you are in this zone, you cannot simply the police and the army simply cannot target you. There must be a basis, and the basis in law, the constitutional due process guarantee, is that there must be reasonable suspicion. So if you are law-abiding and in the zone, you are protected. And I'll go through in a little bit all of the protections as set out in the bill. So let me go now to the freedoms, because what the former speaker said is that certain freedoms would be affected. You wouldn't have freedom of movement and so on. The previous speaker. And you would have to be locked down in your house. You'll have a curfew imposed on you for certain hours. Madam Deputy Speaker, for the last 10 years, persons in those zones, those hotspots, have self-imposed curfews because of the rampant criminality. Persons in those zones do not have freedom of movement as constitutionally guaranteed. I don't know if my friend knows from Laventille West. I'm sure he must have heard, order, don't cross the border. That's right in the Beatum. Right in his constituency, if you live in one street, you can't go in the next. That's freedom of movement. And they have a problem when it is the government trying to uphold the rule of law, and it is the government limiting the movement of the bandits. They have a problem with that. But they don't have a problem with the law-abiding
who cannot move from one place to another. I grew up, Madam Deputy Speaker, in a place called Serrano Road, Belmont. And for a short period, I also lived in Bella Road. And what connects Bella Road to Serrano Road, Belmont is a steps. And what also connects Serrano Road to Bella Road is Macshine Lane. So it's a road connecting. But persons from Bella Road can't go Serrano Road, and persons from Serrano Road can't go Bella Road, and they run parallel to each other. That's not freedom of movement. That already exists based on their 10 years. In fact, that existed under them for such a long time that it became normal. That when you jump in a taxi, when you take a taxi by Queen Street corner, Queen and Henry, or Queen and Charlotte, you have to ask, and you say, look, I go in Serrano Road, and the driver say, well, I had a pass in Bella Road to drop somebody. You can't take that taxi. I'm sure he knows, my friend from Laventille West, of several instances. You would have read cases, seen it on the newspaper, that a taxi just passing to drop somebody in another zone, that the passenger, who happened to be in a different zone, just 2 streets away, was shot and killed because the taxi was in the wrong zone. So these people had their freedom of movement limited because the PNM failed to do nothing with respect of crime. In respect of crime, they failed miserably, but they have the gall to come here and say, don't do this, don't do that, do the other, when they did absolutely nothing. That's why they have the top 8 places. But it's 2 o'clock in the morning now. I don't wish to be long, but I want to deal with something, the so-called elephant in the room, that I was hoping it would not have come up in this debate. I saw it rampant on social media and rampant among bloggers who support the People's National Movement. And when you look at the comments of the people who every day comment on these bloggers, they view this as targeting a certain ethnic group. They've brought race into this, and that is so unfortunate. Let me tell you why. And they made reference several times to say the Prime Minister could declare a zone and the Prime Minister could declare a zone. The Prime Minister, when she declares a zone, is declaring that zone whilst in her capacity as the presiding officer of the National Security Council. So it's not the Prime Minister by herself declaring a zone. So let's get the race out of the way. Because let me tell you another safeguard and why there's no race in this. When the Prime Minister declares a zone, it is based, first of all, on data. It is based on information. There must be a basis. It can't be the Prime Minister waking up one morning and say, let me declare a zone. And when the Prime Minister in the National Security Council, presiding in the National Security Council, declares a zone, then the other persons in the National Security Council, and let me go through all of them because I had to write it down because it kept going on and on and on. So let me put this race bogey to rest. The National Security Council is made up of the Attorney General, a black man. The National Security Council, a proud black man from Bella Road, Belmont. The National Security Council is also made up of my friend Zander, Roger Alexander, member for Tunapuna. A proud black man. My friend Sean Sobers is a member of the National Security Council. A proud black man. Right. And then I'm also on the National Security Council. I'm black. In features and fixtures. The Commissioner of Police.
the Commissioner of Police who has to attend, unlike San Fernando, the Commissioner of Police who has to attend the National Security Council and make representations is a black man. The Chief of Defense Staff who has to attend is also a black man. A little fairer, so that in Trinidad they call him a red man, because he's a black man. The commanding officer of the Trinidad and Tobago Regiment is a black man. The commanding officer of the Air Guard is a black woman. The commanding officer of the Coast Guard is a black man. So, what are you saying, that all of these black men and women would get together and just say, let's target black people? You see, they are using this race thing, and they started it with the Stand Your Ground legislation, and they tried to bring it here. And we had to tell them, and they're doing it again, we had to tell them that Stand Your Ground is in another country where black people are a minority, where the police are in the white majority, and that is not going to happen here. So the majority of the TTPS, majority of the TTDF happen to be black people. So are you saying that they are racist too, against their own? We need to put that to rest, because that is the scare tactics they rely on. Yeah, because we are all in this country black and brown. And in any event, we are all a check and balance on each other. And in any event, as the previous speaker said, decisions of the National Security Council are subject to the scrutiny of the courts by way of judicial review. Is scrutiny by the courts not a safeguard? It is. It has to be. The declaration of the zones, if you read, if they would bother to read it, has to be on the basis of intelligence. It has to be on the basis of things gathered that suggest there's a high crime rate, there's rampant criminality, the murder has escalated, and things of that nature. It's not whimsical. It is data-driven. So what I would ask my learned friends when they go out to I-95 and these other stations next week to parrot their narrative, in the hope of, one said they're going to try to convince the independent Senate, the presidential senators, I would ask them to leave the race bogey out of it, because that is just scaring people. And our mandate is to remove the fear. Because in these communities, right in Toko Sandigrandi, just recently, let me give you an example. Right in Toko Sandigrandi on the Toko Main Road, people have to pay tax. They have to pay tax. Imagine they have to pay $3,000 a month in tax. Not to the government, you know, to the gangs, if they want to continue running the shop. And this group of people, a family of 15, they couldn't pay the tax. The tax is $3,000 a month. The little parlor didn't make the $3,000. And you know what? They burned down the people's house. Does the rule of law exist up there? And that's not the only place. There are many other places like that, where the criminals basically run rampant, where the rule of law does not exist. Just today, we got information about a group of criminals who decided they are going to take over somebody's house in Toko Sandigrandi and take over their business. And that had to be sorted out. That is what we are dealing with. And when we come to sort it out, if we have to lock down a defined area, we are not locking it down for 180 days. It's a zone. And in that zone, a cordon will be established for 24 hours. Is that really so intrusive? And contrary to what the previous speaker said, it's not that you can't leave during the 24 hours, or you can't come in, you can. Of course, you'll be subject, once there's reasonable suspicion that you should be stopped and searched or detained, then of course the law has to do what the law has to do. This thing about a curfew, right in Toko Sandigandi, there are several communities, Babwande, Koka, the list could go on, where there's no electricity, dot road, no water, and the residents have to get in there by a certain hour because the bandits have imposed a curfew. So what are we to do as a government? A government is responsible for upholding the rule of law. And if the government cannot uphold the rule of law, then it is the democratic right of the electorate to get rid of them. And that's why the PNM government is there. And they came here, and if you notice, Madam Deputy Speaker, everything they've said is scare tactics. They predict this would happen, they would predict that would happen. Let me give you two examples of predictions. They predicted that when the war starts in Venezuela, that we will be bombed and so on. Did that happen? Somebody got bombed, and then when he went to the States and the indictment was unsealed, some people got named, but the media don't want to interview them at all, and they stopped giving press conferences. But let me go next to another prediction. They said, don't put police in school. Don't put police in the schools. The police go want to have sex with the people children. They track the young girl and them. The police and them is part of gang too. They say all kind of thing about what will happen when the police reach in the school. Where does happen now? Any of that happen? No. And now, listen, we had a problem with school violence. What are we to do as a government? Listen to them who fail? Never. We took the initiative. It was one of the initiatives in our manifesto, our 60-point crime plan. We took the initiative, we put the police in the schools, although there were some teething problems, as is expected. Now, do you see mass school beatings? How often do you see that? I used to see that every day. Every day I had to use that. My son go and sit common entrance or whatever it's called it now, and I had to show him, look at this video, and say, there's Mokorapu. Or there's Tranquil. This is where you want to go? Get off the TV and go and study. But you know what? I can't even use the schools as an example again. You know why? Because of the initiative that we've put in, you can't see no school fight again. Oh God, don't tell me that. Yes. I don't want to stay...
Act like you never tell somebody that.
Yeah, there's act like saint. I want to address some other issues that were raised. I came here with a totally prepared point form speech. But when I listened to them, I got an entirely new speech. I heard so much nonsense on that side. I could not believe it. Imagine, and let me address something one time. The previous speaker said, the efficacy of a state of emergency is measured by the arrest at the end of the SOE or the arrest during the SOC or something like that. The charges. Thank you.
Listening voice.
Yes. And one has to understand the dynamics of an SOE, particularly one like this one and the nature of the threats that were involved and the nature of the intelligence gathered. And one must understand the efficacy of it, because what we were faced with, a few gang leaders, some out of prison, the rest of them in prison, communicating freely as if they were all outside, calling hit upon hit upon hit, killing people at will, from the inside, some from the outside. And they based on the intelligence, intended to do something on a mass scale. So the state of emergency was meant to address those issues, and what was issued would be, or would have been, the preventative detention orders. And those orders existed to prevent certain occurrences from taking place, inclusive of preventing them from communicating further hits to other people outside. You know, the minute we take them out of the jails, which they had 10 years to secure, which they had 10 years to prevent TVs from coming in, they had 10 years to prevent Xbox and all these things from coming in, and phones, nada, zero, zilch, waste of time. That's what they did. They wasted 10 years. And during this 10 years, hit upon hit upon hit. So you know what we did? The Attorney General had to be inventive. He turned Tetron into a prison and Stobles into a prison. And now all of a sudden, no hits. No hits. The murder rate's gone down. Why you all couldn't think of that? So the achievement of the SOE is that not only that we prevented murders on a mass scale, but by getting these preventative detention orders, we save lives by half, by almost half, 42%. And let me dispel something, because they are going to say the SOE was not effective. It was, and they are going to say why people were not charged. Let me tell you why. If the evidence we are depending on to charge them would be intercepts of hearing them talking about who they're going to kill and when to kill, where to kill, and all that. And we have preventative detention orders that now prevent them from killing, then the evidence dries up. Now we are deprived of the evidence, but what we've done, the balancing act is, depriving us of the evidence enabled us to save lives. So let me go through, because I promised I would go through some of the safeguards in the bill. Now, objects of the Act. The objects are set out, I don't need to regurgitate them. But right in Section 5, you see several times that the arrest without warrant has to be on the basis of reasonable suspicion. Reasonable suspicion is not only a common law, but a constitutional safeguard to prevent unlawful arrest or arbitrary arrest. Now, what they did not tell you is that the present law, if you want to say that is a constitutional breach, the present law in Trinidad and Tobago allows for arrest without warrant already. There are certain situations in which the police can arrest you without a warrant. But it is quite clear here that there must be reasonable suspicion that you have committed an offense, that you are in the process of committing an offense, or that you are about to commit an offense. And only in those situations, the police would arrest you. So this scare tactic the previous speaker went into about, you know, you're going to work and they're going to arrest you. Our old auntie going to clean the house in Westmoreland, she leave from Gandhi, and she come out of the zone, they're going to arrest you. They wouldn't arrest you unless they have reasonable suspicion that you, auntie, hiding